NACM's effort to raise nearly $2 million to support investigative efforts in 1925 furnished similar opportunities to heighten awareness of anti-fraud messages. By keeping initial fraud monitoring and investigations within their own institutions, anti-fraud organizations maintained flexibility in law enforcement, and likely far more than would have been feasible through a strategy of lobbying to place more public detectives and prosecutors on the fraud beat. In cases where an established firm embarked on a marketing campaign that flirted with misrepresentation, the BBBs initially approached it quietly, endeavoring to impress the advertiser with the desirability and the advisability of raising the standard of his own copy. Most of the time, managers accepted proposed adjustments, even agreeing to retract advertising. BBB Publications team with overviews of these settlements achieved through friendly persuasion. The 1928 annual report of the Kansas City Bureau, for instance, reported that it had secured changes in 670 inaccurate advertisements, ranging from instances of underwear overvalued and furniture cut deceptive to deceptive comparative prices and real estate exaggerations. If advertisers rebuffed efforts at moral suasion, Bureau officials often progressed to public disclosure, using their publications, connections, and public relations to shine a spotlight on a given business's problematic tactics. Cases went to state or federal prosecutors only when BBB administrators confronted what they viewed as recalcitrance, which occurred only once or twice for every 100 legitimate complaints. One needs to keep the scale of the business establishment's war on fraud in perspective. After 2 decades of rapid expansion, the persons collectively employed by the BBB network likely totaled fewer than 1,000, a workforce roughly similar in size to that employed by a single large-scale advertising firm such as N.W. Ayer and Company, and less than 3% of the employees at a leading national retailer such as Sears Roebuck and Company. At no point did the bureaucratic resources of NACM and the BBBs approach those of the largest corporate enterprises. Indeed, the corps of store detectives working for the nation's large urban department stores probably exceeded the full complement of BBB employees and NACM's prosecution and investigation department combined, while the force of private railroad police, totaling 10,000 in 1930, certainly did so. Nonetheless, the number of fraud monitors and educators compared favorably with the administrative infrastructure at the Federal Trade Commission. In 1930, the FTC employed only 450 persons and possessed an annual budget of approximately $1.5 million, with which it had to carry out its legal mandates to enforce not only federal prohibitions against deceptive advertising, but also violations of the antitrust laws. If one adds the considerable in-kind contributions of advertising space by publications and radio stations to the BBBs, the educational and disciplinary footprint of the anti-fraud organizations greatly outstripped that of the pre-New Deal Federal Trade Commission. The scope of capitalist collectivism. Suffusing all of these various activities, lobbying to extend statutory prohibitions of deceptive commercial communications, campaigns to inoculate the public against scams and schemes and convince businessmen to resist the inclination to adopt or accommodate such deceptions, articulation and dissemination of commercial standards and best practices, construction of private professional anti-fraud bureaucracies, was an extraordinary degree of confidence. Leaders of the maturing anti-fraud establishment were not bashful about asserting their expertise in matters concerning fraud, which they expressed most commonly in the idiom of public health. NACM officials characterized their endeavors as sanitary work or organized credit hygiene, and insisted that communities should be vaccinated against commercial crime just as they are against smallpox. Credit Monthly represented the association's spokespersons as credit physicians, who safeguarded the country's businesses from the poisonous depredations of the credit crook. BBB managers received an analogous message from NYSE President E.H.H. Simmons in September 1927. The bureaus, Simmons declared, had obligations in the economic and business field closely resembling those which medical men have in the field of public health and sanitation. Just as physicians had educated the public in matters of health, rendering it immune to the scourges of disease which formerly worked such havoc with human life, so anti-fraud leaders had the fundamental tasks of educating the American investor into a similar condition of immunity from the swindling profession and clearing up the conditions where these parasites on our national business establishments lurk and breed. Like public health officials who combated the environmental conditions that bred tuberculosis, yellow fever, and malaria, anti-fraud professionals portrayed their labors as rooted in scientific understanding and aimed at protecting the public from dangerous scourges. Depictions such as a 1926 rendition of Dr. NACM expanded upon the rhetoric that had animated regulation of adulterated fertilizers and foodstuffs. Now, all anti-fraud work took on the sheen of science. Accompanying such self-presentations were insistent claims that anti-fraud organizations represented the United States writ large and looked out for the public welfare without fear or favor. NACM publications characterized its members as crusaders for the economic commonweal, on occasion depicting them in the garb of medieval crusaders, upholding the ancient virtues of vigilantia and fidelitas. BBB officials proclaimed that they had no axe to grind and no interest to protect, that their methods have been scientific, that perhaps most strikingly they were literally of, by, and for the public. The Oklahoma City Bureau declared in 1930 that the organization was unprejudiced, unbiased, and adhering strictly to its own work and purposes, and that it never allowed its facilities or influence to be used to further selfish or personal rights. One president of the national BBB similarly pronounced that anti-fraud work sounded the undoubted note of patriotism, which adds to the general prosperity of our country. Indeed, anti-fraud professionals often asserted de facto jurisdiction over fraudulent behavior, a move that the media tended to ratify, as through a 1926 New Orleans Times-Picayune cartoon depicting NACM as a motorcycle cop hot on the heels of a band of commercial swindlers. The cartoonist added a USA nameplate and titled his drawing The National Policeman, clothing this private association of business executives with the legitimacy of the state. Throughout the 1920s, America's dominant Republican Party blessed the quasi-public character of anti-fraud institutions, with the country's highest officials giving them full-throated endorsements. President Calvin Coolidge observed that, wherever deception, falsehood, and fraud creep in, they undermine the whole structure, a calamity to our commercial life that could only be prevented by the businessmen themselves. His successor, Herbert Hoover, praised the BBB network for greatly contributing to the economic stability and progress of the country. Treasury Secretary Andrew Mellon, Attorney General John Sargent, Secretary of the Post Office Harry New, and many lower-level political appointees expressed similar sentiments. The standing of anti-fraud professionals with Republican leaders translated into influence over key legal appointments. The New York City and national BBBs, the Investment Bankers of America, and the NYSE all had significant say over prosecutorial positions in their bailiwicks, such as the United States Attorney for New York's Southern Federal District or the New York State Assistant Attorney General responsible for enforcement of securities fraud law. Government detectives and prosecutors who had experience with fraud cases also frequently accepted employment at private anti-fraud agencies. With such strong connections, it should come as no surprise that the era's law enforcement officials leaned heavily on these organizations, especially when embarking on high-profile fraud crackdowns, such as the Post Office's campaigns against fraudulent Texas oil companies and Florida real estate scams during the 1920s. The anti-fraud crusade wished to remake commercial culture across the United States. As such, it constituted something of a social movement within the confines of American business, though one emanating from the ranks of the elite rather than the social or cultural margins. The campaign's leaders and troops embraced the challenge of convincing corporate bigwigs, small-scale entrepreneurs, middle managers, securities promoters, and advertising professionals that they should eschew the quick buck and rather act with regard to long-term reputation, the stability of their industries, and the health of the broader economy. As the members of the anti-fraud vanguard fine-tuned this pitch, they put forward numerous sober arguments, but they also conjured evangelical visions of manly commercial fellowship and self-consciously infused their creed into the business establishment's evolving social rituals. Toward these ends, NACM and the BBBs annually convened national conventions, like the 1929 BBB meeting in San Diego, where members of the anti-fraud fraternity deliberated over new tactics, expanded networks of information sharing, and mutually testified to the righteousness of their crusader spirit and nationwide effort. They made periodic fundraising campaigns into collective expressions of esprit de corps, through which participants could offer tangible evidence of commitment. Even more frequently, local chapters held lunches and dinners or dispatched speakers to the monthly meetings of Rotary clubs. At such gatherings, business leaders shared a good meal at a local hotel, and then, after cigars had been lighted, listened to a talk that harangued the fraudster and those who abetted his machinations, while extolling the business community's exertions to rid itself of confidence-killing deception. Tellingly, anti-fraud activists did not shy away from the language of communitarian action, characterizing their initiatives as a movement for truth in advertising. The commercial establishment's fight against fraud depended as much on personal contexts of fellowship as it did on sophisticated lobbying campaigns, impressive public relations machinery, and ever more extensive bureaucratic techniques of commercial surveillance. Movement-building events could attain an impressive scale, reflecting the seriousness and financial commitment that undergirded the early 20th century anti-fraud war. A gala annual dinner thrown by the St. Louis BBB in the spring of 1941 exemplified pivotal dimensions of communal occasions. On the main floor, BBB leaders and invited guests sat at head tables on the side, while representatives from BBB member firms and local dignitaries shared tables in the center. On the mezzanine level, scores of students from more than 50 high schools had the chance to listen to the speechifying and to begin the process of identifying it with the battle against cheats and swindlers. Large American flags festooned the mezzanine railing, reminding participants that the anti-fraud fight was America's fight. Over 1,000 St. Louisans purchased tickets to this gathering, a testament to the sincerity and determination on the part of legitimate business to rid the community of improper practices. The early 20th century drive against commercial fraud tracks patterns evident in most social movements. Whether arising out of evangelical rejection of prevailing institutions and practices, working people's demands for greater economic security and political power, disfavored social groups' insistence upon equal citizenship rights, or the concerns of economic elites about pervasive commercial humbuggery, such collective undertakings have faced similar challenges. The historical enemy might be slavery, alcohol consumption, unequal bargaining power, discrimination on the basis of race, gender, sexual orientation, or business fraud. In all these contexts, movement leaders had to fashion a new sense of identity around issues of shared concern and build deep commitment to the cause, often by creating new kinds of emotional experience. Invariably, modern social movements have sought to subordinate individual concerns and interests to broader communitarian norms. Such endeavors have always required the construction of engrossing narratives that pull individuals into the movement, connect personal identities to the cause, and convince participants that their actions will make a difference. To purge American marketplaces of chicanery, officials such as J. Harry Trigo and H. J. Kenner tried to reframe the emotional stakes of day-to-day marketing practices. Through their organization's publications, public narratives, and social events, these standard-bearers sought, in the language of behavioral economics, to leaven market norms with social norms, to inject communal values into business culture. In doing so, anti-fraud leaders contributed to a broader effort by interwar business interests to impose order on the dizzying transformations within America's industrial economy, chiefly by confining the channels of permissible competition. In many respects, the work of the NACM and the BBBs reflected the antipathy of corporate America to administrative agencies that could bog down enterprises with endless rules and bureaucratic processes. The new business-funded anti-fraud organizations, like so many of their corporate patrons, rejected most proposals to create large and intrusive government bureaucracies as a strategy of addressing the social ills, economic instability, or other externalities generated by modern industrial economies. In the securities arena, for example, BBB leaders vigorously criticized any suggestion that the state ought to protect investors by licensing stockbrokers, or even worse, by vetting public securities offerings to ensure their legitimacy. Indeed, the founding of the New York City BBB formed a central element of Wall Street's efforts to deflect state legislative proposals for blue sky legislation that would create such administrative authority. As the AACW argued forthrightly in 1919, if an industry does not clean house for itself, the law will do it, and the law often operates in such a manner as to injure the legitimate while seeking to stop the faker. Visceral antagonism to the heavy-handed administrative state was accompanied by a hearty embrace of the post-World War I Republican call for associationalism. NACM's efforts constituted a leading example of the Republican preference for trade groups that responded to economic challenges through mutualistic standard setting, in this case with regard to evaluating credit requests and exchanging credit intelligence. Although the BBBs had a much wider purview than most trade groups, they facilitated associationalism in a host of contexts. Most importantly, the Bureau Network defined and continually refined principles for truth in advertising, which they disseminated among newspapers, magazines, radio stations, advertising agencies, and frequent advertisers, such as urban department stores. In the latter half of the decade, the National BBB also joined with the Federal Trade Commission to convene conferences among leading retailers of furs, furniture, and numerous other lines of goods to hammer out transparent standards for the use of trade names that would avoid confusion among manufacturers, dealers, and the buying public. Again and again, the anti-fraud establishment characterized their initiatives as forms of home rule by American business, paralleling the sentiments that drove associationalism in so many other corners of the post-World War I American economy. As H. J. Kenner emphasized in a 1926 speech, the organized business community had pledged to keep its own house in order. Through the BBB's educational efforts, impartial monitoring of the marketplace, and disinterested cooperation with the authorities and law enforcement, Kenner argued, business will impress government and the public alike with its determination to police its own domain. Respect for business and for law will then grow apace. This preference for commercial and financial self-government greatly influenced the BBB's approach to fraud policing, which stressed, whenever possible, flexible adjustments or reliance on the pressure of public disclosure, rather than a turn to the all-too-cumbersome disciplinary power of the state. In fashioning a discourse of home rule, the Anti-Swindling Brigade mirrored the contemporaneous language of Southern segregationists. Like their political counterparts in the Southern Democratic Party, who demanded unchallenged jurisdiction over race relations in their states, business elites asserted their right to deal with issues related to fraud on their terms, through their own administrative and investigative authority. The dilemmas posed by duplicitous commercial speech, however, convinced a broad cross-section of American business leaders of the need for an additional layer of governmental oversight. The specter of diminished public confidence led corporate leaders, especially within the sectors of large-scale retailing, finance, and the media, to turn to the state for retrospective economic regulation through the criminal code. Through vigorous enforcement of a tighter set of criminal fraud laws, the business establishment expected to clamp down on dodgy small-scale enterprises and outright fly-by-night firms. Such enforcement centrally involved the state. Indeed, it entailed increased resources for investigative and prosecutorial manpower and led to the creation of several new divisions focused specifically on fraud, such as within the offices of New York's Attorney General and the U.S. Attorney in Southern New York. Such public fraud fighters, however, worked in conjunction with the new nonprofit organizations created by business elites. Those entities often had greater financial resources and administrative capacity, and increasingly served as an investigative filter, handling initial complaints and deciding which cases merited governmental attention. The cozy relations between anti-fraud organizations and law enforcement officials faced no sanction from the American judiciary, in sharp distinction to the cold shoulder that the era's judges gave to price-fixing agreements and efforts to share information about prices and costs. American cartels and open-price associations had to struggle against age-old legal suspicion of restraints of trade. NACM and the BBBs, by contrast, could and did portray their endeavors as attempts to vindicate American law, to breathe life into long-standing common law precepts against economic deceit that had remained mainly dormant because of practical barriers to fraud prosecutions. In both state and federal courts, judges typically endorsed such activities. As one member of the federal bench argued in a 1941 case concerning the obligation of the Oklahoma City BBB to pay Social Security taxes, "The Bureau carries on a continuous campaign of fraud prevention work. It warns the public against fraudulent plans and schemes. It endeavors to induce the local advertising agencies not to accept advertisements from the promoters of such plans and schemes. Through newspaper advertisements, radio talks, bulletins, and posters, it acquaints the public with fraudulent practices. It exposes specific fraudulent practices being carried on in Oklahoma City. It also endeavors to induce merchants to refrain from misleading advertising, extravagant claims, and price comparisons, and to conform to a high standard of business ethics. It endeavors to educate the consumer to buy wisely." This supportive depiction might as well have been authored by a BBB official. In 1929, New York City magistrate George W. Simpson penned a perhaps even more revealing note to H.J. Kenner in advance of the latter's appearance at a Rotary Club luncheon, imploring Kenner to enlist Rotary in our cause, by which he meant the effort not only to stop outright fraud, but also to head off borderline fraud. Simpson signed the note, "Fraternally yours," an epistolary gesture that helps to explain judicial deference to the strategies of public-spirited businessmen and anti-fraud professionals, who, after all, possessed similar socioeconomic and educational backgrounds as the prototypical mid-20th century American jurist. Unsurprisingly, in light of such sentiments, American judges shied away from placing roadblocks in the path of the anti-fraud campaign. When businessmen shamed by bureaus for fraudulent practices brought libel suits, courts rejected them. As a result of this legal acceptance, early 20th century business-government associationalism reached its apex in the arena of regulating commercial speech. Here, the cooperative impulse among business elites skirted the typical judicial preference for economic competition. Here, the relationship between business and the American state more closely approximated the situation across the Atlantic, where European governments tended to ratify price-fixing agreements in order to stabilize a tumultuous economic environment. Because the early 20th century anti-fraud campaign received such strong support from American government, it represented an ambitious experiment in business self-regulation. Its champions did not hesitate to trumpet its successes, which they depicted as a vindication for business home rule and self-government. Anti-fraud leaders missed few opportunities to broadcast achievements, especially in bringing the individuals, businesses, and rings who engaged in fraud to face the criminal justice system. Both NACM and the BBBs kept careful track of investigations through monthly updates and annual reports, partly to justify their effectiveness to business subscribers. The two institutions also highlighted evidence of significant contributions to law enforcement and even some indications of deterrence. Between 1925 and 1929, the labors of NACM's Investigation and Prosecution Department resulted in nearly 1,600 indictments from either state or federal grand juries. Of the cases that had gone to trial by June 1929, prosecutors had secured more than 734 convictions, achieving a success rate of over 80%. Government prosecutors reported that this showing reflected considerably better conviction rates than before NACM began assisting in evidence gathering, both for fraud cases and for criminal complaints generally. It certainly reflected a vast improvement over the paltry 19th century conviction rates for fraud-related prosecutions. Over the course of the 1920s, BBB managers could point to an even wider array of accomplishments. In addition to the standardization of trade names through industry conferences, local and national bureaus had assisted the print media and radio stations in assessing suspicious requests for advertising space, culminating in the rejection of thousands of proposed ads, including nearly all pitches for get-rich-quick schemes in respectable publications. They had collectively handled several million complaints about either securities promotions or the marketing practices of advertisers, and had negotiated tens of thousands of adjustments in marketing policies by urban retailers in every region of the country. Such adjustments occurred more readily because of the credibility that the bureaus possessed in local business communities, and because of their capacity to operate flexibly and, when they so chose, outside the glare of publicity. Like NACM, the BBBs also made a significant mark on the enforcement of fraud laws. Investigations undertaken by bureaus across the country led to hundreds of indictments and convictions, especially under the federal mail fraud statutes and state securities fraud laws, such as New York's Martin Act, which criminalized deception in securities promotions. The nation's chief fraud opponents further claimed that their undertakings had cut down the numbers of suckers taken for a ride and dramatically improved business ethics. NACM oversaw the founding of dozens of credit exchange and adjustment bureaus across the country, which its officials portrayed as reducing the susceptibility of suppliers to credit fraud. Repeated BBB warnings helped to limit public losses in a host of post-World War I investment and employment scams. Within the realm of merchandising, executives at several large department stores became convinced that the Bureau's outside monitoring of advertising served as a useful check on store practices, leading to the improvement of retail stores as public institutions. As a result of the outside prodding, these executives encouraged their buyers and division managers not only to exercise greater care in formulating advertisements and to cooperate with any BBB investigations, but also to engage in their own surveillance of competitors. Anti-fraud professionals could even point to indications that their labors had created a more substantial deterrent to commercial skullduggery. According to NACM, tighter credit standards and heightened prosecution of credit fraud resulted in a 32% decline in the number of cases referred to its investigation and prosecution department between 1925 and 1928. As early as 1926, the group's general manager, J.H. Trigo, assured its members that "watch your step" has become the motto of the commercial crook. The BBBs pointed to assessments of retail advertising in St. Louis that reported only 2% error rates by the mid-1930s, and a study of 2 fraudulent stock promotions that found a disproportionate number of suckers lived outside the areas served by a bureau. According to BBB officials, such findings suggested that swindlers had learned to avoid their territory. Whether or not all of these assertions had a solid factual basis, they gained currency in the nation's print media, as suggested by a 1929 cartoon in the New Orleans Times-Picayune. Depicting the apprehension of a credit crook by a robust Credit Men's Association, figured again as a policeman, the cartoon includes as onlookers both a very pleased representative of New Orleans business and a fearful potential credit crook. By the mid-1920s, the growing influence of the American anti-fraud movement encouraged some of its key leaders to think in transnational terms. Within NACM, officials envisioned an international credit bureau that would monitor relations between commercial creditors and debtors across national boundaries, while fostering international coordination of credit methods and ideals. Leaders in the truth in advertising movement similarly wished to expand abroad, targeting Europe, and especially England, as propitious ground for anti-fraud bureaus. Such confident proposals for extensions of soft American power dovetailed closely with the dramatic expansion of Rotary International and the effort to bring U.S. retailing strategies to Europe during the 1930s. The latter initiatives broadly shared the ideological predispositions of the Campaign for Economic Truthfulness, as well as the participation of many of the same business elites. To commercial leaders such as Louis Kirstein, American self-government of industry deserved emulation by other industrialized nations. For all the successes of the Credit Men's Associations and the BBBs, the handling of deceptive commercial practices through self-regulation and retrospective law enforcement had some serious limitations. NACM's entreaties that credit managers no longer prefer short-term profits to the longer-term health of the overall commercial credit system clearly did not persuade a great many executives. Otherwise, the Credit Monthly would not have had to continue issuing insistent pleas throughout the 1920s for credit managers to perform due diligence in vetting potential mercantile customers, to share their knowledge about problematic debtors, and to refuse to accept compromise payments from dishonest debtors. All of the BBB's public warnings, all the rejected advertisements and negotiated adjustments of marketing policies, all of the arrests and convictions did not put that much of a dent in BBB estimates of overall fraud incidents. Cut off from easy access to established media organs, swindlers merely turned in greater numbers to the production of their own tip sheets and financial papers, which they distributed widely throughout the country. No longer able to unload a given worthless stock or real estate development because of public exposure, promoters moved on to another town, another scheme, often pursuing some twist on well-known scams that kept the sucker bait fresh. At no point in the 1920s did either law enforcement officials or representatives of anti-fraud organizations estimate actual declines in the annual losses resulting from fraud. Furthermore, the onset of economic depression sharpened the incentives for deceptive advertising as retailers chased ever more elusive consumer dollars and created new avenues for stock swindling, chiefly through attempts to reorganize bankrupt companies. Throughout the interwar period, anti-fraud campaigners sought to solidify their newly gained authority, often through a kind of rhetorical alchemy. These individuals had to show a business constituency increasingly drawn to quantitative assessments of success that contributions to anti-fraud organizations led to appropriate and predicted results. But they also had a predisposition to find new threats to commercial confidence and to magnify the nature of such dangers. Like police in a variety of contexts, and like modern organizational consultants, anti-fraud professionals had a powerful incentive at once to crow about their impact and warn about the fearful consequences of not receiving ongoing funding and support. In addition, anti-swindling campaigns consistently cast suspicions on Americans from the commercial and social margins. These undertakings were funded by large-scale enterprises whose managers believed that small firms constituted the gravest threat to standards of fair dealing. Leaders at NACM and the BBBs came from America's native-born Protestant establishment, and their world views were shaped by the values and expectations of that establishment. J. Harry Trigo, the most important leader at NACM during its first 30 years, offers an instructive example. A fixture of Baltimore's Presbyterian community and a stalwart Republican, he devoted considerable attention to his city's, Baltimore, Young Men's Christian Association, expressed deep-seated hostility toward alcohol consumption, and imbibed the waxing nativism of the post-World War I era. His political and cultural sensibilities had a great deal in common with that of a 19th-century anti-fraud crusader such as Anthony Comstock. To Trigo, the basis of American civilization was under siege from both the low-thinking foreigner and the labor radical. As he explained when denouncing the labor leader Samuel Gompers for criticizing a Supreme Court decision in 1922, "The safety of America is threatened by barbarians like those who caused the downfall of Rome." Such ethnocentrism lent anti-fraud campaigns an anti-immigrant animus, just like the public health initiatives that its publicists so frequently held up as models. To be sure, anti-fraud organizations targeted immigrant communities for educational messages about the best practices for consumers and investors. But in working to fashion a nationwide vacuum cleaning system, a network powerful enough to remove what one NACM Mandarin saw as the unclean lepers that imperiled domestic economic health, these institutions often focused investigative resources on immigrant communities. The Syrian mercantile community received especially close scrutiny, reflecting its reputation for incorporating recently arrived compatriots into fraud rings. Eastern European Jews also figured prominently in the rundowns of arrests and convictions published by Credit Monthly, as well as its accounts of the detective work that brought commercial crooks to justice. As NACM's chief investigator, C.D. West, made clear in one such profile of a Russian Jew who was a serial credit swindler, the organization sought to free business of the parasite, the dishonest immigrant who believes that a change of name and a little American veneer will bring him a fortune overnight. In an analogous vein, BBB staff expended most of their energies on combating commercial untruths by con artists and smaller businesses that pushed the limits of acceptable puffery, hyperbole, and bombast. With the exception of some large-scale retailers who relied heavily on newspaper advertising, the bureaus left alone the big corporations whose executives sat on their boards of directors. As a result, at no point during the 1920s stock boom did the BBB network identify the era's egregious conflicts of interest or misrepresentations within the reputable finance industry, all of which came to light amid the congressional investigations of the early 1930s. Bureau investigators steered clear of securities listed on the major exchanges and pressed ordinary investors to place their trust and savings in the hands of expert counselors from the banking industry. BBB managers issued no warnings about the deceitful tactics used by most leading investment banks to push hundreds of millions of dollars worth of exceedingly risky Latin American bond issues on their customers. They published no cautions about the stock manipulations and insider dealing undertaken by several leading New York City banks. They offered no admonitions about the duplicitous marketing of Kruger and Toll bonds to thousands of small investors, nor the beguiling promises associated with the bond flotations of the Insol public utilities empire. In response to a 1927 inquiry from a New York financial reporter, one BBB employee did voice some concerns about the high overhead costs and questionable management practices of the new investment trusts, later known as mutual funds. By the early 1930s, it would become clear that this early warning was prescient. A number of investment trusts engaged in rank manipulations of stocks controlled by their executives. Others operated on the Fund W plan, issuing false statements of results and paying dividends to early investors out of the capital of those who came later. But the day after the BBB employees' comments appeared in the press, H.J. Kenner issued a clarifying public letter insisting that these remarks were merely his personal views on the subject, and that the Bureau had no institutional position on the advisability of placing funds in investment trusts. The BBB, Kenner reminded the public, confined itself to facts about companies which may appear to be under suspicion. Despite hundreds of bulletins about shady investments, the nation's most prominent anti-fraud organization remained blind to the seamier practices of the investment banks and brokerage firms that bankrolled it. Tellingly, in 1930, the New York City BBB placed Richard Whitney, then NYSE president, on its advisory board. Like the rest of the country, the Bureau remained oblivious to the financial improprieties surrounding his brokerage firm, chiefly the appropriation of trust funds to his own use that would eventually land him in prison. Implicitly convinced of their patron's respectability and honor, BBB officials simply could not entertain the possibility that their chief backers might be major contributors to the problem of duplicity in the American marketplace. They did not so much willfully ignore evidence of financial deceit in high places as never go looking for it. For Kenner and other leaders of the anti-fraud movement, fraud crept in on the feet of outsiders. Where post-World War I anti-fraud organizations such as NACM and the BBBs chose to tread, in clarifying commercial rules for advertising, merchandising, and granting credit, or in putting unambiguously fraudulent promoters and brokerage firms under close surveillance, their close links to prominent businesses and prosecutors, along with their ability to handle disputes flexibly, allowed them to make significant headway. A 1925 speech to employees by Sheldon Coons, the advertising manager of Gimbel's department store, encapsulates many of these advantages. The Better Business Bureau, Coons assured his audience, is not a police organization. It is not an organization run by somebody trying to interfere with our business. It is an organization designed and financed by New York stores and investment houses. Our membership is costing us several $1,000s a year. We are members of this bureau because we want an outside check upon our activities. For Coons, the BBB was a friend rather than a bureaucratic enemy, and deserved cooperation and respect. But the circumscribed territory in which anti-fraud organizations chose to exercise their jurisdiction also ensured some rather glaring failures, and with those failures would eventually come a turn to far more vigorous forms of governmental regulation during the Roosevelt administration. The resulting embrace of an ever more ambitious set of anti-fraud regulatory objectives will receive extended attention in Part 4. But first, the legal environment ushered in by progressive-era policy innovations merits a closer look. Day-to-day efforts to strike at economic duplicity not only threatened to stifle entrepreneurial ingenuity, at times they also endangered long-standing procedural commitments to the rule of law. Chapter 8. Quandaries of Procedural Justice. The modes of American fraud policing that emerged from the early 1870s through the 1920s augmented regulatory power. Both within and outside of the state, anti-fraud organizations developed an unprecedented capacity to monitor economic misrepresentations and sanction the individuals and firms responsible for them. Ranging from chemical laboratories to nationwide information clearinghouses, the new regulatory infrastructures boasted pools of trained, experienced manpower, including scientists, inspectors, and detectives. These fraud fighters did not sit back and wait for allegations of fraud to come to them. They randomly tested the composition of agricultural inputs, impersonated customers to amass evidence against sham mail-order firms, and sent shoppers to see if marketing practices lived up to the promises of advertising copy. In order to overcome the collective action problems that so often stymied fraud prosecutions, they built investigative networks that matched the geographic range of sophisticated swindling rings and deceptive promoters. Finally, anti-fraud organizations developed far-reaching remedies for economic deception, imposing new quality standards, cutting off access to the mails, and limiting access to advertising channels. These new forms of bureaucratic power did not sit well with some Americans. Previous chapters have offered glimmers of this discontent. Through 1910 or so, the most vocal protests came from businesses who perceived themselves as unjustly treated by anti-fraud institutions, although Democratic newspapers and champions of civil liberties from both major parties sometimes chimed in. By the advent of the Wilson administration, anxieties over anti-fraud tactics were increasingly expressed by a conservative faction within the legal profession, who viewed discretionary administrative power with abiding suspicion. One recurrent complaint emphasized a lack of consistency in regulatory determinations, as had occurred in response to variable fertilizer analyses or grain grading. A second, and even more powerful objection, targeted invasive investigative techniques and unaccountable methods of adjudication, which opponents of anti-fraud efforts portrayed as harmful to competition, undemocratic, and even un-American. These latter grievances arose particularly in the contexts of administrative mail fraud enforcement between the 1880s and early 1900s, and the later enforcement activities of the Better Business Bureaus during the 1920s and early 1930s. Postal officials and BBB leaders vociferously defended themselves against their detractors, but eventually modified internal procedures to assuage critics, chiefly through more formal protections for due process. The resulting adjustments anticipated a broader mid-20th century effort to accommodate evolving administrative institutions to the long-standing formalities and values of American legal culture. In the federal government, this process culminated in the passage of the Administrative Procedure Act of 1946, which compelled federal regulatory institutions to adhere to exacting procedural standards in both rulemaking and enforcement actions. But it was evident as well in the early history of the Federal Trade Commission, created in 1914, which from its first decades embraced modes of proceeding that hewed much more closely to common law protections than had the Post Office Department before 1913. Procedural reform and anti-fraud efforts thus served as a prologue to more general administrative law reform. Insofar as late 19th and early 20th century anti-fraud initiatives achieved their aims, success often depended on the power to act quickly and with discretion. One key virtue of postal fraud orders and informal agreements to exclude advertisers from leading publications was that officials could implement them rapidly before fraudulent firms reached many victims. In addition, threats to rely on these remedies persuaded numerous firms that had used marginally deceptive tactics to discontinue them. These advantages were hallmarks of effective regulatory governance. But when both the Post Office and the BBBs eventually agreed to reshape their methods of handling disputes, they reduced their disciplinary impact. Such adjustments testified to the enduring force of America's common law legal culture, even as the United States came to terms with the pressures of modern capitalism. Anti-Comstockery. The first broadsides directed at the Post Office arrived almost as soon as it began to enforce the 1872 Postal Reform Act's provisions targeting objectionable materials in the mails. Opponents of Anthony Comstock's moral crusade complained that his techniques violated American norms of fair play. By adopting fictitious personas to gain evidence against the senders of illicit mail, critics charged, Comstock embraced means that were as immoral as his antagonists' businesses. One Democratic editor insisted at various points in the mid-1870s that the New York City postal inspector stooped to lies and forgeries by sending his decoy letters in search of illegal goods. He made his living by lying, swindling, and deceiving the people in the name of the God and morality party against all true law and manly decency. He systematically relied on the same sort of false pretenses as his far-flung suspects. Comstock's campaigns against distributors of pornography provoked the loudest condemnations of his enforcement practices, though few voices defended the rights of publishers to disseminate literature with sexual content. But many New Englanders, including a number of non-evangelical ministers and avowed free-thinkers, objected to the vice reformers' aggressive investigations in much the same fashion as the Chicago newspaperman. A New York City minister objected to the whole system of spies and the lying thereby enacted by the use of decoy letters, while a Boston intellectual argued that a lie or fraud perpetrated in behalf of morality or religion is just as truly a lie or a fraud as is one prompted by the father of lies. One New York City publisher whom Comstock arrested for selling pamphlets that contradicted Christian revelation and discussed sexual reproduction, D.M. Bennett, compared his mode of operation to that of the Spanish Inquisition. To Bennett, the postal inspectors had embarked on a nefarious business founded on falsehood, deception, traps, and pitfalls for the unwary. This approach might furnish evidence against many ne'er-do-wells, but at the cost of ensnaring innocent individuals as well. Such critiques persuaded over 70,000 Americans to petition Congress in the late 1870s to repeal the obscenity portions of the postal reform law. Qualms about Comstock's practices paralleled concerns about the surveillance instituted by private credit reporting agencies in the mid-19th century. Credit reporters did not engage in such subterfuges. Instead, the agents for R.G. Dunn, Bradstreet's, and other such businesses compiled financial details about individuals, as well as prevailing opinions about their creditworthiness and character. Yet the creation of a nationwide system of surveillance over commercial debtors struck many Americans as a disreputable spy system that intruded into private lives. Other commentators objected to the Secret Service manner in which commercial agencies did their business, because the identity of credit reporters remained a mystery, as did the process by which they formulated their judgments. 19th-century credit reporters and postal inspectors attracted reproach for similar reasons. Both worked for national organizations that wielded potentially crippling power over individuals and firms. Both pursued investigations in secret and made decisions without fear of legal accountability. Underlying the uneasiness with credit reporting and mail fraud enforcement lay ambivalence about the way that the creation of an integrated national economy tended to bring about concentrations of power, minimally constrained by legal or democratic oversight. As Philadelphia economics writer Edward Friedley articulated the concern in 1853, mercantile agencies were in the hands of a few men, self-constituted umpires, subject to the errors of ignorance and mistakes of carelessness, with no guaranteed exemption from the influence of malice, favoritism, bribery, or corruption. Cautions such as Friedli's embodied suspicions of unchecked authority that had animated American politics since the Revolution. Credit reporting firms and the Postal Inspectorate mostly parried the thrusts of their adversaries. The former emphasized their role in preventing reckless speculators and unsavory characters from gaining access to established channels of credit, as well as their facilitation of such access to reputable firms. Mercantile agencies further insisted that the pressures of an intertwined national credit system necessarily limited the privacy rights of would-be debtors. Postal officials stressed the difficulty of building evidentiary cases against proprietors of illicit businesses operating across state lines, which justified some tactical deceptions. Officers who deal with corrupt men, the Reverend Henry Ward Beecher argued at the 1885 annual meeting of the New York Society for the Suppression of Vice, must adapt themselves to the finesse, the courage, and the trickery of their game. As Anthony Comstock stressed, those who complained about the postal laws primarily had run afoul of those prohibitions. They were not the merchant, banker, or businessman engaged in open legal traffic. Comstock further emphasized that there were strict limits to the inspectorate's finesse and trickery. At no point did they violate the sacred seal of mail-in-transit. They simply ordered and purchased goods from firms identified by suspicious advertisements, extraordinary postal volume, or specific complaints from members of the public. In doing so, they used test letters, not decoys. Official duplicity extended only to the fabrication of identities for the purpose of initiating orders. Many Republicans and evangelicals, including key figures within the nation's commercial elite, joined the defense of virtuous creditor reporters and heroic soldiers against vice. Organs of the business establishment, such as Hunt's Merchants Magazine and Bankers Magazine, offered early and full-throated support to nascent credit reporting firms. Once they became established in the 1840s and 1850s, metropolitan business leaders and social commentators portrayed them as a pillar of the country's economic infrastructure. The mercantile agency system, Bankers Magazine concluded in 1858, safeguarded honest businessmen from the ruinous competition of the inexperienced, the incompetent, and the fraudulent, while redressing many evils incident to the credit system. According to the Philadelphia Inquirer, credit reporters labored not only for the benefit of the general commerce of the country, but for the benefit of their neighbors and friends. By the 1880s, the role of credit reporting in protecting merchants and manufacturers against fraud and imposition had become commonplace among leading businessmen. This elite consensus helped commercial agencies fend off libel lawsuits from the 1850s through the 1880s, as well as regulatory proposals in several states. Legal actions were initiated by businessmen who alleged that false credit reports had occasioned commercial losses. In the federal courts and northeastern state courts, judges consistently held that when credit reporters provided information to customers on a confidential basis, they were not liable for damages resulting from inaccuracies made in good faith. Elsewhere, Dunn lawyers sought to frustrate libel litigants through procedural objections and delaying motions, pressure on mercantile witnesses not to testify, and enticements to plaintiffs' lawyers to drop suits. If strong-arm tactics proved insufficient, the agency settled cases to avoid adverse judicial opinions. During the 1870s and 1880s, especially after financial crises that led to widespread bankruptcies, state legislators throughout the nation proposed tough regulations on credit reporting. The most common bills either made intentional dissemination of a false credit report a crime, or required commercial agencies to post heavy bonds as checks against losses resulting from false reports. Outside of South Dakota, which in 1890 passed a bond requirement, credit reporting firms found sufficient legislative allies to keep such ideas from becoming law. The Northeastern establishment similarly endorsed the post office's attempts to regulate fraudulent marketing and the trade in obscene literature. Comstock's Fraud Exposed, explicitly written to counter attacks on mail fraud and obscenity enforcement, received laudatory reviews in the religious, commercial, and Republican press. The Boston Advertiser typically characterized Comstock's ruses as the only way yet discovered to track and convict the scoundrels who defrauded Americans through the mails. Publication of annual reports from the country's urban anti-vice societies, which tallied arrests and other enforcement actions, prompted similar commentary. The objectives of the flagship New York organization, the Christian Advocate explained, were of the highest value to every Christian community and every family home, while its indefatigable secretary, Mr. Anthony Comstock, was doing a work of real Christian heroism by battling the mercenary fiends who are preying upon the morals of the body politic. Persuaded by Comstock and his backers, the nation's business and political leaders brushed off periodic calls for Congress to prune back the regulatory powers of postal authorities, or for the Postmaster General to muzzle his eager special agents. Comstock also sidestepped an attempt on his life in 1874, as well as legal actions for libel and false arrest. Although attacks on Anthony Comstock and his fellow inspectors did little to change investigative practices in mail fraud cases, a quarter-century's worth of complaints about administrative adjudication of mail fraud allegations encouraged procedural adjustments. The assault on the post office's internal legal process was spearheaded by relatively deep-pocketed businessmen who faced fraud order proceedings. The first effort along these lines, undertaken in 1879 by the extremely well-resourced Louisiana Lottery, challenged the fraud order's constitutionality. After a federal court rejected this gambit, attention turned to the specifics of how individuals evaluated evidence collected by postal inspectors and then made determinations to bar individuals or firms from receiving mail. The 1872 Postal Reform Law furnished few guides about such matters. Until the mid-1890s, the department's practice was to have a postal inspector or special agent write up a report on a case, which he would then send to the Assistant Attorney General for the Post Office. After reading the report and any supporting documents, that official would make a recommendation to the Postmaster General, who almost always followed his advice. This approach meant that very few subjects under investigation received the benefit of a hearing prior to the issuance of a fraud order. Indeed, from 1872 through 1896, very few individuals even received notice that the post office was considering action against them. Like Richard Sears, fraud order recipients usually learned about the post office's concerns only once they were barred from the mails. Although most subjects of fraud orders responded with flight, those on the entrepreneurial margin often, again like Richard Sears, appealed for revocations. The post office generally granted hearings in these circumstances and, as we have seen, demonstrated a willingness to revoke fraud orders if lawyers could show that their clients had the backing of significant local elites and would discontinue any problematic marketing practices. After the issuance of fraud orders, however, the legal burden rested on recipients to show why the post office should rescind them. During the 1890s, the government agreed to as many as 64 revocations a year. That same decade, attorneys for the bond investment companies hit with fraud orders excoriated the post office's disregard for basic principles of due process. Thus, J.T. Hanna, an attorney representing Illinois' State Mutual Life Insurance Company, wrote to the acting Postmaster General in July 1894 to express shock at the post office's treatment of his clients. The department, Hanna maintained, has seen fit to brand the business of this company as fraudulent upon information secretly transmitted to you without giving it any notice thereof or an opportunity to meet the charges. Adding insult to injury, it then refused to explain the basis for its action. The lowest criminal, the attorney observed, received more substantial procedural respect. Such treatment occasioned stinging rebukes from the trade press of the advertising industry. To the editor of the Advertiser's Guide, the underlings of the post office had set themselves up as petty tyrants who were every bit as autocratic as the Tsar of Russia or the Sultan of Turkey. Rendering the U.S. Constitution a dead letter, they had instituted a Star Chamber tribunal in which the system hangs men first and tries them after. Late in 1896, members of the federal judiciary joined the chorus condemning the slipshod legal process within the Post Office Department, prompted by legal actions that bond investment firms and brokerages brought to challenge fraud orders. That September, several Chicago brokerages received fraud orders on the grounds that they were bucket shops. One firm challenged the action in federal court, arguing that it had received no prior notice and had no chance to defend itself. At the resulting hearing, District Judge Peter Grosscup took pains to emphasize that the Postmaster General's authority to issue fraud orders was settled law. But he voiced disapproval of the one-sided nature of the department's investigative sifting of facts. "I do not think," Grosscup explained from the bench, "that an ex parte statement of some postal inspector should be the basis of an order that might destroy a man's business." A week later, the judge refused to grant an injunction against the Chicago postmaster, though not without remarking that the great authority vested in the Postmaster General ought to be restricted. Officials in Washington could pay little heed to the yelps of dodgy mail-order businesses or the screeds of advertising journals that profited from deceptive ads. After all, the late 19th century American legal system tolerated many summary processes in which defendants possessed few of the procedural rights enshrined in the state and federal constitutions. The handling of vagrancy charges by urban and southern rural courts stood out in this regard, as did federal hearings to consider the exclusion of would-be immigrants. But a sharp lecture from an esteemed federal judge who had a track record of ratifying the post office's regulatory efforts was not so easy to ignore. After the Republicans had regained the White House and control over federal appointments in the 1896 election, the new Assistant Attorney General for the Post Office, James Tyner, revised fraud order policy. Henceforth, postal officials would conduct hearings in Washington before issuing fraud orders. Legal process would remain far more informal than civil suits or criminal trials, and defendants would not necessarily receive access to evidence against them. But postal officials would no longer act against businesses on the basis of allegations made by one aggrieved person, and they would furnish a memorandum of the charges to assist the mounting of a legal defense. These procedural concessions ushered in a 6-year period in which the post office issued fraud orders far less frequently, in some years barring fewer than 50 individuals or firms from the mails. Officials publicly explained the reduction as a reflection of more careful vetting of cases, along with a disinclination to issue fraud orders in doubtful cases. The new standard led the department to revoke a number of fraud orders, including several that targeted bond investment companies, on the grounds that federal courts had not adjudged their operations to be so deceptive as to constitute fraud. By expanding the zone of legal ambiguity surrounding the fraud order, the McKinley administration heightened opportunities for corruption with the office of the Assistant Attorney General for the Post Office. As a subsequent 2-year internal investigation documented, James Tyner's deputy and nephew, Harrison Barrett, along with another departmental lawyer, Daniel Miller, used the new procedures to operate a de facto protection racket. After notifying firms that they were under investigation, Barrett and Miller intimated that the owners could deflect legal action by amending their business practices. The key step, they then explained in letters to corporate attorneys, was to retain outside legal counsel who possessed the expertise to guide them. Through the close of 1900, Barrett directed mail-order firms to a Baltimore lawyer with whom he had close relations. He then resigned his position and entered into a partnership with that attorney. Thereafter, Miller suggested that businesses that needed to revise marketing literature to meet postal standards hire Barrett. Tyner subsequently lost his job, and both he and Barrett faced a 1904 criminal trial for conspiracy to defraud the government, which resulted in an acquittal attributed chiefly to Tyner's advanced age and poor health. Such influence peddling extended beyond the confines of the Post Office Department, reaching as far as Congress. A few months before the Tyner-Barrett trial, Senator Joseph Burton of Kansas was convicted on a bribery charge stemming from his efforts to forestall a fraud order against a St. Louis investment firm. In exchange for a $500 monthly retainer, Burton agreed to act as the investment firm's attorney, using his influence to intercede with postal authorities. The senator made no attempt to deny this arrangement. Instead, he argued that his legal services constituted a more formal version of the good word that members of Congress regularly communicated to the Post Office Department on behalf of constituents under suspicion. Burton's trial, in conjunction with the Tyner-Barrett revelations, suggested that irregularities had become commonplace within mail-order proceedings. These scandals gave adversaries of the fraud order additional ammunition, and they wasted little time in using it. As in the 1890s, the leading dissenters were high-profile businessmen who faced postal scrutiny. Led by oilman H. H. Tucker and publisher and banker E. G. Lewis, these critics sharpened the arguments against the Post Office's allegedly autocratic practices and disseminated them to a national audience. They simultaneously cultivated influential new allies among civil libertarians and members of Congress. Tucker, one of the colorful early 20th century stock promoters who invoked a language of democratic capitalism, sought to cash in on a succession of oil booms in Kansas, Oklahoma, and Texas through the Uncle Sam Oil Company. Attracting thousands of investors through puffing newspaper advertisements and prospectuses, Tucker promised not only to develop wells in emerging fields, but also to build refineries and a transport network. The oilman initially cultivated investor loyalty by depicting his enterprise as an inveterate opponent of the Standard Oil monopoly. He then cemented attachment to Uncle Sam by explaining any legal setbacks, including a 1907 mail fraud prosecution and 1908 fraud order, as the result of dirty work by Standard Oil's political and legal errand boys. Insisting that the post office was persecuting him at the behest of the oil giant, Tucker avoided a guilty verdict in 1907 and then took his attacks to Congress, President Theodore Roosevelt, and the press. At every point he lambasted postal officials, and especially R.P. Godwin, Tyner's successor as Assistant Attorney General. Godwin, Tucker's company argued in a 1908 petition to Congress, had maliciously disregarded evidence presented by Uncle Sam at its fraud order hearing, and then authored a report on the case that was untrue and incorrect and wholly unsupported. In addition to asking for relief from the fraud order, Tucker called for a congressional investigation into postal regulation that would expose the outrages and injustices as have been perpetrated upon this company, create a basis for the punishment of misconduct in office, and formulate legislative reforms that would prevent such injustices in the future. Lewis, the St. Louis-based mail-order entrepreneur who mixed an eye for innovative business opportunities with an elastic conception of truthful marketing, responded even more vigorously to the Post Office's regulatory tactics. He excoriated the department in his magazine's editorial pages, then, through his publishing company, distributed 2 books that fleshed out his critiques. He cooperated in the production of a 3rd volume about his travails, authored by a former high-ranking postal official who dissented from the department's treatment of Lewis. Through his political connections, he also pushed legislation to establish a legal mechanism to appeal fraud orders in the federal courts. Like Tucker, Lewis alleged malfeasance, claiming that the postal protection racket had continued after Tyner's firing and was now run by Leonard Goodwin, a Chicago attorney specializing in mail fraud cases and the brother of the new Assistant Attorney General. Lewis alleged that Goodwin had promised to make his troubles with the federal government disappear. For the right retainer, he would show the publisher how to word his marketing materials so as to meet any objections from the post office. Such machinations were possible, Lewis argued, because every step of the fraud order process remained shrouded in secrecy. Even when accorded a hearing, defendants had no access to the evidence, inspectors' reports, or legal justifications that underpinned fraud orders. "If a man uses the mails," Lewis defiantly pronounced in 1905, "he has no right of any sort that a post office inspector has to respect." The publisher and banker portrayed himself as a victim of secret Russian methods, a man who had been crucified from coast to coast as a fraud and swindler. On their own, the transparently self-interested views from shifty entrepreneurs on the margins of American capitalism were unlikely to influence the direction of postal regulation. But the arguments put forward by H. Tucker, E.G. Lewis, and other mail-order businessmen received amplification from the occasional trade journal affiliated with the sector. They also resonated with a collection of writers, lawyers, and politicians who either worried about individual civil liberties or opposed waxing centralization of federal authority, as well as some conservative Republicans who winced at their party's flirtation with paternalistic regulation. The periodical Health, which catered to a sector that attracted numerous fraud orders in the 1900s, encapsulated the key arguments against post office legal culture in a 1909 editorial. Fraud order proceedings, Health's editor fulminated, were arbitrary, a gross travesty of justice, even un-American. The Assistant Attorney General for the Post Office had become a veritable poobah who took on the roles of prosecutor, judge, and sheriff. This official decided whether the initial evidence collected by postal inspectors warranted a hearing, oversaw that proceeding, and then determined whether to recommend a fraud order. This mixing of legal functions, the editor proclaimed, violated basic Anglo-American norms about justice and the rule of law. An eclectic group of public intellectuals picked up on similar themes. The anti-imperialist editor Louis Post saw fraud orders as a type of persecution, given that they occurred without trial or accusation upon the mere ipse dixit of a postal clerk at Washington. Such power harnessed autocratic impulses on a par with the extension of American political control over territories recently wrested from Spain. Franklin Pierce, a prominent New York City attorney and Democratic legal reformer, identified the lack of due process in mail fraud deliberations as a prime example of federal usurpation, also evident in growing reliance on appointed commissions and the summary conduct of immigration cases. Even with the procedural reforms initiated in 1897, the Post Office retained authority to institute temporary bans on mail service pending hearings. Such action, Pierce maintained, shared much in common with lynchings, as the Postmaster General first went about destroying a man's business and then gave him the courtesy of a hearing to ascertain whether he is guilty in front of the same official who judged the case as meriting action. For Edward Frederick Brown, a conservative Republican author, the Post Office's anti-fraud system of paternalism had put even the empires of Europe into a second class, portending an ominous illustration of the present socialistic tendency to build up the executive power. With such varied opponents of a vigorous national government training their sights on the fraud order, Lewis, Tucker, and other similarly situated businessmen had little difficulty finding congressional advocates for curbs on the Post Office's anti-fraud powers. The leading champions of reform included Edward Crumpacker, a former Indiana judge and House Republican, and William A. Ashbrook, an Ohio Democrat. An ardent opponent of racial disenfranchisement, lynching, and the treatment of African Americans by the Southern legal system, Crumpacker viewed the fraud order through the prism of procedural fairness. The Postal Department, he explained to the House of Representatives in 1906, ran a system of espionage in which hundreds of secret emissaries used dark lantern methods to produce secret reports, which then became the basis for blasting forever the business reputation of firms. Such proceedings, he argued, were absolutely inconsistent with the spirit of free institutions. From 1905 through the early 1910s, he pushed legislation that would have allowed the recipients of provisional fraud orders to appeal in federal district court. The post office would then have 15 days to make its case before a federal judge and jury, whose assent would be required for any appealed fraud order to go into effect. In federal court, common law procedural protections would be in effect, allowing accused business owners to see investigative reports and to present and cross-examine witnesses. After the Democrats' 1910 electoral victory placed Ashbrook in the chairmanship of the House Committee on Post Office Expenditures, he convened hearings on the department's treatment of E.G. Lewis and the Uncle Sam Oil Company. Taking place over several months, the Lewis hearings furnished the publisher with ample opportunity to air his version of events to a national audience, placing an official spotlight on the implementation of anti-fraud policies. As in the late 19th century, leading figures within the post office mounted a robust public relations campaign to counter attacks on their handling of fraud orders. The department's annual reports insisted that postal officials exercised great care in assessing firms alleged to be violating the mail fraud law. No firm or individual lost access to the mails without a thorough review of the relevant evidence by both the Assistant Attorney General and the Postmaster General. Whenever legitimate enterprises disseminated misleading advertisements without a clear intent to deceive, the department afforded them the chance to discontinue misrepresentations, clean up ad copy, and adjust any outstanding complaints from customers. In pamphlets and magazine articles, officials such as Postmaster General George Cortelyou further pointed out that only 1 in 80 recipients of fraud orders challenged them. They also insisted that the loudest calls for constraining post office discretion emanated from those who have been hampered in nefarious undertakings through the issuance of fraud orders, men who naturally saw the mail fraud law as autocratic and tyrannical. Above all else, postal officials stressed the indispensability of promptness in fraud order proceedings. Delay for any appreciable time meant that a scheme could run its fraudulent course or transfer its affairs to other names and destinations before it could be obstructed by official interference. By contrast, the existence of a summary process protected the public from hordes of rascals whose transgressions, because of the evidentiary challenges that had bedeviled prosecutors for decades, defied criminal prosecution. The establishment press, including trade periodicals, professional journals, mass-market magazines, and leading metropolitan newspapers, echoed the post office's stance on these issues. Whether or not federal judges paid attention to the controversies over the fraud order, they mostly continued to defer to bureaucratic judgments about which marketing practices were sufficiently deceptive to justify this remedy. In 1902, the Supreme Court did chip away at postal regulation of medical treatments. In American Magnetic School of Healing v. McAnulty, the tribunal directed a lower federal court to grant a temporary injunction against a fraud order and to entertain legal arguments about whether the school's claims about its capacity to heal patients through the use of magnetism actually constituted mail fraud. Writing for the majority, Justice Rufus Peckham ruled that assertions about the efficacy of healing methods involved matters of opinion rather than fact, and so did not easily fit within the legal framework of fraud. But in another case 2 years later, the Supreme Court reiterated that the fraud order was a constitutional exercise of power, and that the judiciary would not second-guess the Postmaster General's findings absent clear indications of legal improprieties. The lower federal courts, moreover, continued to reject almost all requests for injunctions against fraud orders, finding that the identification of fraudulent schemes was a factual matter, and that Congress had authorized postal officials to assess such facts. even when a federal judge indicated that he would have ruled differently in a fraud order proceeding, as Circuit Court Judge Learned Hand did in one 1909 case. This disagreement was not enough to overturn postal authority. So long as there be any evidence at all sustaining the Postmaster General's position, Hand concluded, that officer's decision was final and unreviewable. For the courts to void a fraud order, it would have to be a clear case of error in which no one can reasonably conclude anything else. Such a high legal standard meant that reform would have to occur through the political branches. The legislative high-water mark of efforts to subject fraud orders to judicial review came in January 1907, when the House of Representatives passed the Crumpacker Bill on a voice vote. But intensive lobbying from George Cortelyou, along with a veto threat from President Roosevelt, doomed the proposal in the Senate. Despite this legislative outcome, the tirades against postal autocracy eventually nudged the post office to adjust its policies. In 1910, a new Postmaster General, Frank Hitchcock, decided to de-emphasize the fraud order in favor of criminal prosecutions. The stated rationale for this shift was that fraud orders did little to hamstring the savviest swindlers, as a man who was put out of business by such a fraud order might very easily move across the street into another office building and begin his work over again under the name of another bogus company. To take down such adaptive promoters, Hitchcock explained, the post office had to invest the time and resources to build cases that could withstand the rigors of criminal trials. The continual comparisons of postal officials to secret police, czars, and sultans surely helped to convince him to take this step. The Post Office Department's new tack dramatically increased the number of individuals whom it arrested, prosecuted, convicted, and sent to prison for mail fraud. Before 1910, the department did not keep comprehensive statistics on its criminal fraud cases. It likely did not prosecute more than 50 a year. But from that year through the end of the Taft administration, the tempo of prosecutorial activity quickened. Over these 3 years, postal authorities sent well over 1,000 mail fraud cases into the federal courts, including several high-profile prosecutions of New York City brokerage firms that floated fraudulent stocks, such as Continental Wireless, a corporation that falsely promised to create a nationwide network of wireless telegraphy stations, a vision of what would eventually become radio. To facilitate more intensive enforcement, Hitchcock reorganized the Postal Inspectorate. In addition to placing the Inspector Corps under the immediate supervision of his office, he created an elite unit of investigators to handle complicated cases, demanded more coordination among regional offices, and instituted a policy of geographic rotation. This last innovation attacked the parochialism of many senior inspectors who had developed inappropriately cozy relationships with businessmen in their cities, including some individuals who had displayed a penchant for deceptive marketing. Hitchcock further deepened cooperation with other federal agencies with an anti-fraud mission, such as the Agricultural Department's Bureau of Chemistry, which enforced the Pure Food and Drug Act. These initiatives enabled the post office to bring off a high percentage of mail fraud convictions. From July 1910 through June 1913, the ratio of convictions to acquittals was better than 7-1, a much greater prosecutorial success rate than had been the norm in 19th-century state fraud cases. And yet, Mr. Hitchcock's war on swindlers, as the Independent dubbed it, soon bogged down amid investigative fatigue and the obstinate realities of the criminal justice system. By the fall of 1912, the Post Office Department was groaning under the strain of over 4,000 fraud investigations, leading to a formal request that Congress move responsibility for such inquiries to the Justice Department. Even though only about 1 out of every 8 investigations led to indictments, and roughly 1/4 of indictments resulted in trials, mail fraud cases also began to clog the federal courts. The reorganized and reinvigorated Postal Inspectorate could now more readily grapple with the sophisticated strategies of deception and misrepresentation employed by large-scale mail-order businesses. But as the relevant evidence became more voluminous and intricate, and as a wealthier class of defendants hired specialized legal counsel, mail fraud trials became ever more complicated. Turning on complex matters of fact and law, they often took months to complete. As Chief Postal Inspector Robert Sharp observed in 1912, mail fraud actions had practically filled the dockets of the courts and exemplified the inadequacy of the present judicial machinery to promptly dispose of the various cases. Once Postmaster General Hitchcock directed his inspectors to aim for criminal convictions rather than administrative fraud orders, federal prosecutors complained that their offices could only handle the new fraud workload to the exclusion of other matters of public importance. Faced with lengthening backlogs, U.S. attorneys called for state officials to take charge of these cases. Postal officials, moreover, soon expressed concern about judicial approaches to mail fraud trials, which tempered the impact of high conviction rates. The discouraging feature to the department in its fraud crusade, Chief Inspector Sharp lamented in 1912, was the character of sentences imposed by the courts. Individuals who defrauded thousands of Americans frequently avoided prison terms, getting off with small fines ranging from a few dollars to $3,000. Men who robbed the people of millions of dollars left courthouses with sentences of only a few months. According to Sharp, most judges did not appreciate the national implications of mail fraud, and so viewed the offense as meriting only light court sentences. The expense of these trials raised additional concerns as journalists contrasted their tens of thousands of dollars in costs with the minimal jail terms and fines that they produced. Disquiet over the shortcomings of criminal prosecution prompted yet another redirection of enforcement policy. The Democratic Postmaster General appointed by President Woodrow Wilson, Albert Burleson, articulated the need for fresh strategic thinking. His Republican predecessor's single-minded focus on criminal prosecution, Burleson proclaimed, left too many Americans vulnerable to mail fraud. Characterized by continuances, lengthy trials, and appeals, fraud prosecutions were necessarily slow, and their execution of sentences had been deferred for long periods. During this interval, which the flood of mail fraud cases had only exacerbated, many fraudulent companies had continued to reap a harvest from investors or customers. Even worse, light sentences created minimal deterrence. Short jail terms and low-level fines barely disrupted the operations of many swindling enterprises. Predicating anti-fraud strategies solely on criminal prosecution, the Wilson administration's new team contended, left the American public at the mercy of swindlers. Burleson maintained that the sensible response was to pursue both fraud orders and criminal prosecutions, because the former had immediate preventive impact. Even when firms went through the hassle of restarting their operations under newly created front companies, fraud orders reduced their profits and slowed the process of finding new customers or investors. Mindful, however, of the long-standing aspersions cast at fraud order proceedings, the new administration instituted yet another procedural overhaul. Henceforth, the Assistant Attorney General for the Post Office would no longer personally review the reports and recommendations made by postal inspectors, nor decide whether to pursue fraud orders, nor draw up formal citations of charges, nor present cases at hearings. Instead, lawyers in his office would undertake that work on their own. The Assistant Attorney General would take on a judicial role, presiding over fraud order hearings, assessing all relevant evidence and argument, and preparing memoranda for the Postmaster General's consideration. This new arrangement, postal leaders argued, addressed long-standing concerns about the unfairness of having the same person serve as prosecuting attorney and authoritative assessor of facts. Reconfiguring fraud order proceedings to look more like common law trials did not eliminate public attacks, as the occasional author or lawyer still raised the hue and cry of governance by fiat. But the Post Office Department's moves diffused politically salient critiques. Complaints about postal secret police and American star chambers no longer echoed from the House of Representatives, nor reverberated across the telegraphic reports of the Associated Press. Indeed, the ramping up of non-governmental anti-fraud organizations such as the NACM, the BBBs, and the AMA gave the Post Office influential and vocal supporters. These organizations lauded the department's endeavors and expanded its disciplinary scope, their private investigators cooperating closely with federal authorities. From 1913 into the 1920s and 1930s, postal inspectors and attorneys went about their business, while the solicitor of the Post Office Department, formerly the Assistant Attorney General, took on his new role of administrative judge. Greater attention to legal formalities, however, brought costs. Fraud order hearings evolved into elaborate affairs with motions, presentation of voluminous evidence, and punctilious production of official records. Departmental lawyers took increasing care to prepare for hearings, as did the Washington attorneys who specialized in mail fraud cases. By the late 1910s, fraud order hearings could take several weeks. This slower pace made it impossible for the department to handle the same number of formal hearings as it had under Postmaster General Cortelyou. The annual number of fraud orders accordingly declined, ranging between 27 and 76 between July 1913 and June 1919, even as mail-order business boomed. These figures understated the reach of enforcement actions, as postal officials simultaneously negotiated a much larger number of stipulations that committed otherwise legitimate businesses to stop deceptive practices. The department also continued to prioritize criminal prosecutions, with annual cases approaching 1,000 a year by America's entry into World War I. Nonetheless, by lengthening the administrative gauntlet for fraud orders, the new procedures encouraged a much finer internal filter for identifying commercial deceptions that merited action. In the 1919 fiscal year, tens of thousands of complaints and hundreds of investigations produced only 61 formal administrative hearings, with fewer than half leading to fraud orders. After its reforms, the Post Office no longer confronted noisy controversies about the legitimacy of its anti-fraud work. But the department became less nimble in its efforts to disrupt swindling through the mails, beset into the 1930s by a caseload that threatened to overwhelm an understaffed cohort of investigators and prosecutors. The Ku Klux Klan of Commerce. The nation's network of Better Business bureaus also encountered sharp public questioning of methods and motives. During the 1920s, and even more after the onset of the Great Depression, the bureaus faced claims that they cared only about extending their influence and furthering their corporate funders' interests. According to their antagonists, the BBBs sometimes functioned like the protection racket allegedly run by Post Office lawyer James Tyner. The accusations were that the BBBs extorted subscriptions from businessmen, in some cases relying on solicitation agents who employed the same boiler room tactics that BBB leaders decried in the securities markets. If local concerns refused solicitations, critics argued, those firms found themselves subject to BBB investigations and then public shaming, which often caused irreparable commercial harm. Fearful of such treatment, many businessmen decided to pay for immunity. At other times, the BBB's detractors maintained that they kept new firms from gaining footholds through sharp competition or inventive puffery, pointing to examples in the Denver dry cleaning industry and the St. Louis personal loan market. Another complaint was that the BBBs ignored the unethical or even illegal commercial practices of the large corporations on which the organizations depended for much of their funding. Anti-BBB literature of the early 1930s noted repeatedly that the NYSE and the Investment Bankers of America had furnished tens of thousands of dollars in assistance to the bureaus. A common allegation compared the bureau network to the more sophisticated tip sheets of stock swindlers, which railed against all the fraudulent promotions clogging the nation's mailbags, even as they flogged their own valueless schemes. To its critics, the anti-fraud network served the purposes of the stock exchange by throwing suspicion outward, which served also to prevent scrutiny inward. An illustration in a 1931 exposé of the anti-fraud organizations encapsulated this latter contention, portraying BBBs as the exceedingly good pal of business elites. With these lines of attack, the antagonists of private anti-fraud organizations extended a libertarian critique of governmental administrative regulation to the economic establishment's preferred mechanisms of home rule. In either case, regulatory institutions turned out to be the pawns of entrenched businesses, and so created indefensible barriers to entry for would-be competitors. Skeptics about the BBB network further condemned its pretensions to quasi-public status, calling it an invisible government without accountability or oversight. This strand of anti-BBB discourse echoed the 19th century attacks on credit reporting and the decades-long complaints about fraud orders. Like the foes of 19th century commercial spy systems and secret postal investigations, the adversaries of interwar anti-fraud organizations rejected their vaunted surveillance networks and influence over prosecutors and the press. Such methods once again attracted the charge of being un-American, because they required a system of espionage that is more vicious than the fraud it professes to suppress, and ignored principles of due process. As a longtime BBB adversary put this argument in 1933, the bureaus had supplanted the legitimate agencies of investigation, prosecution, and protection. They had placed such powers in the hands of unelected irresponsible men, as well as unlicensed snoopers, mostly despicable female quasi-purchasers who inject themselves into retail stores to find, if possible, something derogatory to the merchant. The BBB's financial dependence on many of the businesses that they monitored elicited similar complaints. Even the name of the organization came under assault. The word bureau was a delusion and a snare, falsely suggesting to ordinary Americans that it had official public status, that it was even a quasi-judicial body of our government. Vigilance Committee, the institution's original moniker, implicitly struck one antagonist, the iconoclastic social commentator Edward C. Regal, as more appropriate, because its extra-legal mode of operation was reminiscent of the Ku Klux Klan. He dubbed the BBBs the Ku Klux Klan of Commerce. Leaders of the Truth in Advertising movement had repeatedly invoked the language of home rule, portraying BBBs as institutions by which the business establishment could take the lead in policing candor in the marketplace. For Regal, parallels between the anti-fraud campaign and the cause of white supremacy extended far beyond strategies of rhetoric. The National Businessmen's Protective Council, a short-lived competitor to the BBBs, brought most of these charges together in a striking cartoon that illustrated a promotional pamphlet. The cartoon's central figure, a heavily muscled man symbolizing oppressed business, is bound by a clownish professional snooper and throttled by a venomous two-armed snake representing better business bureaus and other rackets. Over the snooper's shoulders, a racketeer whispers instructions. All the while, in the distance, governmental officials either look away or glance bemusedly at the goings-on. Here was a vision of trade and industry under the rule of the racket, and of the BBBs as antithetical to American traditions of liberty, law, and free enterprise. BBB officials responded to these various jibes in much the same way that credit reporting agencies and the post office had. In public commentary, they defended their methods as judicious institutional innovations that prevented economic duplicity. Both they and their political allies also attacked the credibility of their critics, whom bureau defenders described as falling into one of three groups. The first comprised businessmen who pursued questionable marketing tactics and hoped to deflect attention from their own malpractices. This group included the stock promoter George Graham Rice, whose encounters with postal fraud allegations had led him to hone a populist rhetoric. In the wake of his first fraud order in 1904, and then his later mail fraud convictions, the inveterate promoter levied withering assaults on postal regulation, arguing that the country's financial elite, and especially the Guggenheim mining syndicate, used it as a means to crush their antagonists. In later years, his stock tip sheets denounced the Post Office, the New York Stock Exchange, and the nation's BBBs, all of which he characterized as doing the bidding of Wall Street. A second source of criticism, BBB leaders suggested, came from professional agitators and cranks such as Frank O'Sullivan and Edwin Regal, who owed their livelihoods to windmill tilting against the central institutions of modern American society, or from seemingly upstanding civic leaders who were hiding shady pasts, such as Logan Billingsley. A small-scale Chicago publisher and author, O'Sullivan specialized in florid detective literature and exposés of the criminal underworld. A self-taught libertarian economist, Regal operated through an outfit known as the Consumers Guild of America, which was little more than a shell organization to dress up its president's periodic rants against both big business and big government. After a career in Seattle as a bootlegger, during which he faced allegations of involvement in 2 murders, Billingsley moved to New York City, where he dived into real estate development. In the early years of the Great Depression, he gained control of the moribund Bronx Chamber of Commerce and Manhattan Board of Commerce, building up their public profiles by falsely claiming to have attracted prominent businesses as members. Like George Graham Rice, Billingsley sought to discredit the institutions of the truth in advertising movement after the BBBs exposed his own deceptions and evasions. Finally, anti-fraud organizations pointed out that they were occasionally targeted by populist politicians, such as Iowa's Republican Senator Smith W. Brookhart. These politicos repeated the usual anti-BBB charges, seeing the issue as a chance to burnish their credentials as opponents of concentrated economic power. Given the sources of the complaints about BBB methods, its representatives advised that the public treat them as untrustworthy grumbling. Such gripes about the techniques of anti-fraud organizations were, the Columbus BBB explained in the early 1930s, nothing more than the squealing of a stuck pig. The squealing, however, sometimes contained an element of truth. Throughout the 1910s and the boom years of the 1920s, the BBBs had focused far more on identifying and publicizing the deceptions of fly-by-night firms than on the misrepresentations of large-scale retailers or leading investment banks. One exception to this generalization concerned price-related advertising by some metropolitan department stores, which BBB leaders highlighted as a further refutation of the claims made by its chief antagonists. The most prominent incident involved a public spat over the price claims of R.H. Macy and Company, which played out over the course of 1925 and 1926. This controversy would eventually push the BBBs, like the Post Office, to introduce procedural reforms. For decades, Macy's had cultivated a reputation for low prices, boasting, as in one typical 1880 advertisement, that "our prices are below competition." By the 1920s, this claim had become far more precise. Macy prices, the store proclaimed in a 1925 ad, are at least 6% less every day of the year on every article of merchandise, including both regular and sale items. The department store could meet this promise, executives claimed, because Macy's purchased goods in large quantities for cash or extremely short credit terms and sold only for cash, thus avoiding the bad debts and high return rates associated with credit sales. Prompted by a chorus of complaints from competitors, the New York City BBB's merchandising division sent its professional shoppers into Macy's over several months in 1925, in line with its policy of checking the advertising claims of all retailers, including member firms. The shoppers then compared the prices of identical items at other retailers, discovering dozens of items elsewhere that were the same price or even cheaper. Several meetings between BBB officials and Macy's executives ensued, as the Bureau pressed the company to redress the alleged inaccuracy in its core advertising message. But Macy's management rejected any suggestion that its ads were fundamentally inaccurate, characterizing the Bureau's demands as intrusive attempts to dictate marketing policies. The dispute between Macy's and the New York City BBB closely paralleled a key point of contention between the Post Office and Sears Roebuck in the mid-1890s: how to interpret the significance of unfilled or wrongly filled orders. Sears had emphasized that his firm's enormous volume of business and large number of employees rendered some mistakes inevitable, and that the company had created an internal mechanism for identifying and correcting errors. Percy Strauss, Macy's vice president, took a similar tack in responding to the BBB's allegations about his firm's ad copy. His department store, Strauss pointed out, sold thousands of items, with prices for many changing regularly. In order to adhere to Macy's policy of selling below its competitors, the establishment maintained an internal comparison bureau, which sent out employees to other retailers to survey prices. Macy's also encouraged customers to bring lower prices to its attention and charged its hundreds of sales clerks with reporting prices conflicting with our policy. Whenever Macy's management became aware of a price differential, Strauss insisted, they adjusted the store's prices downward. But in light of the enormous range of its offerings and the size of its workforce, some mistakes and oversights were inevitable. In many cases, moreover, thorny questions arose over whether particular goods were really directly comparable or equivalent, which required time-consuming technical analysis and internal debate. Strauss further explained that in all instances of ambiguity, Macy's erred toward giving to our customers the benefit of the doubt. Macy's and the New York BBB possessed very different understandings about what counted as an advertising inaccuracy, and who should have the authority to apply that standard and fashion remedies for violations. The department store's executives did not object to the BBB's shopping checks. Indeed, they welcomed them and promised to adjust prices whenever the Bureau pointed out discrepancies. They also readily adjusted the wording of their advertising copy, including an explicit concession adopted in early 1926 that "we are not infallible. Others may on occasion cut our price, may on occasion sell merchandise for one reason or another at prices lower than we until we find it out." But they refused to give ground on their central marketing claim that they systematically offered the lowest prices in New York, and so were the store of the thrifty, of those who pay as they go. To concede this point, Percy Strauss insisted, would amount to tacit approval of the BBB's extending its jurisdiction far beyond the mission of combating fraud. The result of such a concession would be all manner of dangerous meddling in the delicate and difficult process of competition in business. Rather than accept this diktat, Macy's resigned its membership in the New York City Bureau. The controversy over Macy's pricing policy simmered for several more years. BBB officials wished to demonstrate their willingness to stand up to a large corporation. They were fortified in that impulse by the encouragement of several Macy's competitors, such as Gimbel's and Wanamaker's, which viewed their rivals' claims of perennial underselling as misleading. For several years after Macy's resignation, BBB leaders looked upon the department store with suspicion. In the late fall of 1930, for example, the head of the Detroit BBB confidentially reported rumors that Macy's was bankrolling the activities of Logan Billingsley's Manhattan Board of Commerce, which had included attempts to place anti-BBB billboard ads in Detroit. At the national level, the BBB network forged standards for advertising copy that frowned on the use of universal claims of underselling, such as those pushed by R.H. Macy and Company. In its 1932 Guide for Retail Store Advertising, the affiliated BBBs described such assertions as impossible of fulfillment because no advertiser could have complete and accurate knowledge of all prices in all other stores by all merchants at all times. Nonetheless, Bureau officials felt compelled to handle its scrap with Macy's in a much less confrontational fashion than its response to the organizations and individuals who criticized its operations most vehemently. Percy Strauss was no George Graham Rice. The Macy's vice president was a well-respected member of the nation's business elite who managed an iconic retail establishment, not a shifty promoter with a criminal record and a history of running businesses that, at best, pressed the bounds of propriety and honest marketing. In January 1926, at the height of the dispute over the 6% claims, the New York City BBB offered to send the Macy's advertising case to an ad hoc review panel, appointed by the president of one of three organizations, the Merchants Association of New York, the New York State Chamber of Commerce, or the Bar Association of the City of New York. This approach, the BBB head Bayard Dominick suggested, would permit the fullest possible determination of all the facts as to whether Macy's advertising slogans are accurate as applied to your business, or whether they are misleading to the public and unfair to your competitors. Dominick's proposal conceded that the Bureau's mode of enforcement was open to the same kind of objections so often lobbed at fraud order proceedings before the 1913 postal reforms, that the BBB vested the role of investigator, prosecutor, and judge in the same institution, and sometimes the same person. Macy's declined to participate in arbitration relating to its advertising strategy, but the idea of instituting some type of appeal process to an impartial body remained alive within BBB circles. As the public attacks on its methods intensified amid the early years of the Great Depression, procedural reform of this sort became more attractive. An additional prod in this direction came from the increasing integration of the BBB network into the formal policymaking and enforcement activities of the federal government. During the late 1920s, the Federal Trade Commission had called upon the national BBB and the affiliated BBBs to coordinate trade practice conferences to set standards in several industries, including one on national periodical advertising. This initiative culminated in the 1933 adoption of a Code of Advertising Practices, which largely tracked the 1932 Guide to Retail Advertising. To fortify its case for the adoption of such codes, and perhaps to make them more palatable to its large corporate funders, the National BBB proposed the creation of a review committee on fair business practices in 1931, comprising representatives of advertisers, the advertising industry, and media. This board would furnish an appeal tribunal to advertisers who disagreed with NBBB findings. Although its jurisdiction would be informal, akin to voluntary arbitration, its procedures would mimic many legal conventions. After advertisers requested a hearing, the NBBB would furnish it with a brief designating the alleged practices and setting forth the reasons why the practices are considered by the Bureau to be unfair to competition or detrimental to the public interest in advertising. The appellant would next file a written answer within 15 days, and the NBBB would set a date for a hearing. Although that proceeding would be conducted in an informal manner, the board would have the power to confine discussion to the precise dispute at issue. Both sides would have the opportunity to introduce expert testimony, and each party could ask legal counsel to present arguments. Edward Green, the NBBB's general manager, depicted this setup as a sound application of quasi-judicial opinion applied to business conduct. In combination with the surveillance and moral suasion furnished by the national BBB, Green contended, The new tribunal would provide a broad and equitable system of self-regulation by business. With the incoming Roosevelt administration in view, Green found sufficient support from the publishing, broadcast, and advertising industries to begin preparations for a review board in late 1932. Over the next several months, the NBBB persuaded trade associations representing these industries to appoint members to the board, and announced in late spring of 1933 that it would soon begin operations. This initiative quickly faded from public view, however, displaced by the chaotic activity of the National Recovery Administration, NRA. As part of the New Deal economic recovery strategy, the NRA asked industries, including advertising, to adopt and then enforce fair business practices. The codes that emerged for retail advertising followed the script laid down by the NBBB's work from the late 1920s and early 1930s. Throughout the country, moreover, the new federal agency turned to the BBB network for assistance in enforcement, borrowing several BBB officials to help run metropolitan compliance divisions and drawing on a number of local BBBs to undertake the work of code monitoring and enforcement. Now, instead of the planned Advertising Review Committee, firms who chafed at a BBB interpretation or decision could gain a formal hearing before an NRA code administrator. Unlike the Post Office Department then, the early 20th century BBB network did not actually implement extensive procedural protections for its mode of handling instances of marketing deceptions. As we will hear, the truncated history of the Advertising Review Committee foreshadowed institutional evolution after World War II by both the national BBB and many of its local bureaus. On its own terms, the episode from the early 1930s still suggests the influence that common law procedural norms had on anti-fraud initiatives. From the inception of the Truth in Advertising movement, bureaus had stressed the advantages of informal investigations and negotiations taking place outside of the public spotlight, so long as firms demonstrated a willingness to defer to their assessments of fair dealing. But in the face of sustained criticism about secret methods and unaccountable arrogation of power, and wishing to bring along heavy corporate advertisers whose executives and legal counsel wished to maintain freedom of commercial action, BBB leaders looked to defuse criticism through procedural adjustments. Their proposals reflected long-standing ideals about the rule of law: notice, specification of charges, the chance to present and rebut evidence, the opportunity to rely on legal counsel, and judgment by individuals who did not participate directly in the initial investigations. Edward Green stressed that any hearings by the Advertising Review Committee would be conducted in an informal manner, and that the rules governing its operation were indeed much more informal than a court proceeding. Even within the realm of business self-regulation, however, American legal culture left its stamp on institutions. The New York Times did not miss the legal implications of the Advertising Review Panel. Its headline for the story, reporting on its adoption, informed readers that the advertising field was about to get a high court, though this august body would function entirely outside the ambit of the state. Early fraud fighting at the FTC. As Federal Trade Commission officials began to combat deception in interstate trade during the mid-1910s, they skirted the political assaults that the Post Office Department had endured and that critics would later direct toward the BBBs. They did so in part by paying attention to issues of procedural fairness from the start, adopting rules that insulated the Commission from charges that it operated like Russian secret police. Unlike the Post Office, which could bar access to the mails and initiate criminal fraud prosecutions, the FTC's arsenal consisted mainly of cease-and-desist orders, which directed firms or individuals to stop specified practices. Officials at the Commission, moreover, could only issue such orders after a lengthy administrative process that incorporated several features of common law adjudication. After receiving an initial complaint about a business, usually from a competitor, or encountering evidence of wrongdoing through direct monitoring of the marketplace, the FTC would assign one of its staff attorneys to conduct a preliminary investigation. Typically involving at least some field interviews, this inquiry resulted in a written report that recommended either closing the case or initiating a formal hearing. A review board of 2 senior FTC attorneys and 1 FTC economist would then consider the recommendation, evaluating whether the firm in question participated in interstate or foreign commerce, whether its activities were sufficiently deceptive to violate the FTC Act, and whether formal administrative proceedings were in the public interest. This last requirement hinged on the applicability of other means of legal redress. If the board viewed the investigation as sufficiently thorough and believed that further FTC action was called for, it would ask the commissioners for authorization to launch a more formal consideration of the allegations. With that authorization, the FTC would send the target of the investigation official notice of an impending hearing to consider charges that it had engaged in unfair methods of competition, including a summary of the allegations against it. Before the hearing, the enterprise would have the opportunity to file a written answer to the charges, laying out the contours of any defense. The hearing would usually be conducted by a trial examiner not involved in any aspect of the investigation to this point, and would give respondents the opportunity to present evidence, cross-examine witnesses, and rebut arguments. After the hearing, the trial examiner prepared findings and a recommendation either for a dismissal or for the issuance of a cease and desist order, to which lawyers for the respondent and the FTC could reply through formal briefs. Finally, the full complement of 5 FTC commissioners would receive the complete record of the case, hold a further hearing for oral argument from the parties, debate its merits, and vote on its disposition. The FTC then gave ample notice of its actions and furnished access to the evidence amassed by investigators. It also took pains to separate the officials who investigated and prosecuted cases from those who ruled on them. FTC proceedings did not offer the full panoply of common law protections available in the regular courts. They allowed a wider range of admissible evidence and limited respondents' opportunity to enter procedural motions available in traditional legal disputes. Inquiries into allegations of unfair competition remained exercises in administrative law. Some legal observers would have preferred an even greater institutional separation between FTC prosecutors and trial examiners, especially in light of the occasional practice of asking prosecuting counsel to prepare formal findings for consideration by the full commission. Nonetheless, early FTC deception cases reflected the Wilson administration's general concern for procedural niceties, evident in its reform of the fraud order process. Indeed, adherence to the formal requirements of exacting procedural rules frequently compromised the FTC's ability to strike quickly at firms engaging in methods of unfair competition. During its first decade, numerous commentators reproached the FTC for its protracted process. The Commission itself noted that many preliminary inquiries entailed long, extensive, and painstaking investigation of the facts. Although subsequent hearings were supposed to take place within 40 days of legal notice, a crowded docket made months-long delays all too common. As a result, the issuance of a cease and desist order often took a full 2 years. And if a firm defied such an order, the FTC had to go to federal court to compel its enforcement, a process that required still more time. Some respondent corporations grumbled that the slow pace of FTC decision-making forced them unfairly to contend with bad publicity before they were exonerated. Delays also meant that some fraudulent enterprises continued operations for months or even years while cases against them wound their way through the FTC bureaucracy. Perhaps the most problematic category of deception cases involved securities frauds. Because of the factual complexities and wide geographic reach of such swindles, the taking of testimony proved especially time-consuming. In the case of Samuel E.J. Cox, a notorious peddler of worthless Texas oil stocks who eventually faced federal prosecution for mail fraud, the FTC took almost 4 years to move from an initial 1919 complaint to the filing of a cease and desist order. As the legal scholar Gerard Henderson observed, "If the facts found by the Commission are true, one is tempted to ask how many gullible citizens were separated from their savings while the case was in progress." The FTC's legal process, then, often led to the shutting of commercial or financial schemes long after swindling schemers had moved on to new locales. When control of the FTC passed over to Republican appointees in 1925, Chairman William Humphrey instituted several policies that sought to redress the FTC's version of the slows. One pair of administrative changes sought to facilitate negotiated agreements between the Commission and investigated businesses, akin to the turn-of-the-century stipulations arranged by the Post Office with firms that possessed good reputations but had flirted with misrepresentation. Under Humphrey's direction, the FTC no longer docketed formal complaints nor publicized cases immediately after initial investigations. Instead, it allowed firms facing allegations to make provisional responses to them in closed, informal hearings. If, after this step, FTC attorneys still felt disciplinary action was appropriate, they tried to dispose of most false advertising cases through negotiated settlements. The most common arrangement required a business's acceptance of a formal stipulation to cease those practices that the FTC lawyers saw as problematic. In such instances, the FTC publicized only the relevant facts, keeping the names of stipulating companies from public view. According to Humphrey, these reforms allowed the FTC to dispense much fairer administrative justice while enabling it to quit playing tag with fraud. Businesses that faced an unjust complaint from some competitor no longer had to deal with negative publicity in the months and years that it took for an action to make its way through administrative process. With stipulations, disposition of deceptive practices cases occurred within months rather than years. The much greater emphasis on negotiated compromises, Humphrey also stressed, moved FTC proceedings closer to the workings of the traditional court system, where most controversies ended with settlements. Such arrangements had the further advantage of freeing up investigators and lawyers to focus on truly fraudulent companies and unscrupulous media firms, against which the FTC chairman vowed not simply firm enforcement, but a war of extermination. In a similar vein, Humphrey greatly expanded the investment of FTC resources in trade practice conferences, which had begun soon after the conclusion of World War I. These meetings of firms in a particular industry identified unfair commercial tactics that had become commonplace and then adopted rules against such practices. Although these statements of industry custom lacked the force of law, their articulation helped to create commercial standards and norms that influenced managerial behavior. Even before the new FTC regime, Gerard Henderson had concluded that the educational influence of a single trade practice submittal is as valuable as the coercion of a host of formal complaints and orders. The agreements that resulted from trade conferences also helped FTC officials with enforcement actions. Industry rules of the road facilitated assessments of whether particular complaints about unfair methods of competition deserved attention. And because those rules reflected the expressed sentiment of the trade, they extended the capacity of FTC lawyers to use moral suasion against firms that had allegedly violated them. The FTC convened dozens of such conferences in the 1920s and 1930s, often in conjunction with the national BBB. A further initiative concentrated on direct monitoring of national print advertising. In 1929, the FTC created a special board of investigation headed by 3 attorneys, which reviewed thousands of sampled ads every week. This new unit operated in much the same fashion as the nation's BBBs. Like the Bureau network, the FTC developed a close working relationship with publishers of national magazines. When an official identified an advertisement that appeared to be deceptive, the FTC would contact the relevant publisher or station manager and request substantiation of marketing claims. If unsatisfied by the reply, officials suggested that the publication or station make adjustments or refuse the ad. If neither action was forthcoming, the FTC could authorize formal investigations of the advertiser as well as the relevant advertising agency and media outlet. This informal mechanism of regulation, the FTC claimed in its 1931 annual report, led advertisers, agencies, and print publications to agree to stipulations 95% of the time. The Commission calculated that over 10,000 false and misleading advertisements have been discontinued as a result of its work. The FTC's regulatory ethos under Chairman Humphrey, then, reflected a strong commitment to both common law proceduralism and the Republican philosophy of business self-rule. Each of these impulses called for a more restrained approach to false advertising and other deception cases, though one still presupposed an active administrative state. This version of associationalism retained the tension between adherence to formal legal process and informal administrative problem-solving. For William Humphrey, the key to resolving this tension lay in a more sympathetic regulatory stance toward legitimate enterprises. The Republican FTC chairman remained confident that his legal staff and fellow commissioners could identify outright swindlers when they saw them, treating them differently from honest businessmen who occasionally engaged in misrepresentation. Humphrey believed, like Postmaster General Cortelyou, that his agency could serve as a trustworthy keeper of the commercial peace. At the same time, he shared the growing concern of many early 20th century observers about vulnerable consumers within industrial economies. The FTC, he proclaimed in 1926, was charged with making it impossible for the frauds and fakers, swindlers and scoundrels, with the help of dishonest, unprincipled, and mercenary publishers who share in the fruits of their crime, to rob the sick and unfortunate, the credulous and the ignorant, of hundreds of millions of dollars annually. Humphrey's procedural innovations found favor within the business community, which appreciated curbs on investigative publicity. But some influential legal thinkers viewed the FTC's turn to informal dispute resolution as an affront to procedural justice. To Henry Ward Beer, a professor at Brooklyn Law School and one of the nation's foremost trade lawyers, Humphrey's FTC had fashioned shortcuts that violated the first principles of legal procedure, as well as the explicit terms of the FTC Act. That statute, Beer insisted, only authorized formal complaints, public hearings, and public rulings. Informal inquiries, secret stipulations, and trade practice conferences had no firm legal basis. They replaced fair-minded judgment with the worst kind of arm-twisting by officialdom, which few firms would resist, regardless of the merits of a given case. As a people, Beer protested, we are not content to have our rights tried by administrative fiat. As a result, he argued, it would be far preferable to have much fake advertising go unpoliced than to have one honest businessman put out of existence through informal mechanisms that masqueraded as a substitute for its legal authority to proceed by complaint and finding of facts. Despite such carping, the FTC adhered far more closely to Anglo-American conceptions of the rule of law than most agencies of the early 20th century federal government, including the pre-1913 Post Office. As with the Post Office Department, however, deference to procedural norms meant a slower pace of formal justice, and so more time for opportunistic marketing strategies that employed deception. The direction of institutional evolution within late 19th and early 20th century anti-fraud organizations underscores the attraction that many American elites had to the philosophy of administrative law articulated by the influential Victorian-era British legal scholar Albert Venn Dicey. For Dicey, the emergence of modern administrative agencies posed a grave threat to Anglo-American conceptions of liberty because they so often took away the right to gain a review of state action by a member of the regular judiciary under the rules and interpretive practices of the common law. As Dicey put the argument in his widely read lectures on the British legal system, the rule of law required that when a regulatory agency took some action that harmed private interests, it acted on the basis of a distinct breach of law established in the ordinary legal manner, with recourse in all cases to the ordinary courts of the land. In the first half of the 20th century, Dicey's views found favor among a segment of America's legal establishment that saw the emerging administrative state as a threat to the rule of law. Many American legal thinkers, among them University of Chicago law professor Ernst Freund, embraced a conservative, substantive version of Diceyism. Freund insisted that U.S. constitutional values required far-reaching checks on administrative discretion, including the ability to appeal all administrative decisions in federal court. He wished to establish an American Rechtsstaat, in which administrators applied clearly articulated, legislatively enacted rules and remained subordinate to the judiciary. This vision appealed to middle-class urbanites who associated public policy with the corruptions of boss-run political machines, as well as to prominent members of the bench and bar who equated liberty with legal rituals and process. An alternative position was staked out by a group of eminent legal figures, most of whom were based in either America's financial capital, New York, or its seat of politics, Washington, D.C. This group included corporation lawyer, Republican Governor of New York, and Supreme Court Justice Charles Evans Hughes, Henry Stimson, the Republican who served as Presidents Taft and Roosevelt's Secretary of War and Hoover's Secretary of State, John Foster Dulles, a leading business lawyer and eventual Republican Secretary of State, and, perhaps most importantly, Felix Frankfurter, Harvard law professor, policy counselor, and Roosevelt appointee to the Supreme Court. These attorneys recognized the implausibility of asking courts to review the nitty-gritty of administrative fact-finding, and so viewed flexible administrative decision-making as indispensable to the resolution of economic controversies within an industrialized society. But they sought to infuse regulatory agencies with respect for due process and called for members of the legal profession to become watchdogs of the administrative state, ready to cry foul when discretion transmuted into unprincipled, unfair arbitrariness. These ideas would become fundamental premises of American regulatory design, enshrined in the 1946 Administrative Procedure Act and the analogous legislation later passed by most state legislatures. Earlier experimentation with anti-fraud measures, however, demonstrates the long-standing gravitational pull of procedural reforms. To ignore them in the construction of regulatory organizations was to court antagonism from affected entrepreneurs and public censure from conservative lawyers and politicians. By contrast, grafting elements of regular court procedures into regulatory operations enabled agencies to fend off critics. Provision of notice and specific charges, formal hearings, separation of investigation, prosecution, and judgment, opportunity to appeal. These policies cemented the legitimacy of administrative anti-fraud adjudication within state agencies and quasi-public institutions such as the BBBs. In fits and starts, from the 1870s into the 1930s, anti-fraud regulators blunted political critiques by embracing procedural protections. This pattern did not emerge at the behest of a judiciary jealously guarding its prerogatives, for the courts deferred to administrative muscle-flexing against deceptive business practices. Instead, the demands came from a motley crew of journalists, iconoclastic social commentators, and the targets of fraud investigations, all of whom usually drew on a popular legal culture that distrusted governmental power. Specters of star chambers and secret police connected the critique of anti-fraud regulation to the nation's revolutionary past, updated to distinguish American liberty from the dictatorial dispositions of Eastern Europe and Asia. Eventually, opponents of administrative anti-fraud techniques fashioned a more professionalized discourse that reflected the norms of elite legal education and the emergence of specialized legal practices. Those opponents received support from many large-scale businesses, which embarked on a concerted effort to slow down the ever more wide-ranging American regulatory juggernaut, and to compel less ambiguous directions from regulatory agencies. The disputes over basic procedural questions in American fraud law has important implications for historical understandings of the rule of law, that complex, evolving, and ambiguous cluster of ideas and attitudes about justice that has helped to shape legal institutions in numerous societies over the past several hundred years, from Great Britain and its far-flung colonial possessions to the continental powers of Western Europe, to late imperial and republican China, to the United States. Modern conceptions of governance enshrined such values as clarity and effective dissemination of rules, impartiality in official judgments, provision of appeal, and universal application of law regardless of social position. As the evolution of American anti-fraud institutions suggests, these norms were hardly shibboleths. They connected elite debates over bureaucratic design to more popular conceptions of law and justice, and appeals to these values often carried weight in the construction and refining of institutions, public and private. But their precise implications remained the subject of intense political jockeying amid the efforts to adjust institutions to the challenges of industrialization and the emergence of integrated national economies. To think about rule of law historically, then, one must do more than define its key elements and how they changed over time. One must also locate the sources of ideas and sensibilities, whether within the circles of legal elites or among social groups, or in the ambit of a more diffuse popular legal culture. One must further identify when established rule of law tenets receded in the face of competing political and legal priorities, or once again came to the fore, often with new twists or points of emphasis. And one must assess the social and economic consequences resulting from fidelity to these norms. Greater procedural protections within anti-fraud organizations slowed up their legal machinery. This shift hardly took away the ability of the Post Office, the FTC, or the BBBs to arrange stipulations with firms under investigation. Indeed, each of these organizations became a savvier practitioner of informal regulation, more appreciative of how industry-wide deliberations over fair practices and judicious settlements could attain regulatory goals with targeted use of scarce institutional resources. But the emergence of slower and more expensive formal procedures furnished businesses that relied on deception with more room to maneuver. Unscrupulous enterprises enjoyed more time before they felt enough pressure to close up shop and move, or before authorities were able to shut them down. In evaluating behavior on the margin between puffery and misrepresentation, public institutions such as the FTC may have shied away from confrontation with deep-pocketed corporations or settled for easier terms, because the alternative would likely involve protracted legal proceedings with uncertain outcomes. Concerned about the social costs of business fraud, late 19th and early 20th century American policymakers experimented with the techniques of modern administrative regulation. They did so in some cases with the hope of burnishing professional credentials, but in all instances with the expectation of bypassing the frustrations associated with attacking deceit through the regular courts. Although several decades of legal counterattacks did not fully remold anti-fraud regulation according to common law precepts, the critiques did encourage regulatory officials to take procedural fairness far more seriously. With the resulting institutional adjustments came heightened protections for the civil liberties of entrepreneurs and companies, greater authority for business lawyers, and more court-like rituals within administrative adjudication, but also a sometimes less aggressive enforcement posture and more regulatory disappointments akin to those that characterized Barnum's America. Part 4. The Call for Investor and Consumer Protection, 1930s to 1970s. Chapter 9. Moving Toward Caveat Venditor. Shortly after Franklin Delano Roosevelt's inauguration in March 1933, he sent a special message to Congress that called for federal regulation of the securities markets. Taking note of the severe losses that investors had incurred through practices neither ethical nor honest on the part of many persons and corporations selling securities, the new president asked for legislation that would require comprehensive disclosures by marketers of stocks and bonds. The enormity of the Great Depression, he argued, demanded new standards for communication by public corporations, investment bankers, and other players in financial markets. In order to restore public confidence in mechanisms of capital allocation, Congress had to place the burden of telling the whole truth on the seller. Without oversight that ensured candor by the vendors of investments, Roosevelt proclaimed, stock exchanges and the bond markets would remain moribund as shell-shocked investors shunned public securities. Roosevelt's plea represented a turning point in the policing of business fraud in the United States. After some wrangling over details, Congress acceded to his request, creating a powerful agency to supervise America's capital markets, the Securities and Exchange Commission, SEC. Along with the 1938 Wheeler-Lee Act, which extended the FTC's jurisdiction over duplicitous marketing, the creation of the SEC vastly expanded federal responsibility for regulating the truthfulness of economic speech. During the New Deal, the nation's elected officials pledged to redress informational asymmetries within America's industrialized continental economy. They chose to act through robust bureaucracies that would monitor national marketplaces and combat deceptive business practices. These developments ushered in a half-century of intensive public action to constrain economic duplicity. Congress, state houses, and city councils passed legislation that attacked such deceit, both in general and with respect to specific markets such as retail trade, franchising, and consumer credit. From the late 1950s through the 1970s, states and municipalities also launched new agencies charged with combating business fraud. One must be careful not to overstate the degree of change associated with post-New Deal anti-deception regulation. Legislators and other policymakers had many earlier experiments upon which to build, and the fraud-fighting endeavors of the mid-20th century retained key features of those precursors. The waxing insistence that sellers face stricter standards at no point meant forsaking the assumption that economic actors had to be able to fend for themselves. Roosevelt explained that his call for tighter securities regulation did not absolve buyers from the duty to keep a sharp lookout. Rather, the proposal adds to the ancient rule of caveat emptor, let the buyer beware. The further doctrine, let the seller also beware, caveat venditor. The crafting and implementation of New Deal securities legislation adhered to this formulation. Indeed, almost all of the anti-fraud policies enacted by American legislatures and regulatory agencies between 1933 and the 1970s were premised on due diligence by economic actors. Those policies also reflected abiding anxieties about extending too much power to administrative bureaucracies, whether through overgenerous budgetary allocations or the granting of undue discretionary authority. As a result, even at the height of the more expansive mid-20th century American state, non-governmental and self-regulatory organizations continued to play key roles in the anti-fraud regulatory environment. The Roosevelt administration's embrace of caveat venditor nonetheless signaled a shift in political discourse and policy. For the following 4 decades, American legislators and regulators from both political parties gave less credence to assertions of economic freedom and worried more about preserving popular confidence in markets or treating economic actors fairly. They also framed anti-fraud policies in terms of consumer and investor protection. Indeed, only with the New Deal did those phrases come into common currency. The next 3 chapters survey American fraud policing from the New Deal through the 1970s. This chapter considers anti-fraud efforts into the early 1960s, focusing on federal regulation of the financial markets and retail marketing, as well as related undertakings by Better Business Bureaus. Chapters 10 and 11 grapple with the impact of consumerism on anti-fraud regulation from the late 1950s through the late 1970s. Together, these 3 chapters document wide-ranging attacks on commercial deception through legislative statutes, administrative rulemaking, and in some contexts, judicial interpretation. They also chart the bipartisan construction of a much denser and more integrated network of anti-fraud institutions, both public and outside the state. Despite enduring constraints on the reach and effectiveness of anti-fraud regulation, all of this activity circumscribed the scale, scope, and impact of marketplace deceptions. Institutional designs and intellectual foundations. New Deal anti-fraud regulation was born out of anxieties about the securities markets, which focused on decades-long patterns of self-dealing, manipulation, and misrepresentation, given new intensity by the post-World War I boom and subsequent stock market crash. During the dramatic run-up in stock prices from 1920 to 1929, Wall Street depended on a wider base of shareholders. Having become accustomed to investment through the World War I Liberty Bond campaign and bombarded by the hard-sell techniques of fast-growing brokerages such as Merrill Lynch, several million middle-class Americans joined the investing class. These newcomers purchased not just the securities of established sectors such as banking, insurance, transportation, and mining, but also shares in manufacturing, retail firms, and investment trusts, as well as foreign bonds. The mix of strong demand, unsophisticated purchasers, and weak regulatory constraints generated powerful incentives for deceit. As Chapter 5 demonstrated, mail fraud enforcement had targeted stock and bond swindlers since the late 1870s, and interstate investment fraud became a more substantial priority for the Post Office Department in the 1910s and 1920s, resulting in scores of prosecutions and convictions. During World War I, the Treasury Department's Capital Issues Committee received the authority to scrutinize proposed initial public offerings and to disallow the marketing of any issues deemed to be inconsistent with the war effort. Far more substantial regulatory legislation occurred at the state level, with the outpouring of blue sky laws. Rather than truly discriminating filters, however, state regulatory schemes proved to be at once porous and overly restrictive. The former problem resulted from legislative exemptions, either for sectors such as utilities and banking or for companies with listed securities. The Investment Bankers of America, IBA, founded in 1913 to fend off the threat posed by blue sky laws, worked hard to establish safe harbors for stocks and bonds sold on exchanges. Woeful bureaucratic limitations further hampered state regulation. Legislative appropriations often allowed only cursory enforcement, and even the best-funded agencies did not constrain the tip sheets and telephone boiler rooms that drove interstate sales. At the same time, promoters inveighed against blue sky licensing requirements. To these apostles of enterprise, the new rules created legal shackles that only reinforced the power of established stock exchanges and investment banks, while placing a straitjacket on industrial development. Even New York's far-reaching attempts to curb securities fraud through the 1921 Martin Act and the creation of a dedicated Bureau for the Prevention of Fraudulent Securities, BPFS, faced important limits. From 1925 onward, it distributed compulsory questionnaires to promoters and stock brokerages, so that it might learn about questionable practices even without specific complaints from investors. BPFS attorneys initiated thousands of fraud investigations during the 1920s and 1930s, pursued hundreds of injunctive proceedings to force firms out of business, and brought scores of criminal prosecutions. Its success rate in the courts, moreover, represented a distinctive break from the hapless record of 19th-century state anti-fraud enforcement actions. As with requests for mail fraud orders, most BPFS motions for injunctions and the appointment of receiverships went uncontested. The Bureau usually prevailed when promoters or brokerages opposed it in court, and its criminal fraud prosecutions, while far less common than injunctive proceedings, typically resulted in convictions. BPFS could and did point to successful enforcement actions against large-scale investment frauds. Attorneys general and their deputies took every opportunity to crow about their fearless takedowns of the New York's Consolidated Stock Exchange during the mid-1920s, George Graham Rice's promotion of the Idaho copper mine, Charles Bob's looting of a mining investment trust, and many other financial frauds. Officials also stressed that the Bureau's impact extended beyond putting investment swindlers out of business or in jail, because initial inquiries from staff attorneys often convinced securities firms to reform their marketing practices. Despite official breastbeating, contemporaries questioned how much enforcement of the Martin Act curbed the hawking of fraudulent investments. There were too many dodgy promoters for a few dozen investigators, attorneys, and clerks to track down, leading to laments from attorneys general about stingy appropriations and an impossible workload. Too often, critics such as the progressive lawyer Samuel Untermeyer argued that enforcement under the Martin Act would merely lock the stable door on these promotion frauds after the stock had been distributed and the thieves had bolted with their swag. Furthermore, court orders to dissolve fraudulent securities firms, again like mail fraud orders, did not prevent seasoned operators from relaunching scams through new firms. And Martin Act investigations targeted fringe operators, outsiders who dealt in unlisted stocks. Like the investigators of the Better Business Bureaus, the BPFS rarely scrutinized national financial elites. Amid the prosperity unleashed by World War I, as well as a heightened pace of technological diffusion and a rapid expansion of consumer credit, shady practices became endemic in Wall Street. Large public corporations, such as the Insull Utilities holding companies, took advantage of permissive accounting standards to inflate income statements, thereby facilitating the marketing of new securities. Corporate insiders and the managers of stock pools relied on a corrupt press corps to disseminate news favorable to their trades and manipulated prices directly through wash or matched sales, transactions in which they arranged to have Confederates purchase shares to create the appearance of intensifying demand and increasing prices. Floor traders and specialists at the NYSE took advantage of knowledge about pending orders to engage in front-running. As these insiders received large orders that would affect prices, they first placed trades on their own account that would appropriate some of the economic value from those price movements. The investment trusts that sprang up during the 1920s created a culture of secrecy that abetted misrepresentation. Although fund managers claimed to have adopted sophisticated portfolio strategies that minimized risks, they often used investor funds to prop up struggling companies that they controlled, skimmed profits through undisclosed management and underwriting fees, and amplified risks by purchasing securities on margin. Investment banks and stock brokerages indulged in both conflicts of interest and deceptive practices. When underwriting initial public offerings of stock, investment bankers underpriced shares and reserved placements for corporate insiders and other favored clients, including members of the nation's political and legal elite. In marketing the sovereign debt of struggling Latin American countries such as Peru, banking syndicates characterized the securities as low risk, despite internal reports that warned of parlous fiscal situations. Banks and brokerage firms that sold securities to the broad middle class, such as National City, adopted several practices of the boiler room brigade. In addition to training salesmen in high-pressure tactics and implementing commission-based remuneration policies that encouraged stretching of the truth, they trimmed the firm's losses on poorly performing stocks in their portfolios by instructing sales personnel to push those securities on retail customers. On the eve of the Great Depression, New York Attorney General Hamilton Ward conceded that prevailing regulations, including his own state's Martin Act, did little to prevent the most bare-faced securities frauds. "The Martin Act," Ward observed, "is no protection against the common thief who claims to be a broker or salesman and deals in worthless securities. From the petty grafter to the gang of high-pressure salesmen with plenty of money who open a big office, there is a large field in which the remedies provided by the Martin Act help but little." Amid the wreckage strewn about the post-1929 financial landscape, the most ambitious forms of state anti-fraud legislation appeared even more insufficient. Malfeasance in the financial sector attracted public critiques before the New Deal, whether through the tell-all memoirs of stock operators Thomas Lawson, George Graham Rice, and Jesse Livermore, the analyses of academics such as economist William Z. Ripley, or the coverage of muckraking journalists such as John T. Flynn. But only with the Senate Banking Committee's hearings on the securities markets did many Americans learn about the seamier side of the 1920s stock boom. These hearings, which began in the spring of 1932 and picked up momentum after Roosevelt's election and the selection of Ferdinand Pecora as lead counsel, received saturation press coverage. The evidence presented by Pecora demonstrated the questionable ethics and behavior of vaunted firms, including National City Bank and J.P. Morgan. The hearings undercut Wall Street's image, set off a political furor, and laid the groundwork for the Securities Act of 1933 and the Securities and Exchange Act of 1934. This pair of statutes remolded the marketing of securities. Although some Roosevelt administration officials and congressmen wished to create a federal blue sky law, the chief drafters of the legislation, including Harvard law professors Felix Frankfurter and James Landis, viewed state regulatory approaches as failures. Instead of vesting the federal government with the obligation to certify new stock issues as reasonable propositions, Frankfurter and Landis joined two separate strategies of regulatory governance. The first involved bans on insider trading, market manipulations, and deceptions in initial public offerings and the secondary shares market. Here the architects of reform emulated the approach of the Martin Act, as well as state false pretenses laws and the federal mail fraud statute. They presumed that vigorous criminal prosecutions would deter outlawed behavior. The second strategy followed the long-standing logic of British financial regulation, which emphasized transparency in accounting and truthful marketing claims. The New Deal securities laws imposed rigorous disclosures requirements on public corporations, investment banks, and stock brokerages. But American legislators also extended the British approach. Across the Atlantic, the government depended on investors to identify wayward companies and promoters. Congress instead created an administrative regime to oversee provision of financial information, lodged in a new oversight body, the SEC. Before investment banks could sell new securities to investors, they had to register proposed offerings, first with the FTC and, starting in 1934, with the SEC, and then wait 20 days before making sales. Registration documents had to furnish information about past performance, future strategy, and prospects, assets and capital structure, and underwriting fees and sales commissions. If questions arose about veracity or completeness, firms could amend statements during the waiting period. If the SEC judged the information to be incomplete or untruthful, it could issue an administrative stop order that blocked offerings. Public companies further had to submit quarterly and annual statements about earnings and financial conditions, audited by independent accountants and consistent with accounting standards approved by the SEC in conjunction with the American Accounting Institute. The legislation furnished exemptions for small-scale stock offerings, closely held companies with fewer than 1,000 shareholders, and corporations with only in-state investors. But it reached most stocks and bonds owned by American investors. 3 later pieces of legislation completed the New Deal architecture of securities regulation, each designed in light of SEC investigations and hearings. The 1938 Maloney Act mandated the creation of quasi-public regulatory organizations to oversee America's hundreds of brokerages, as well as the over-the-counter, OTC, market, which took place through telephone trades based on privately circulated price sheets, and which handled secondary bond transactions, stock purchases by large institutional investors, and trading in shares of unlisted companies. The new quasi-public associations would have authority to license brokers. They would further set training standards and rules of practice, monitor compliance with these rules, hear complaints from customers, and penalize brokers and firms that misled or mistreated investors. The SEC retained supervisory authority over self-regulatory institutions, as well as its own direct powers of rulemaking, monitoring, and enforcement. After the passage of the Maloney Act, the industry settled on a single self-regulatory organization, SRO, to fulfill these roles, with the IBA reconstituting itself to become the National Association of Securities Dealers, NASD. 2 years later, Congress enacted the Investment Companies Act and the Investment Advisors Act, which established regulatory oversight of investment trusts and the new fields of investment counselors and portfolio managers that had emerged after World War I. The first of these 2 statutes prohibited self-dealing in the selling and investment practices of mutual funds. It also barred individuals who had been sanctioned for securities fraud from serving as investment company directors or officers, required investment companies to register with the SEC, and mandated that these corporations provide investors with detailed updates about holdings, financial structure, and strategy. The second statute required advisors to register with the SEC and disqualified individuals who had participated in securities fraud. It further forbade material misrepresentations and mandated disclosure of potential conflicts of interest. On occasion, the SEC extended rules against deceptive practices, as in 1942, when it adopted Rule 10b-5. This regulation clarified the 1933 Securities Act's prohibition of fraud in securities transactions, declaring that it covered purchases as well as sales, omissions of material facts that made claims misleading, and any other kind of deceitful device, scheme, or artifice. For almost 2 decades, Rule 10b-5 remained a minor element of securities regulation, ignored by SEC enforcement staff and securities lawyers. But in 1961, more aggressive officials adopted an interpretive opinion that this rule prohibited stock trading by corporate officers who were taking advantage of non-public information, as well as the provision of such information to others who then traded on it. All of this legislative and administrative action was premised on the use of regulatory power to reshape the business environment. The central goal of disclosure requirements on corporations and investment banks, like the licensing mechanisms for stock brokerages, stock dealers, and investment advisors, was to remake the structure and culture of the financial markets. Toward this end, legislative framers, along with SEC staff, enlisted the help of financial professionals. policymakers concentrated on private gatekeepers such as corporate attorneys, who had the responsibility to oversee compliance with the new requirements, and public accountants, whom the legislation anointed as monitors of corporate financial statements. This strategy of administrative prevention retained punitive features. Failure to abide by disclosure requirements made corporations subject to civil and criminal penalties, as did adoption of deceptive or fraudulent marketing practices. The Securities Acts also gave investors standing to sue for damages if corporations had made false claims or withheld material information, and if investors had suffered losses due to reliance on false or incomplete representations. But their central aim was to construct a new set of norms and practices about communicating truthful financial information. The apex of regulatory power in this system lay with the SEC and its hundreds of government lawyers, economists, and bureaucrats. Nonetheless, its designers remained leery of gumming up the securities market with excessive red tape. As a result, they delegated extensive responsibility for regulatory compliance to the long-established stock exchanges, the newly created NASD, and the legal and accounting professions. As with securities law, post-1933 regulation of duplicitous retailing built on institutional forerunners and involved more robust activity by the national government. The most important federal agency in this policy arena remained the FTC. During the 1910s and 1920s, FTC lawyers had investigated thousands of businesses to determine whether they had violated Section 5 of the FTC Act, which outlawed unfair methods of competition. Its inquiries generated hundreds of cease-and-desist enforcement actions, as well as many more stipulations, written pledges to discontinue objectionable business practices. At no point, however, did the FTC enunciate the marketing transgressions that would trigger investigations. FTC administrative law judges and commissioners rather laid out principles piecemeal in case opinions. Through this common law-like accretion, the pre-New Deal FTC identified clusters of disfavored marketing deceptions. Misleading claims about the quantity, quality, or newness of goods raised the eyebrows of FTC officials, as did false assertions about place of origin, the nature of ingredients or components, and the seller's status within the business community. Other enforcement triggers included unjustified disparagement of competing firms, deceptive claims about prices, such as fake going-out-of-business sales and the touting of big discounts from fictitious high list prices, and phony testimonials. The trade practice conferences of the 1920s and early 1930s, which hammered out voluntary codes of fair competition, applied these broad principles to the specific contexts of individual industries. From the onset of the New Deal through the 1960s, the FTC took a very dim view of these marketing tactics. As its investigators, hearings officers, and commissioners evaluated allegations of commercial misrepresentations, they used a much lower evidentiary standard than that required for criminal fraud allegations. The issue of fraudulent intent did not factor into FTC assessments, at least as they substantiated cease-and-desist proceedings in court, nor did the question of whether purchases had been influenced by deceptive claims. Instead, as the Supreme Court ruled in the 1919 case of Sears Roebuck v. FTC, the Commission only had to find that advertising or other aspects of marketing had a capacity or tendency to injure competitors directly or through deception of purchasers. Later action by the courts and Congress expanded the reach of FTC regulation. Just a few months after President Roosevelt decisively shifted the Supreme Court's political balance through the appointment of Justice Hugo Black, that tribunal further lowered evidentiary requirements in FTC deception proceedings. The pivotal case was FTC v. Standard Education Society, 1937, an appeal from an FTC cease and desist order against an encyclopedia distributor. According to the FTC, the firm's army of door-to-door salesmen falsely claimed that prominent figures had either contributed to or endorsed the encyclopedias. They told prospective purchasers that they wished to give them a set of volumes as a gift in order to gain access to their homes, before explaining that they would also have to pay for a 10-year subscription to monthly supplements. And they mischaracterized the regular purchase price as a steep discount. To argue its case in the federal courts, the Standard Education Society retained Henry Ward Beer, the fervent and longtime critic of expansive FTC administrative action. A federal appeals court vacated several elements of the FTC's order, resting its judgment on the logic of caveat emptor laid out by Beer. We cannot, the lower court argued, take too seriously the suggestion that a man who is buying a set of books and a 10 years extension service will be fatuous enough to be misled by the mere statement that the first are given away and that he is paying only for the second. This opinion echoed the 19th century jurists and editors who marveled at the stupidity of some Americans. On this view, if hopeless rubes insisted on ignoring telltale signs of imposition, courts had no business protecting them. After the FTC took the case to the Supreme Court, Justice Black rejected this contempt for the credulous sucker. The fact that a false statement may be obviously false to those who are trained and experienced, Black reasoned, does not change its character nor take away its power to deceive others less experienced. There is no duty resting upon a citizen to suspect the honesty of those with whom he transacts business. Laws are made to protect the trusting as well as the suspicious. The best element of business has long since decided that honesty should govern competitive enterprises, and that the rule of caveat emptor should not be relied upon to reward fraud and deception. Black's opinion for the court accordingly upheld the FTC order in its entirety. Like the post-1937 federal judiciary, Congress enlarged the FTC's fraud beat. During the 1920s, the Supreme Court had ruled that the FTC only possessed jurisdiction over duplicitous sales practices if it could show that they constituted unfair methods of competition that brought harm to other businesses. The 1938 Wheeler-Lee Act removed this limitation, prohibiting deceptive practices in interstate commerce regardless of losses incurred by other firms, and enhancing the FTC's powers to act against deceptively marketed food, drugs, and cosmetics. Buoyed by these moves by the Supreme Court and Congress, FTC hearing officers and commissioners pushed out the boundaries of illegal deception. From the 1940s through the mid-1960s, they continued to convene trade practice conferences, encouraging firms and trade associations to hammer out sectoral codes of fair competition. In the late 1950s, the Commission conducted economy-wide campaigns against fictitious pricing, bait-and-switch advertising, and deceptive guarantees. After distilling the broad principles that had underpinned cease-and-desist orders in these areas, it disseminated official guides and made them investigative priorities. These endeavors received deferential treatment from the federal courts. Mid-century appellate judges shied away from overturning FTC assessments in deceptive practices cases, even without evidence that customers had been deceived or that anyone had suffered quantifiable monetary harm. Members of the federal bench presumed that FTC experts could be trusted to look out for the careless and least sophisticated readers of advertising, identifying the tricky or ambiguous claims that would trip up easy marks. If those public servants found that descriptions of hair dye as permanent went beyond the legal pale because the dye would not impact new growth, the courts would not upend their judgment. Nor would they overrule FTC findings that a company's buy one get one free promotional campaign was deceptive, on the grounds that the firm had never sold the item at the stipulated price, or its rejection of a television shaving cream advertisement that claimed the product could soften sandpaper because the ad relied on camera tricks and a simulated prop made of plexiglass covered in sand. As the eminent federal judge Learned Hand summed up the FTC's discretion in deception cases, it had the authority to require a form of advertising clear enough so that, in the words of the prophet Isaiah, wayfaring men, though fools, shall not err therein. FTC staff well understood the leeway that they enjoyed. The Commission's 1966 Manual for Attorneys described its mission as protecting the most ignorant and unsuspecting purchaser. This objective required that investigators assess the general impression of ads and promotional materials, but did not hinge on showings of intent and gave investigators flexibility in building cases, because establishing deceptiveness was not amenable to any general or all-purpose rule of investigative procedure. This paternalistic vision represented a stark reversal from the presumptions that defined transactions a century or even a half-century earlier. With America's entry into World War II, the national government refocused anti-fraud policy on military contracting and the regime of consumer price controls. As manufacturers retooled factories to meet the insatiable demand for weapons, munitions, tanks, and planes, reports surfaced of overbilling and other abusive practices. Federal officials responded by scrutinizing the work and billing practices of contractors and subcontractors. The armed services adopted stringent rules about quality control and cost structures, and backed them up with thousands of civilian inspectors and auditors who spent most of their time within factories. Congressional committees held a series of hearings to keep administration officials attentive to the task of keeping contractors honest. This oversight encouraged jawboning over charges and contract renegotiations. Where such informal pressure did not generate satisfactory outcomes, the Defense Department initiated dozens of high-profile prosecutions, which in most cases led to convictions. The crucial arbiter of the wartime retail economy was the Office of Price Administration, OPA, which had the task of enforcing rationing systems and price controls on consumer goods. In Washington, OPA economists and scientists set price ceilings and quality standards for a bewildering variety of consumer goods, and then constructed rationing regulations for crucial items such as gasoline and meat. Across the nation, local OPA officials, many of them former BBB leaders, enlisted hundreds of volunteer advisory groups and tens of thousands of local board members to assist with the formulation and implementation of regulations. A companion army of volunteer price assistants, mostly housewives, monitored compliance with price and quantity controls in retail outlets. Fraud enforcement represented only a minor aim for this gargantuan bureaucracy, which remained focused on tamping down inflation and ensuring the fair distribution of essential goods. But the organization nonetheless spearheaded hundreds of investigations across the country into ration coupon counterfeiting, as well as the fraudulent sale of highly in-demand rebuilt radio sets and used cars, leading to scores of arrests and trials. In the decade and a half after World War II, Congress passed a series of other statutes that targeted specific forms of commercial deceit, including the 1951 Wool Act and Fur Products Labeling Act, the 1958 Textile Fiber Products Identification Act, and the 1958 Automobile Information Disclosure Act. These statutes embraced the central regulatory strategy that animated New Deal securities law: information provision. Each specified several types of truthful information that businesses had to provide to their customers and defined standards for presenting that information. Together, they solidified the federal government's commitment to acting against misleading and fraudulent forms of commercial speech, while also signaling an ongoing preference for enhancing the capacity of individuals to look after themselves. Post-World War II national policymakers exerted analogous efforts to rein in fraudulent educational institutions. Such concern reached back into the 1910s, when Better Business Bureaus, state prosecutors, and federal postal inspectors all began to wage battles against diploma mills. The creation of national higher education grants and guaranteed loans through the GI Bill, however, gave the problem of educational fraud new salience. Now the issue was not just protecting the credulous or safeguarding the value of legitimate degrees and the standing of reputable educational institutions, but also preventing raids on the Treasury. After the 1944 passage of the GI Bill, there were periodic scandals involving fly-by-night vocational schools and more respectable institutions that misled prospective students about instructional quality or graduates' career trajectories. The federal government's primary regulatory response, heralded first in the 1952 Veterans Readjustment Assistance Act, depended on state and regional accrediting agencies. These non-governmental organizations took on the role of certifying that universities, colleges, and proprietary vocational schools furnished bona fide educational programs, and so deserved eligibility for federal loans and grants. As with oversight stock brokerages, which relied on NASD scrutiny, attempts to combat fraud in higher education delegated key regulatory functions to quasi-public entities. Companion anti-fraud efforts occurred outside Washington, D.C., as state and local governments added their own statutes and ordinances targeting consumer fraud. During the 1940s and 1950s, much of this legislative barrage singled out problems in specific economic sectors, such as marketing practices in the insurance industry, which was not subject to federal regulation with the contested exception of advertising in national publications, or licensing and bonding regimes for occupations. The number of states that made instances of false advertising subject to prosecution as a misdemeanor also grew. By 1956, 43 states had enacted such laws, with 31 mandating that prosecutors did not need to establish either knowledge or intent to obtain convictions. In one long-standing arena of anti-deception regulation, mail fraud enforcement, the judiciary did prune federal power. In a pair of cases, the Supreme Court ruled that the post office had to demonstrate fraudulent intent to justify the issuance of fraud orders, and that postal officials had to take greater care in framing the scope of such orders so that they reached only activities shown to be fraudulent. These rulings, however, were premised on concurrent expansion of FTC authority, which gave the federal government an alternative administrative sanction for deceptive marketing practices, the FTC Cease and Desist Order. The Post Office also retained authority to investigate allegations of mail fraud, initiating criminal prosecutions where appropriate. Thus, from the onset of the New Deal into the 1960s, tighter anti-fraud regulation represented a consistent feature of the American political economy. There was no epochal event such as the 1929 stock market crash to serve as a generational touchstone for regulatory moves against duplicitous retail marketing. At no point did the specter of consumer fraud seem daunting enough to crash the entire economy. On occasion, smaller-scale incidents galvanized national concern over the willingness of businesses to shade the truth. In 1958, revelations that the major television networks had scripted popular game shows such as 21 and The $64,000 Question shocked elite commentators and ordinary viewers alike. A few years later, public disclosures that music companies showered DJs with inducements, payola, to play their records on radio programs produced similar reactions. These episodes generated high-profile congressional hearings, sparked some policy shifts, such as a federal law criminalizing payola, and encouraged the FTC to embrace a more aggressive posture toward deceptive business practices. In the absence of scandals, Americans continued to learn about the ongoing problem of consumer and financial fraud from commercial watchdogs. At no point did metropolitan newspapers cease to cover fraud prosecutions. As early as the 1930s, columnists such as the New York Post's Sylvia Porter guided investors through the maze of modern capitalism, including advice on how to avoid financial swindles. The mid-century embrace of long-term investigative reporting produced numerous series on prevailing cheats, such as Jim Forey's 5-part June 1957 expose for the Chicago Defender on sleazy automobile sales practices. Mid-20th century national magazines also emulated their predecessors. Publications as various as Better Homes and Gardens, Reader's Digest, Nation's Business, The Saturday Evening Post, and Changing Times ran compendiums of business scams and recycled general cautions about the telltale signs of fraudulent marketing. A number of these journalists, such as Ralph Lee Smith, Frank Gibney, and Sidney Margolius, reached national audiences through books on frauds and rackets that drew on their careers covering consumer issues. Anti-fraud sentinels in the press continued to have allies in the nation's network of better business bureaus, which became even more entrenched during the post-war decades. The BBBs retained a focus on public education, as indicated by a massive campaign at the end of World War II to warn Americans about a flurry of investment frauds. By the 1950s, though, the BBBs put more effort into combating consumer fraud, a reflection of the deepening institutional framework of securities regulation. As Americans moved to the suburbs, BBBs followed right along, opening up offices in fast-growing new communities. By 1962, there were bureaus in 122 American cities and towns. They distributed a torrent of consumer guides to suburbanites, explaining how to look after their interests when dealing with a landscaping company, ordering television repairs, or purchasing an appliance on credit. In several cities, they produced radio and television segments that highlighted enduring problems of consumer fraud. 3,000 radio and television episodes and 40,000 shorter public service advertisements a year. In Chicago, for example, the long-running radio programs Hello Sucker and It's Your Money ran weekly in the 1950s, warning listeners about frauds in automobile showrooms, among door-to-door salesmen, and through the marketing of franchising opportunities and residential developments. These campaigns rivaled the scale of BBB efforts in the 1920s. National consumer organizations founded during the Great Depression, such as Consumer Research and Consumers Union, also monitored deceptive business practices as part of efforts to educate the parents of baby boomers and other post-war adults about how best to spend. As these organizations evaluated product quality, they remained alert to marketing that pressed at the boundaries of acceptable puffery. Their newsletters and magazines then informed subscribers about products, services, and companies that flattered to deceive. Some of the most insistent post-World War II pleas for combating business fraud came from middle-class women, who took advantage of the growing tendency of economic discourse to feminize the consumer by picturing this abstract individual as a middle-class housewife. Cultural linkage of American household consumption to female decision-making had long-standing origins. The 19th century birth of consumer education was bound up with the invention of home economics, a highly gendered undertaking. Mail-order houses, early department stores, and advertising agencies all directed marketing to potential female purchasers. But the equation of women with consumption decisions became even more common after World War II, as the figure of Mrs. Consumer became a common stand-in for the spending public, addressed in ads, referenced in the business pages, and depicted in anti-fraud literature, such as an early 1950s BBB poster that showed a skeptical housewife deflating the confidence of a door-to-door salesman by invoking the need to check out his firm with the local bureau. Mrs. Consumer took on the gloss of the capitalist economy's true sovereign, the maker or breaker of corporate profitability. Through mounting consumer complaints to businesses, BBBs, and government officials, middle-class women deployed this rhetoric with regard to numerous consumer issues, including deceptive marketing. They organized as well, joining myriad neighborhood organizations that lent popular heft to consumerism. Heightened expectations by consumers and investors encouraged diffuse support for anti-fraud regulation. Ongoing media coverage raised awareness of commercial deception and at least sometimes fostered public outrage over economic injustices. A steady increase in the number, kind, and reach of NGOs dedicated to fighting business fraud broadened the chorus of voices calling for anti-fraud measures, as well as the research base about marketing practices and consumer behavior. These developments swelled popular pressures for government action against commercial deceit and enlarged the stock of ideas about how to execute such regulatory campaigns. But the adoption of anti-fraud regulations between 1945 and the early 1960s rarely reflected vigorous grassroots mobilization. During these years, regulatory action against misrepresentation was pushed by business interests, much as had been the case in 19th-century debates over fertilizer adulteration or the early 20th century campaign against false advertising. Adoption of more stringent labeling regimes for furs and textiles in the 1950s, for example, came at the behest of fur raisers, wool and cotton growers, and upscale manufacturers and retailers. Other than officials from regulatory agencies, representatives from these sectors were the only witnesses who testified before congressional committees considering labeling reforms. These groups alleged that discount sellers were engaging in rampant mislabeling that undercut public confidence in higher quality goods. They also contended that many consumers were duped by such tactics and needed protection that only strong public regulation could provide. Similarly, major record labels instigated the late 1950s payola investigations in the hopes of beating back inroads by independent producers. The latter had turned to payola as one way to introduce R&B, rock music, and African American artists to a wider public, focusing on new local radio stations that coveted young listeners. Even though the established music distributors also furnished DJs with gifts and favors, they calculated correctly that investigations into the industry's endemic bribery and kickbacks would hamstring independents, such as BMI and Ace Records. Advocacy for post-war anti-fraud regulation, however, did not always equate to regulatory capture, in which corporate puppeteers lay behind more stringent regulatory action, pulling the strings of public officials in order to fend off competitive threats. With some initiatives, such as moves against bait advertising and misleading pricing practices, anti-fraud professionals within the business establishment, BBB careerists, aided by counterparts at national advertising trade associations, stood out as the key figures driving regulatory agendas. From the 1930s onward, local BBBs and the national BBB identified such marketing practices as deserving of priority attention. During hundreds of trade practice conferences, BBB leaders hammered out detailed specifications about what constituted bait-and-switch tactics, false comparisons with competing retailers, and fake assertions about sale discounts. By the early 1950s, the bureaus had developed comprehensive standards in these areas, whether for consumer goods such as vacuum cleaners and automobiles, or for services provided by home improvement companies and insurance companies. These codes served as templates for the FTC's regulatory rulemaking and enforcement priorities, which targeted bait advertising in late 1958, deceptive pricing in 1959, and deceptive advertising of guarantees in 1960. Post-war BBB officials, moreover, articulated an expansive anti-fraud philosophy that reflected an institutional mission distinct from that of their corporate funders. C.W. Dessert, a trade practice consultant specializing in the regulation of car marketing, articulated this stance in a sharply worded 1957 letter to a Texas auto dealer who had opposed more stringent anti-fraud rules for the industry. As a dedicated automobile man and as a Better Business Bureau trade practice consultant, Dessert explained to the dealer, we admit to a kind of bias, for we are biased against the petty thief who filches pennies from a blind man's cup. We are biased against the shopper who lies about what the other dealer allowed him for his old heap, and the merchant whose business ethics and law is that of the shady business jungle, and whose theme song is caveat emptor, let the buyer beware. We are most decidedly biased against the merchant in any line, including automobiles, whose technique is to trade upon and exploit human ignorance and credulity, and who, as an automobile medicine man, pitches his snake oil by mass advertising to today's Mortimer Snurds instead of to the yokels from the tailgate of a horse-drawn wagon, as in the earlier days. For Dessert, sharp practices in retailing had no place in modern America. This mindset percolated throughout the national network of long-serving BBB professionals. The voices raised up against American business fraud during the Great Depression, World War II, and the immediate post-war period then reflected important continuity. As was the case during the Progressive era, some business interests continued to see deceptive sales cultures either as a short-term competitive threat or a longer-term menace to consumer confidence. And a cadre of anti-fraud professionals often took the lead in formulating legal reforms and setting enforcement priorities. Indeed, Presidents Truman and Eisenhower refrained from the full-throated critique of caveat emptor that had framed New Deal securities regulation. To be sure, Harry Truman treated consumer welfare and the equitable distribution of America's economic bounty as policy lodestars for his Fair Deal. These broad goals shaped his thinking about using fiscal policy to tame the business cycle and extending prosperity to a wider circle of Americans through national health insurance, expansion of Social Security, stronger protections for labor unions, federal aid for education and housing, stricter antitrust enforcement, and civil rights legislation. But at no point did Truman make consumer protection a centerpiece of his domestic agenda. While in office, Dwight Eisenhower signaled a concern that American businesses faced too much heavy-handed governmental oversight. The great economic strength of our democracy, he proclaimed in his first message to Congress, has developed in an atmosphere of freedom. The character of our people resists artificial and arbitrary controls of any kind. This philosophy guided Eisenhower's legislative priorities and appointments to regulatory agencies such as the SEC and FTC. Thus it should come as little surprise that the pace of major federal anti-fraud initiatives slowed in the decade and a half after World War II, or that anti-fraud legislation adopted by Congress in this time period, such as the Textile Fiber Identification Act, came at the behest of business interests. Toward the end of Eisenhower's time in office, however, the television quiz show and payola scandals elicited a few presidential echoes of FDR's rhetorical shots against unscrupulous stock promoters. Ike denounced the quiz show frauds as a terrible thing to do to the American public, and described payola as an affront to public morality. In both cases he called for investigations and prevention of reoccurrences, which nudged Congress to pass legislation criminalizing fakery over the airwaves. These responses presaged more sustained presidential engagement with deceitful marketing and business fraud as national problems. Challenges of enforcement. New Deal and post-World War II anti-fraud statutes, of course, did not immediately transform legal culture and day-to-day economic relations any more than the formal legal reforms of the previous century. Policy innovations do not magically elicit adequate enforcement. Once again, we need to consider law in action, the meanings of all the new statutory requirements and administrative rules to aggrieved consumers, embattled firms, and consumer watchdogs, the legal system's mediation of fraud-related disputes, and the impact of new legal norms on the beliefs and values that influence economic behavior. With the pivot toward the legal principle of caveat venditor, American policymakers filled in the latticework of a modern anti-fraud state. By 1960, thousands of individuals worked for anti-fraud institutions, deepening organizational capacity, constructing enforcement networks across jurisdictions and agencies, and encouraging professionalization of anti-fraud regulators. In some arenas, such as securities regulation, these endeavors achieved significant improvements in the trustworthiness of commercial speech. Wrestling with the flim-flam man, however, continued to require constant monitoring, patient investigation, shrewd deployment of resources, and unwavering vigilance. And the wrestlers did not always live up to these exacting requirements. Mid-20th century anti-fraud enforcement efforts confronted numerous obstacles that had deep historical roots. Echoes of long-standing popular attitudes toward hucksterism represented one complication. Despite the shifts away from the premises of caveat emptor in American law, many corners of society retained contempt for the sucker and grudging admiration for those who took advantage of them. Post-World War II overviews of prevalent consumer and investor scams often marveled at the wondrous gullibility of those suckers who bit on the truly preposterous, incredible, astonishing, fantastic swindles lurking about the American marketplace. Accounts of specific fraud scandals, such as the 1948 implosion of Arthur Netzer's Ponzi-like car deposit scheme in southern Illinois, or the 1961 collapse of David Farrell's guaranteed trust deed investments in Southern California, elicited analogous amazement at just how eager and naive investors and consumers could be. American linguistic practices also still communicated a disfavored status for those taken in by bait-and-switch advertising or investment scams. Even when seeking to warn consumers and investors about the need for skeptical appraisal of puffery, mid-20th century commentators tagged those who lacked such habits with unflattering monikers. One list included Come On, Fly Flat, John, Juggins, or Pigeon. Another Apple, Bates, Boob, Chump, Clown, Easy Mark, Addlecove, Addict, Egg, Fink, Lily, Mooch, Mug, Pushover, Top, and Sweet Pea. Such turns of phrase did not imply abiding concern or respect. The picaresque confidence man also continued to receive frequent billing in popular culture. W.C. Fields's 1939 film You Can't Cheat an Honest Man became a mainstay of post-war television, repeating the message that those preyed on by financial bilkers had only their own greed to blame. It was joined by such hits as A Day at the Races, 1937, The Rainmaker, 1955, and The Music Man, 1962. These productions offered sympathetic characterizations of grifters who relied on their wits to navigate unforgiving worlds. As one writer observed about the ongoing cultural status of the confidence man, he remained an eccentric, a source of anecdote, a joke quickly told. Even within the consumer movement, more conservative spokespersons such as Frederick Schlink of Consumers Research opposed stringent anti-fraud regulation, repeating the argument that it was impossible to hornswoggle an honest man, and worrying that regulatory paternalism would render consumers unthinking wards of the state. These undercurrents of mockery toward fraud victims and approbation for tricksters were not as powerful as in the 19th or early 20th century. Most post-World War II discussions of swindles and commercial impositions stressed the psychological vulnerability of consumers and investors to well-constructed deceptions. A 1960 article in Changing Times, a personal finance magazine aligned with moderate republicanism, conveys this common interpretive stance. The author of this catalog of prevalent swindles and marketing trickery declared that no one is safe from commercial and financial fakery, that anybody can be a victim, that fraud operators can strike anywhere and anyone. By the same token, perpetrators of business frauds received scorn as heartless criminals. Still, wonderment at the credulity of American consumers and investors remained a feature of public discourse and private attitudes, as did some ambivalence about the golden fleecers who so artfully separated them from their savings. Such sentiments could hinder anti-fraud prosecutions. Amid lingering norms that harkened back to the age of caveat emptor, the psychology of embarrassment or denial still led many shorn Americans to keep quiet. According to Nathaniel Goldstein, New York Attorney General in the mid-1950s, the vast majority of defrauded investors fell into this category, letting pride keep them from filing complaints against the sharpers. Even when victims were not dissuaded from making public complaints, there might be considerable delay between the moment of deception and its recognition by the consumer or investor, complicating any investigation. As in previous eras, the tiny stakes of many scams constituted a further barrier to action. Because many consumer frauds filched only small sums from individual purchasers, most victims did not chase after satisfaction. In both financial and consumer fraud cases, moreover, key actors in the American justice system viewed allegations of marketplace deceptions with jaundiced eyes. Outside the ranks of specialized anti-fraud agencies and divisions, the legal fraternity often retained personal standards that hewed closely to those of W.C. Fields or even P.T. Barnum. In the decades before the emergence of public interest law firms and a plaintiff's bar that specialized in class action suits, American attorneys were more accustomed to the perspective of business interests than that of consumers or investors, and so tended to sympathize with that viewpoint. Thus, if disgruntled consumers or investors sought out legal advice about how to handle some allegedly deceptive transaction, they were likely to be counseled against pursuing criminal complaints. For similar reasons, many mid-20th century prosecutors were disinclined to bring fraud-related charges against businessmen. Moving in the same social and political circles as retailers and real estate developers, and often contemplating returns to private practice, they had incentives to avoid antagonizing future clients. Prosecutors also knew that criminal fraud cases were often hard to win for the same reasons as in earlier periods. The artful dodging of duplicitous businessmen, so vexing to late 19th century postal inspectors and early 20th century BBB managers, continued to trouble anti-fraud enforcers. Pitchmen of mid-20th century get-rich-quick schemes proved no less capable than their predecessors of moving boiler rooms from location to location, or of seeking out friendly jurisdictions from which to operate. Improvements in communications even expanded their geographic options. After the creation of the SEC, Canadian cities became popular bases for peddling penny stocks to American investors over the phone. The wide expanses of the United States also still offered escape routes for the purveyors of consumer frauds, as was made clear by the decades-long predation by a clan of several hundred petty swindlers known as the Travellers or the Terrible Williamsons. This set of related Scottish families maintained a nomadic lifestyle, moving from town to town pitching bogus goods and services, such as the cheapest textiles passed off as fine imports, shoddy driveway resurfacing, or ineffective roof sealing. The Williamsons took care to stop in one location just long enough to bilk the local citizenry out of as many hard-earned dollars as possible before a chorus of complaints raised the alarm with local police. In those unusual circumstances in which members of the Klan stuck around long enough to face arrests and criminal charges, they had little compunction about skipping bail. As a result, post-war BBB's officials and journalists issued repeated public warnings about their exploits. When victims were willing to file complaints and testify in court, and law enforcement officials were able to corral alleged perpetrators, prosecutors still had to weigh the drain on resources that fraud cases often entailed. Although the post-1945 judiciary accommodated anti-fraud reforms that lowered evidentiary burdens in administrative enforcement actions, the legal requirements for criminal fraud convictions remained steep. Just as in the previous century, much investigative legwork was necessary to substantiate fraud prosecutions. Establishing the false claims that underpinned marketing deceptions, as well as reliance on those falsehoods by victims and the fraudulent intent of defendants, often required interviews with far-flung witnesses and, in financial cases, expert accounting analysis. Prosecutors might have needed weeks to present such evidence before grand juries or in court, which meant that fraud cases clogged criminal dockets. The nature of the evidence at issue further gave well-prepared defense counsel opportunities to slow matters down with procedural challenges. These considerations shaped case selection even among prosecutors who made fraud cases a priority. Mid-20th century criminal fraud prosecutions also ran into difficulties with juries and trial judges. The former could struggle to keep track of complex evidence about obscure financial transactions, manifest skepticism about the extent to which defendants had meant to deceive their counterparties, or demonstrate reluctance to stigmatize a man as a criminal because sales pitches had taken a few liberties with the truth. The latter often refused to see fraud charges as meriting the degree of concern shown to instances of violent crime, or went out of their way in jury instructions to emphasize that fraud convictions required a showing of fraudulent intent beyond a reasonable doubt. These stubborn dimensions of the legal system meant that some criminal sanctions against hucksterism went unused. Despite the steady passage of statutes criminalizing false advertising, prosecutions almost never occurred, because prosecutors viewed indictments as disproportionate responses to deceptive marketing. In addition, charismatic businessmen accused of fraud retained their penchant for avoiding criminal penalties, even after business failures that resulted in losses to investors, employees, and creditors. The 1949 to 1950 trials of automobile impresario Preston Tucker suggests how the best defense attorneys had a knack for leading judges and juries to see their clients as sympathetic, if flawed, entrepreneurs. After World War II, the Tucker Corporation developed a new motor car, the Torpedo, in the hopes of cashing in on voracious demand created by rising household incomes and a wartime production ban. This vehicle possessed several technological innovations, but was beset by cost overruns and the gargantuan capital requirements of launching a new automobile firm. To raise cash, Tucker sold hundreds of dealerships to local businessmen and thousands of purchase options to consumers, while regaling potential investors with his company's prospects. After national magazine stories raised questions about corporate financial practices and a series of engineering difficulties, the firm spiraled into bankruptcy. At this juncture, officials at the SEC, Post Office, and FBI became convinced that Tucker was emulating several fraudulent interwar car makers, such as the Pan Motor Company of St. Cloud, Minnesota, which built factories and prototypes as part of elaborate schemes to bilk investors. As a result, they charged Tucker and 7 other corporate officers with mail and securities fraud. 2 high-profile trials led first to a mistrial and then acquittals. In the second trial, the judge instructed jurors about the high legal bar for fraud cases, informing them that they could convict only if they found that the defendants had made false statements and promises out of a purpose and design to cheat. Jurors rejected the prosecutor's argument that a mix of unrealistic projections, aggressive salesmanship, and generous executive compensation met such an exacting standard. Versions of this script recurred through the Cold War decades, as judges and juries declined to follow the lead of prosecutors in fraud cases brought against flamboyant leaders of failed corporations. Even when prosecutors won fraud cases, they often despaired over continuing judicial leniency. Whether fraud convictions came under state false pretense laws, the federal mail fraud statute, or prohibitions against securities fraud, defendants received minimal sentences. More often than not, unsavory characters who had filched large sums received only wrist slaps, probation, suspended sentences, or jail terms of a few months. The disinclination of judges to rap their knuckles a little harder when staring down at individuals convicted of business fraud had ramifications for plea bargaining. Because defense lawyers knew the score, plea deals rarely imposed jail time and often mandated only consent decrees that accepted findings of legal violations without admission of guilt. In earlier decades, frustrations with criminal fraud prosecutions had encouraged innovations such as the postal fraud order and informal pressure on publications to reject advertising from offending firms. These tactics had elicited howls about creeping despotism, prompting adoption of procedural protections, which, in turn, had limited the effectiveness of administrative remedies. Proceduralism became even more deeply ingrained after World War II. Within the criminal courts, the dominant trend, driven by a Supreme Court concerned about civil liberties, was to give defendants greater access to legal representation and to ensure observance of procedural safeguards. Tougher appellate scrutiny of criminal convictions sometimes meant the overturning of fraud convictions on procedural grounds. That possibility expanded the tactics employed by defense attorneys in business fraud cases because trial judges operated in the shadow of the appellate bench. Heightened concern for procedure also cramped administrative enforcement. Here, the legal terrain was reshaped by the 1946 Administrative Procedure Act, which mandated extensive opportunities for public comment as part of the rulemaking process and required that administrative actions mimic criminal process. Parties facing enforcement actions had to receive ample notice of specific allegations. They enjoyed rights to legal representation, access to incriminating evidence, and reasonable accommodation in preparing defenses. They could expect that hearing officers, investigators, and prosecutors would all be separate individuals, and that hearing officers would explain the legal basis of findings to them. Such protections, embraced as well by state administrative procedure acts, extended the time and resources needed to pursue administrative orders against firms accused of deceitful marketing. Given sufficient bureaucratic capacity, the extensions of American commitment to the rule of law need not have presented insuperable enforcement problems. Some anti-fraud agencies, moreover, were able to build sizable organizations. The SEC began the post-World War II era with a budget of $4.6 million, which enabled it to maintain a staff of nearly 1,200, including more than 300 employees in regional offices. But even at the most well-funded agencies, anti-fraud officials often still felt hard-pressed to meet their responsibilities in light of the growing population and economic activity. The SEC's budget did not keep pace with the explosive growth in securities origination and trading in the 15 years after World War II, and budget cuts under Eisenhower forced the Commission to slash its staff by a quarter. Appropriations for the FTC's regulation of anti-deceptive practices did increase at a rate comparable to that of economic growth between 1945 and 1965. But its deceptive practices unit struggled to handle thousands of annual complaints about false advertising and misleading sales techniques. Even more so than in the 1920s, administration action at the post-war FTC became notorious for its languid pace. Investigations often took months or years, and then had to go through secondary reviews by staff attorneys. Consideration of formal cases by hearing officers and then the full commission took even longer, as high-level staff evaluated the analyses and conclusions of investigators, and prevailing rules encouraged continuances. Every few years, an FTC chairman would declare war on internal delays and preside over speed-ups that would reduce bottlenecks. But a dilatory and over-legalistic institutional culture would then reassert itself. Although the courts mostly upheld FTC findings, appeals tacked on more time. In one convoluted case brought against Carter's Little Liver Pills for dubious health claims, the interval between the first investigation and the last court challenge was 16 years. More often, 3 to 5 years elapsed before the conclusion of all appeals, far longer than the typical length of advertising campaigns. In addition, once FTC cease and desist orders became final, the agency allocated minimal resources to check on compliance. The agency developed a reputation for snail-like procedures and a comatose spirit, becoming known to the Capitol's chauvinistic wags as the Old Lady of Pennsylvania Avenue. The regulatory odyssey of Michigan's Holland Furnace Company suggests the capacity of some larger corporations to exploit these bureaucratic shortcomings. Holland Furnace had franchises in most states. Working door to door, its sales agents would create the impression that they were either government safety inspectors or private heating engineers and ask to see the furnace. If homeowners agreed, agents would disassemble it and then spin grave tales of impending disaster via cataclysmic explosion, asphyxiating fumes, or engulfing conflagration. Next would come high-pressure pitches for replacement models, along with refusals to reassemble the old unit on the grounds that salesmen would not be accessories to murder. Holland managers gave salesmen extensive training in these tactics. The company also structured compensation incentives to encourage the hard sell. Holland executives pushed this selling scheme beginning in the mid-1930s. Scores of consumer complaints led the FTC to issue a cease and desist order against the firm in 1936, but the sales force ignored it. Years of additional complaints prompted another FTC investigation in 1954, which after 4 grinding years of procedural challenges culminated in a second cease and desist order. Holland personnel gave this order and a subsequent court decree the same short shrift. The firm continued to advertise for branch sales agents whom it promised to teach our business, enabling them to make above-average wages while you learn and higher wages once you are experienced. Holland management also scoffed at fraud investigations by state and local agencies, raising every conceivable legal objection. Only in 1965, when a federal judge found the corporation in criminal contempt of the court decree, sentenced the former company president to a short prison term, and levied a fine of $100,000, did the firm take meaningful steps to root out abusive practices. Daunting practical realities confronted mid-20th century enforcers of laws against business fraud. Reticence among the fleeced, migratory swindlers, echoes of the world of caveat emptor that ricocheted around some corners of the criminal justice system, hyper-legalism, budgetary allocations that failed to match legislative aspirations. But regulatory officials were not without their own resources in coping with such challenges. Just as the history of American business fraud foreshadowed these problems, it also suggested regulatory rejoinders. Every facet of early 20th century American campaigns against business fraud reappeared in post-World War II initiatives at a greater scale and intensity. Fortifying the anti-fraud state. Aware of their limitations, post-war anti-fraud organizations looked to maximize monitoring capacity and efficiently deploy resources for enforcement. One priority was to improve coordination and information sharing among the agencies with jurisdiction over business frauds, an echo of the American Agriculturalists Network of Correspondence, the NACM's Rogues Gallery, and the compendiums of quackery and quacks put together by the AMA's Bureau of Investigation. As soon as the SEC opened its doors, officials forged close relationships with federal postal inspectors, state securities regulators, and criminal investigators and prosecutors. Within months, the SEC collected sufficient data to construct a comprehensive set of securities violation records. This central index and clearinghouse maintained details on about 15,000 Americans and Canadians who had faced allegations of securities fraud. In addition to keeping the index up to date, the SEC sent out a monthly confidential bulletin to its bureaucratic partners and contacted them about thousands of individual cases. By 1950, the fraud register comprised details on over 53,000 stock promoters, brokers, and salesmen. SEC staff also analyzed the records to spot overall patterns and always made the files available to state and local officials to assist with current enforcement problems. The Postal Inspectorate developed analogous information systems as well as national distribution of wanted posters. The latter, such as a 1948 bulletin for Frank Clifford West, alias Carl B. Mason, included not only photographs but also capsule biographies. In West's case, consumer fraud schemes in 7 separate states, fingerprints, and even handwriting samples. These national information systems facilitated the tracking down of even the most migratory swindlers. Post-war anti-fraud agencies extended their reach through heavy reliance on self-regulatory organizations. New Deal securities regulation incorporated private regulatory gatekeepers from the start. The SEC leaned not only on securities exchanges and the NASD, but also on corporate accountants and attorneys. Exchange staff closely monitored transactions for indications of market manipulation. The NASD's inspectors visited brokerages far more often than their SEC counterparts, and its officials could levy punishments on individuals and firms that unfairly treated investors, including fines, suspension, and expulsion. Accountants and attorneys had professional obligations to keep corporations attuned to the new set of regulatory rules. As investor confidence returned during and after World War II, cooperation from self-regulatory institutions and professional gatekeepers became ever more crucial. By the late 1950s, the annual value of shares traded on registered exchanges eclipsed that of the 1930s by more than 300%. Investors could buy more than 7,500 stock issues on those exchanges or over the counter, while the number of brokerages approached 5,000, accompanied by nearly 1,500 firms that offered investment advice. Faced with the enormity of the American financial markets, SEC officials presumed that prevention of securities fraud would have to rest on a solid foundation of self-regulation, self-discipline in the brokerage community, and a commitment among lawyers and accountants to foster compliance with the law. The relentless circulation of capital threatened to overwhelm centralized regulatory oversight. Outside of finance, trade associations for broadcasters, news publications, and advertising agencies took on responsibilities for keeping deception out of major marketing channels. But the most important NGOs involved in anti-fraud enforcement remained the Better Business Bureaus. The post-World War II BBBs continued to encourage consumers with grievances against businesses to contact them. Millions of Americans internalized these pleas, bombarding BBB offices with letters and phone calls that raised questions or concerns. Although most complaints did not allege fraud, a significant fraction did so. A steady stream of BBB members complained about advertising and marketing tactics by competitors. These two streams of accusations prompted over 30,000 annual investigations nationwide. In addition, BBB officials scanned newspaper and magazine advertisements and then sent out a corps of several hundred professional shoppers to discover whether enterprises lived up to their marketing promises. This ongoing policy of shopping the ads triggered additional inquiries. BBB activities amplified the monitoring activities of state agencies such as the FTC, which could only invest limited resources in surveillance of broadcast and print advertising. In hundreds of civil and criminal cases at every jurisdictional level, BBB officials coordinated with government investigators and prosecutors. BBB offices further responded to regular requests from governmental officials for assistance with enforcement efforts. During the early years of the New Deal, for instance, the Missouri Commissioner of Securities, resident in Jefferson City with no budget for investigative staff, pleaded with the St. Louis, Kansas City, and Springfield BBBs to forward intelligence about firms dealing in securities without licenses, or about duly licensed dealers and brokers who may be adopting shady or questionable methods in the distribution of securities. After World War II, the Federal Housing Authority asked for BBB assistance in policing the submission of completion certificates by construction and home improvement companies, which were required for homeowners to receive FHA mortgages. The FHA's deputy commissioner went so far as to ask every office to establish a working relationship with the local BBB, because such close cooperation will serve as one means of maintaining a close watch over operations in your area. The post-World War II BBB network never enjoyed statutorily sanctioned authority like that of the NASD and securities regulation, though BBB leaders sometimes hoped for such formal delegation. As the head of Denver's BBB mused in an early 1960 memo, "Maybe we could dare to propose that BBBs be set up like Eric Johnston's operation in the movie industry, or NASD's operation in the securities business, the commissioner of baseball, etc." Such tentativeness suggests minimal confidence in achieving official grants of power. Nonetheless, the BBB's post-1945 activities meant that the line between public and private business regulation continued to blur, as efforts by public and private agencies shaded into one another, even without explicit legislative delegation. By the 1950s, the more established anti-fraud organizations, whether inside or outside the state, boasted numerous long-serving career professionals. These individuals had familiarity with marketplace deceptions, kept abreast of new variations, and knew how to conduct fraud investigations. The best of these careerists appreciated the challenges of navigating criminal and administrative enforcement actions and grasped the importance of sensible prosecutorial discretion given limited institutional resources. They also enjoyed strong personal relations with their peers in other agencies. Long tenure as a fraud fighter by itself did not guarantee legal savvy or implementation of effective enforcement techniques. The FTC developed a reputation for having bureaucratic deadwood, with timid staff attorneys cowed by the tendency of the pre-New Deal judiciary to overrule more expansive FTC actions. From the 1930s onward, many of the most powerful career attorneys owed appointment and promotion to connections with members of Congress serving on oversight committees. Dubbed cronies by critics, these civil servants perfected the art of the drawn-out investigation, demanded procedural meticulousness, and often set agendas more on the basis of how much competitors groused about a business's advertising than on sustained analysis of harm to consumers. Tellingly, the 1966 FTC Manual for Attorneys furnished detailed instructions about how to handle complaints from competing enterprises, because staff not infrequently learned about alleged violations from those quarters. By this point, the FTC had developed a reputation for fecklessness, inertia, and leniency toward powerful corporations. By contrast, at the SEC, within the Postal Inspectorate, and among the ranks of federal prosecutors, appointments and promotions more often reflected talent and performance. A few biographical sketches suggest the ability of veteran anti-fraud enforcers in these agencies to cultivate high standing among policy elites and the wider public. Irving Pollock typified the SEC's dedicated core of lawyers who hewed to meritocratic norms. Arriving at the SEC in 1946, a few years after graduation from Brooklyn Law School, Pollock was one of the few staff lawyers who had not attended an Ivy League university. Over more than 3 decades, he participated in almost every aspect of fraud regulation, from monitoring new issue registration statements to fraud prosecutions. As he moved into managerial positions, he created an indexing system of SEC cases to streamline the process of linking evidentiary findings to prosecutorial arguments. Because of his breadth of experience, Pollock took on a key role in conceptualizing the early 1960s special study of securities markets, a mammoth assessment of regulatory policy amid rapid changes on Wall Street. Throughout the Cold War era, the reputation established by high-ranking SEC officials such as Pollock helped the organization attract the nation's sharpest law school graduates. At the Post Office and Justice Departments, the careers of Nathaniel Cossack and Henry Montague illustrate the accrual of expertise in fraud cases. Cossack joined the Fraud Division in 1952 as a prosecutor after serving as an FBI agent known for excelling in the painstaking research and patient detective work which fraud cases require. He became divisional chief in 1953 and then Deputy Assistant Attorney General in 1965. These positions afforded opportunities to plan and carry out nationwide anti-fraud campaigns, which required coordination of personnel from multiple jurisdictions and agencies. Originally a postal clerk in Poughkeepsie, New York, Montague lacked the professional education of fraud prosecutors. But after becoming a postal inspector during World War II, he received an extended tutorial on how to locate perpetrators of business frauds. After a decade of field work, he became head New York inspector in 1951 and then chief postal inspector a decade later, a position that he occupied until his retirement in 1969. Montague's office was an early adopter of computer processing to improve investigators' access to mail fraud complaints and invested in forensic laboratories to speed analysis of handwriting and typewritten evidence. Throughout his tenure, he forged deep networks with other federal agencies and U.S. attorneys. By the time he left his post, exacting hiring standards and rigorous professional training had allowed the Postal Inspectorate to cultivate a reputation as among the most effective of all federal investigators. Self-regulatory organizations depended on an analogous accumulation of professional experience. Most of the key figures in the post-war BBBs were careerists. Men such as W. Dan Bell came of age in the 1920s, or the Great Depression, found a niche in the early bureaus, and stayed on for the bulk of their working lives. Beginning his BBB work by monitoring Chicago auto ads for compliance with NRA regulations, Bell worked as an automobile marketing specialist for the Cleveland BBB in the late 1930s, managed first the Peoria and then the Buffalo BBB during World War II, and took over the revived Denver Bureau in 1951, presiding over it until he retired in the mid-1970s. At the national level, bureau leaders such as Kenneth Wilson and Victor Nyborg spent most of their adult lives with the organization. Scores of BBB officials who served during the mid-20th century had similar resumes. The professional identities of BBB leaders were based not only on the status hierarchies of a continental network of local organizations and national umbrella institutions, but also on fidelity to its mission of fostering honesty in communication with consumers and other firms. High-level BBB staff viewed themselves as deputized by the business establishment to serve as arbiters of fair competition. Kenneth Barnard summed up this self-perception in a March 1960 letter to Clyde Kemery, then the manager of the Oklahoma City BBB. Granting that better business bureaus are the creation of the business community, Barnard refused to concede they are its vassals. Indeed, the record shows that businesses created them as the umpires of business advertising. The story was much the same at other self-regulatory bodies, such as the AMA's Department of Investigations, with the partial exception of the NASD, which into the early 1960s relied on volunteers from member firms to fulfill enforcement functions. This generation of anti-fraud specialists was influenced strongly by the Great Depression and World War II. The majority came of age during this 15-year stretch. Some served in the military. Manifesting allegiance to public service, they valued anti-fraud work as a lifelong calling. Despite close links to the business establishment, they viewed themselves as resolute defenders of the trust that underpinned capitalist marketplaces, and so the integrity and strength of the American economy. If they hungered after distinction, it was for the esteem of peers in the growing fraternity of anti-fraud investigators, prosecutors, and regulators. Like their predecessors in the Truth in Advertising movement, post-war anti-fraud regulators placed a high priority on refashioning and reinforcing social mores about manipulative and deceptive marketing. This impulse drove the many trade practice conferences convened into the 1960s by BBBs and the FTC. Republican regulators favored this mode of anti-fraud regulation because it involved minimal public expense and placed the onus for regulatory action on business. As with so many other features of the anti-fraud state, the goal of trade codes was to improve the quality of information that structured purchasing decisions. With manufacturers incorporating so many new materials, novel production processes, and other technological innovations, opportunities for misrepresentations in selling emerged all the time. The fashioning of complex service products and complicated credit terms created further avenues to mislead purchasers. Trade practice conferences gave communities of businessmen the chance to hammer out principles of fair competition that would make miscommunication, misdirection, and deception less common. The often tedious business of code-making laid out exhaustive standards for information provision. Rules articulated by the Chicago BBB in 1965 for the local advertising of plastic slipcovers convey the impulse. The slipcover code not only prohibited bait tactics, price quotes excluding labor, porous guarantees, misleading claims of low overhead, and use of asterisks or excessively small print, it also set out complex definitions for quality, at least 8th-grade clear plastic with no poly or polyplastic, and specified norms for the allowable size of furniture to be covered. Tight-back, loose-cushioned sofas up to 90 inches, sections to 65 inches, and chairs approximately 34 inches in width, unless firms described variations in their ads. The thousands of marketing codes drafted from the 1940s through the mid-1960s had important implications for regulatory enforcement actions. Codes often clarified the specific nature of alleged misrepresentations. They also offered touchstones as enforcers engaged in moral suasion, because firms had participated in code formulation and had consented to the rules. The tone of BBB bulletins, for example, mixed communal boosterism with ministerial preaching that called wayward congregants back to the straight and narrow path. A 1957 bulletin from the Pittsburgh BBB to its members typified this rhetorical style. As part of a national campaign against deceptive car marketing, it had convinced over 100 area car dealerships to sign a new code of conduct. The report on this campaign for integrity in auto advertising applauded firms that had shown a vast improvement in the candor of their advertising copy and reminded dealers that they had agreed that it was more desirable to compete in a clean competitive environment. It also contrasted the admirable dealer who didn't hem and haw when a BBB official pointed out questionable advertising claims, who was a man and so quickly agreed to run a correction, from the backsliding dealer who continued to push exaggerated price claims, the other kind of bird who tries to talk around you instead of to you, and is most interested of all in comparing himself to advantage with the dregs of other advertisers. With such messages, bureaus staked out ground as independent arbiters of best commercial practice, called on businessmen to live up to professed ideals of commercial morality, and infused those ideals with an ethos of manliness. Implicit in this framework of self-regulation was a faith in voluntary fulfillment of regulatory directives. The facilitators of trade practice conferences hoped that deliberation about the boundaries of legitimate marketing would lead participating firms to embrace the resulting standards and embed those rules in commercial routines. Insofar as the detailed rules of codes became general practice, one did not need to worry so much about compliance. Earl Kintner, a Republican FTC commissioner appointed by President Eisenhower in the late 1950s, elaborated on this approach in speeches to chambers of commerce, trade groups, advertising conventions, and BBB meetings. By every means at its disposal, Kintner explained, the Commission is attempting to fan the coals of conscience into a fire hot enough to burn the impurities out of ads. Advertising agencies had to find the courage and pride to prefer professionalism to short-termism and the rat race, demonstrating that they had the guts to put these principles over billings. Media outlets should not be blinded by short-sighted visions of shady profits. Such pronouncements tinged self-regulatory endeavors with Protestant evangelism, hearkening back to the 19th century pleas of H. Boardman and the moralism of progressive-era truth-in-advertising acolytes. Kintner presumed that the Bible belonged not only in the modern counting house, but also the marketing department and advertising agency. This approach to anti-fraud regulation could reconfigure competitive environments, as the FTC's moves against deceptive claims by mail-order health insurance firms illustrate. The private health insurance industry mushroomed after World War II, stimulated by wartime tax policies that made employee benefits tax-deductible, the failure of Truman's plan for public insurance, advances in medicine, and rising household incomes. Amid this surge, dozens of insurance companies looked to sell policies through the mail. By the mid-1950s, these firms provided coverage for 3 million Americans, bringing in nearly $70 million a year in premiums. Competition was fierce, encouraging expansive promises in promotional materials about benefits which skirted exclusions, coverage limits, and policy termination triggers, though the actual policies mentioned these contractual features in fine print. As early as 1949, several larger companies had asked the FTC to sponsor a trade practice conference to root out misleading advertising tactics. The resulting meeting produced a sectoral code of conduct, but many firms refused to abide by it. Then, after a mammoth 10-month nationwide investigation in 1954 that belied its reputation for timidity, the FTC charged 41 companies with false and deceptive advertising, including several leading insurers. Through the 1945 McCarran-Ferguson Act, Congress had vested insurance regulation with the states unless they had abdicated oversight. The charged corporations used this statutory provision to challenge FTC jurisdiction in the courts. Aware that the companies had a strong case, the FTC convened a second conference to forge a revised set of industry standards, inviting not only insurers and the Health Insurance Association of America, HIAA, but also state regulators and the National Association of Insurance Commissioners, which had developed its own statement of best practices for mail-order ads. The United States Senate also began to consider legislation to tighten federal regulation of mail-order insurance marketing, as did individual states. Faced with these pressures, more established companies subscribed to a code of ethics and pledged that they would help to eliminate the bad apples in their industry. To sustain HIAA membership, companies now had to eschew misleading ad copy. Over the next several years, cut-rate mail-order insurance firms continued to pop up, but they had a harder time placing advertisements as regulators circulated lists of licensed insurers to publishers, convincing many to accept ads only from these companies. Coordinated action by BBBs could result in similar reforms. Early in the Eisenhower administration, bureaus in Los Angeles and Chicago spearheaded an initiative to clean up marketing by large discount car dealerships, which had adopted abusive sales practices such as bushing, increasing prices after an initial oral agreement, and packing, including overpriced extras in packaged car deals. In the late 1950s, nationwide cooperation among BBBs exposed systematic misrepresentation and overcharging by auto collision insurers, which in turn prompted multi-million-dollar refunds. Despite these demonstrations of the potential to reshape commercial norms through self-regulation, most post-war anti-fraud officials recognized that there would always be a population of dissemblers and swindlers who would prey on gullible Americans. As a result, every anti-fraud bureaucracy responded to budgetary constraints and procedural gauntlets by constructing internal filters to guide prosecutorial discretion. Veteran enforcement officials at the SEC and the Post Office acquired a fine-grained sense of the circumstances that facilitated successful prosecutions. Unless prosecutors saw evidence of callous deceit that would raise the hackles of judges and juries, they declined to seek indictments. The vast majority of complaints or referrals did not generate docketed investigations, while investigations leading to criminal prosecutions tended to hover at around 1%. Civil enforcement actions were more common but still represented a small fraction of official inquiries. Prosecutorial selectivity, in combination with accumulated savvy in presenting fraud cases, resulted in impressive conviction rates. From World War II through the 1960s, U.S. attorneys won criminal cases referred by the SEC more than 80% of the time. Mail fraud cases were even more likely to result in guilty verdicts. The Postal Inspectorate's meticulousness helped federal prosecutors to convict 19 out of 20 defendants. Such outcomes represented even greater prosecutorial successes than during the early 20th century campaigns against business fraud. Furthermore, when circumstances brought wider public attention to nodes of commercial chicanery, anti-fraud agencies had the capacity to mount coordinated campaigns with bite. In the mid-1950s, officials at the SEC and Justice Department became alarmed by boiler rooms that floated sham mining and high-tech stocks amid a booming market, as well as mutual fund managers who unloaded worthless securities on their investors. Federal regulators ramped up securities fraud investigations with annual indictments and convictions between 1959 and 1965 increasing 400% as compared to the previous 15 years. Many of these cases targeted peddlers of dodgy Canadian uranium mines or corporate shells masquerading as producers of the latest electronics wizardry. But federal prosecutors also went after more sophisticated promoters, including Walter Tellier, Lowell Burrell, and Alexander Guterma. These individuals organized complex multi-million-dollar frauds involving mergers, acquisitions, and the burgeoning corporate strategy of conglomeration. One can point to numerous enforcement drives against other arenas of business fraud. Toward the end of the 1950s, several members of Congress were alerted by constituents to an upsurge in interstate advance fee schemes, which dangled alluring franchising opportunities, promises to find buyers for those wishing to sell small businesses or residential properties, or offers to arrange loans for small business owners in need of capital. The resulting congressional hearings triggered multi-year investigations mounted by the Department of Justice's Fraud Division and the Postal Inspectorate, generating dozens of successful prosecutions. During the early 1960s, officials at the Federal Communications Commission cooperated with their counterparts at the DOJ and the Post Office to clamp down on U.S. mail-order scams that ran ads on high-powered Mexican radio stations. Throughout the 1960s, federal agencies also launched extended campaigns against credit fraud rings, interstate real estate scams, and a spate of managerial frauds at savings and loans. Even the most gung-ho enforcers, however, had to be mindful of resource constraints. Ever-present budgetary and staffing limitations allowed only so many expensive, time-consuming investigations and interagency campaigns. As a result, post-World War II anti-fraud cops, just like their interwar predecessors, relied heavily on negotiated settlements. When evidence seemed serious enough to warrant official attention, the first option was always to enter into informal discussions with a firm whose business practices were skirting the lines that separated puffery or aggressive reliance on informational advantages from fraud. Enforcement strategies at post-war BBBs typified reliance on a graduated system of sanctions. Bureau officials encouraged disgruntled purchasers to seek out resolutions such as partial refunds that would allow both sides to avoid implications of impropriety. If BBB staffers judged ads or sales techniques to violate standards of fair dealing, they would request revisions, turning to sterner measures only when businesses rebuffed these interventions. For firms that did not follow through on promises to clean up their marketing, the next stage involved drawing up formal stipulations. In April 1952, the Logan Appliance and Furniture Mart signed off on a typical voluntary agreement with the Chicago BBB, pledging to forswear advertising which has the tendency to mislead and all bait practices. They also agreed to furnish fuller information than they had about credit terms. Such declarations, like the act of signing on to an industry code, committed firms to the moral force of BBB standards and the legitimacy of ongoing BBB oversight. BBBs further asked some firms to run corrective advertisements that apologized for past deceptions. If firms rejected overtures for quiet adjustments or signed stipulations only to violate their terms, BBBs again turned to the weapon of publicity. Every local branch published newsletters calling out firms that had strayed too far from BBB principles. A still more pointed step was to give local media outlets details about a firm's repeated violations and intransigence in the face of requests for reform, and to proclaim that further advertising by this source is not in the public interest. Although not every publisher or broadcaster abided by such NIPI declarations, many, including leading publications such as the Chicago Tribune and the Los Angeles Times, did. Radio and television stations, which had to worry about FCC license renewals, also abided by Bureau directives. NIPI declarations functioned like postal fraud orders, cutting lines of communication between businesses and customers. The most common outcome of such proclamations was a toning down of marketing, which led the BBB to lift its objections. According to the Chicago BBB's automotive trade consultant, Carl Dalkey, NIPIs were much more effective than to haul someone into the local state attorney's office for a hearing. What we do is not only a lot tougher, but it's faster and it works. As a result of Bureau jawboning, firms ran corrections to thousands of ads, 150 in Chicago alone during 1957, and adjusted thousands more. In 1962, businesses complied with requests from the national BBB for such adjustments 93% of the time. In addition, BBB investigations could and did help authorities send fraudulent businessmen to jail. At the same time, BBBs emulated public anti-fraud agencies through greater concern for procedural rights. Although pushed by the consumers and competitors who complained to them, Bureau officials remained representatives of the business community, eager to protect the businessman. They further had to worry about retaining membership. As a result, BBB officials extended the benefit of the doubt to established firms. The always present threat of civil suits for conspiracy and libel fortified this inclination. From the 1930s through the mid-1960s, local BBBs faced more than 100 such lawsuits, which reinforced a preference for quiet investigation and patient persuasion. Concerns about due process eventually led BBBs to revisit the idea of an appeals process, with several local bureaus forming advertising review boards. Before a NIPI directive went into effect in these markets, an affected enterprise could ask for a hearing before a tribunal of prominent BBB members. After sustained debate within national BBB structures, the organization endorsed such forums in late 1952. By the end of 1960, 26 BBBs had one, with a further 16 in the works. The extension of proceduralism into self-regulation created openings for business cheats in much the same fashion as had the punctiliousness of FTC cease-and-desist hearings. Consider the saga of Fritzl Television Repair. For almost 2 decades, owners of televisions and radios complained to the Chicago local BBB about Fritzl, alleging unauthorized, unnecessary, and faked repairs, shoddy work, overcharges, and rank coercion, as employees refused to return radio or television sets until bills were paid in full, regardless of pending complaints. Fritzl customers pleaded with the BBB to make the firm accountable for its abuses and to warn others about it. "I keep wondering," a Mrs. Andre Shervance wrote in June 1954, "how many other people are being done in as I was. I don't like to feel that such dishonesty can go unchecked." Into the 1960s, bureau staff regularly contacted the company to mediate on behalf of consumers like this North Side housewife. Fritzl accommodated BBB overtures, reaching numerous settlements with disgruntled customers, but not changing its business practices. Only after the Illinois Bureau of Consumer Fraud began a 1964 investigation did the BBB go after the firm, assisting with a sting operation that demonstrated a pattern of fake repairs in which Fritzl technicians replaced working components with second-rate or even faulty ones. Here was another Holland Furnace Company, operating on a local scale. Cases like Fritzl recur throughout the Chicago BBB files. Although complaint mediation frequently happened within days, BBBs often took years to adopt tougher measures, especially when businesses did not make the mistake of brushing off BBB staff. Even a steady stream of mediated compromises, ad corrections, and stipulations might not lead to less deceptive marketing. As with FTC disciplinary action, a far-sighted marketing department could easily cope with BBB finger-wagging. By the time that a BBB staffer objected to an ad, firms could cheerfully comply because they were about to roll out a different, though analogous, pitch. BBB methods did not necessarily work better than those of the administrative state. Beginning in the late 1950s, some BBBs tried a more preventive tack by offering advance assessments of advertising campaigns. The vetting of proposed ads allowed businesses to receive clearer signals about the interpretive boundaries of BBB and media codes of conduct. This opportunity to iron out wrinkles before the fact, Bureau officials insisted, did not constitute pre-censorship. It was merely a sensible mechanism to ward off deceptive pitches before they reached the public's ears and eyes. On occasion, persistent preaching led to conversion. The post-war Chicago BBB could point to numerous examples in which years of jawboning persuaded an aggressive discount house to clean up its advertising. Bargain Town, USA, for instance, tussled with the head of the Bureau's home furnishings division for nearly 5 years in the late 1950s and early 1960s. On several occasions, BBB officials demanded ad corrections by this local toy store chain. 3 times they issued 3 NIPI directives because of disputed comparative price claims. Bargaintown treated BBB officials with deference and complied with these requests. Eventually, its owner-managers also agreed to cease making claims about markdowns from manufacturers' suggested list prices on the grounds that the ongoing revolution in American distribution had so intensified price competition as to render them meaningless and confusing, producing a lack of confidence by the consumer in ourselves as merchants and in the toy industry in general. BBB officials could not hope for a clearer recitation of the truth in advertising catechism. From the 1920s up to the late 1960s, the FTC, SEC, and Post Office disposed of its fraud-related caseload in similar fashion. If inquiries convinced FTC lawyers that a firm's marketing promotions had the capacity to mislead, they looked to negotiate pledges to stop the offending practices. In order to encourage compromises, the FTC in 1951 stopped requiring that businesses agree to findings of illegal marketing as a condition of stipulations. Beginning in 1962, it followed the BBB's lead and set up an advisory service to dispense guidance about the legitimacy of new marketing strategies. SEC and postal regulators likewise looked to give firms the chance to correct problems before initiating the creaky wheels of formal legal process. If registration documents for an initial public offering lacked important details or included misleading text, SEC officials would send a deficiency letter that laid out the problematic features and asked for revisions. After a process of give and take by conferences, telegraph messages, telephone conversations, or correspondence, the Commission would draft a voluntary agreement setting out necessary amendments. SEC staffers also issued advisory opinions to corporate lawyers who asked for guidance about the legality of promotional materials. Within the Post Office, most fraud investigations led not to fraud orders or indictments, but rather stipulations in which firms promised to discontinue objectionable marketing. This posture reflected realities that confront all regulatory bureaucracies. But for BBBs and many officials at federal anti-fraud agencies, they also represented deeper philosophical commitments amid the era's epochal conflicts with Soviet communism. BBB leaders remained dedicated to an ideology of business self-regulation, in which regulators, ideally, handled marketing deceptions outside the glare of publicity. This style also suited the leadership of the post-war FTC and SEC. Convinced that most businessmen were trustworthy and well-meaning, these officials gave reputable firms considerable leeway. There would be, Earl Kintner and later Democratic FTC Chair Paul Rand Dixon agreed, no commercial Gestapo as the United States engaged in the battle between individual freedom and state slavery. The sentiments expressed by these 2 FTC commissioners spoke to broader impulses that underpinned anti-fraud policies from the early New Deal through the first years of the Kennedy administration. During these 3 decades, most new anti-fraud regulations and enforcement campaigns were pushed either by business interests or policy entrepreneurs within anti-fraud agencies. Corporate interests, such as textile manufacturers, worked to root out what they saw as unfair competition. Policymakers sometimes worried about systemic threats that fraud posed to capitalist markets, nowhere more so than in securities regulation, as the Great Depression left an enduring imprint. In other contexts, such as the post-World War II moves against diploma mills, legislators and regulators looked to protect the government itself, much as the Reconstruction-era post office had moved against mail fraud to safeguard its own reputation. These efforts were often inflected by deeper faith in the value of candor in commercial speech. They always depended on dense networks that linked national and state governments with self-regulatory organizations. In all of these contexts, anti-fraud regulators stressed the importance of looking out for consumers and investors who lacked the information or sophistication to sidestep misleading and fraudulent pitches. But before the 1960s, consumer perspectives rarely drove either anti-fraud politics or policy. In the 1940s and 1950s, organizations such as Consumers Research and Consumers Union did help educate Americans about marketing deceptions, but they lacked the bureaucratic capacity, strategic vision, and standing to set regulatory agendas. Amid the heightened socioeconomic expectations that accompanied the post-war boom, however, a resurgent consumer movement would increasingly bring its own analyses of business fraud to Washington, D.C., state capitol buildings, and city council chambers. Buoyed by the more general political activism of the 1960s and greater awareness that specific demographic groups continued to be the victims of abusive marketing practices, advocates of consumerism would soon inject a new sense of urgency into public efforts to beat back the scourge of business fraud. Chapter 10. Consumerism and the Reorientation of Anti-Fraud Policy. The post-war tightening of laws against business fraud occurred during a period of remarkable prosperity. Rapid economic growth between 1940 and 1970 moved tens of millions of Americans into the middle class, raising social expectations. Although America's consumer society had deep historical roots, the embrace of consumption took on new dimensions after World War II. Politicians and other arbiters of public values came to define social aspirations in terms of home ownership, possessions such as cars and televisions, and the capacity to pursue chosen lifestyles. Such messages were amplified by advertising barrages from corporations and ubiquitous depictions of material plenty in radio dramas, movies, and television shows. This perspective privileged technologically driven improvements in living standards and a concomitant widening of consumer choice. Over the same decades, the nation's leading financial institutions, led by the NYSE, developed comprehensive public relations programs to bring the masses into the financial markets. This renewed drive to democratize investment, along with the expanding scope of institutional investors such as pension funds, insurance companies, and mutual funds, meant that by 1970 a majority of American families had a personal financial stake in the securities markets. For some business elites and their political allies, the valorization of consumer culture and democratic participation in modern financial capitalism had deeper political purposes. One goal was geopolitical, to sharply differentiate the U.S. economy with its capacity to distribute the fruits of capitalism to a broad middle class from its Soviet antagonist. A 1952 DuPont Chemicals advertisement that posed the question, "Which Marx gets the biggest laugh, Karl or Groucho?" encapsulated this line of argument. It lampooned the Marxist joke about the impoverishment of the people under capitalism, which you don't get until you try to find a place to park downtown amid all the impoverished people shopping like mad in the department stores, or until you see newsreels of the new Russian automobile, which would be sneered off any used car lot in America. Related messages focused more on domestic political economy. Through public relations and advertising that extolled free enterprise, the corporate establishment hoped to deflect calls by more militant labor unions for a greater say in the management of enterprise. Business elites further wished to constrain the broader New Deal focus on providing economic security and to forestall more substantial roles for the public sector, such as nationalized health care or expansive public housing projects. Such efforts did limit the place of government in American capitalism, but in nudging popular mores toward the imperatives of consumption and the views of Groucho Marx, the tribunes of free enterprise sharpened popular dissatisfaction with perceived duplicity by manufacturers, retailers, and financial firms. The mid-20th century consumer economy, moreover, provided unscrupulous American firms with ample opportunities to generate dissatisfaction. American inner cities remained home to businesses that riffed off the venerable strategies of bait-and-switch advertising, high-pressure selling tactics, and reliance on deceptive credit terms. In the process of unleashing new frontiers for consumption, post-World War II suburbanization created further avenues for consumer fraud, with home improvement, automobile sales, electronics repair, and real estate scams topping the list. By the 1960s, dramatic growth in the elderly population encouraged scams targeting seniors. After World War II, the panoply of available investments continued to include Ponzi schemes and scores of get-rich-quick stock promotions. With so many targets remaining for would-be reformers, and with heightened popular sensitivities to duplicitous marketing, the embrace of anti-fraud initiatives allowed one to claim the mantle of consumerism. Savvy politicians across the country recognized this opportunity, as did a slew of community-based consumer organizations. The result was a renewed and reconfigured anti-fraud coalition, pushed by consumer activists and informed by sociological and legal research, with significant participation from leaders of both major political parties, including 3 successive U.S. presidents. New anti-deception laws and agencies proliferated at all levels of government, reflecting the imperatives of consumer and investor protection. Nonetheless, macroeconomic challenges during the 1970s meant that public investments never quite matched rhetorical flourishes. Those same economic pressures set the stage for a conservative backlash against the most ambitious advances of the anti-fraud state. Expansion of the Anti-Fraud Coalition. The impetus to redirect anti-fraud regulation toward consumer interests sprang from the discontent that ordinary Americans expressed as they navigated the post-war economy. All the paeans to technological improvement and the good life heightened expectations about consumer experience, even as the concerted efforts of social movements deepened American commitments to individual rights. As racial minorities, women, and other social groups pressed their claims through popular discourse and constitutional litigation, a larger fraction of the populace felt emboldened to demand their due, and so disinclined to remain silent suckers. The BBBs and law enforcement agencies reaped the resulting whirlwind, embodied in tens of thousands of annual consumer complaints that accused businesses of misleading or untruthful marketing pitches. As in earlier eras, journalists played a central role in identifying the contours of business fraud and making them visible to the public. National magazines, such as Ebony and Better Homes and Gardens, along with leading newspapers such as the Chicago Tribune and the New York Times, continued to cover business fraud. Every year, their journalists churned out hundreds of stories that alerted readers to the latest deceptions, covered enforcement actions, and dispensed advice about how to avoid scams or seek redress. Prominent writers also updated the messages of Confessions of a Confidence Man and The Bargain Hucksters, publishing books that focused on the latest marketing depredations in urban neighborhoods and suburbia. By the 1960s and 1970s, a growing number of urban newspapers and television stations gave individual reporters and columnists the opportunity to become local consumer sentinels. At the Philadelphia Tribune, a paper that focused on the local African American community, journalist Len Lear put together in-depth series on scams by home improvement firms, used car dealers, unscrupulous or phony doctors, and predatory life insurance companies. The paper also created Mr. Help, a service desk that readers could contact to ask for assistance in dealing with consumer complaints. Christine Winters, who wrote for the Chicago Tribune, pumped out dozens of articles on the consumer frauds prevalent in the Windy City. In Atlanta, station WAGA gave its consumer relations editor, Paul Reynolds, wide latitude to put together regular segments on automobile repair ripoffs and mail-order frauds. Television viewers in Washington, D.C. received regular news coverage of consumer scams on 3 different local channels: the ABC and NBC affiliates and independent station WTTG. These reporters, joined on the fraud beat by counterparts throughout the nation, offered troubleshooting services for disgruntled consumers much like those provided by BBBs. Investigative journalism was accompanied by a growing corpus of social science research into the prevalence, dynamics, and policy responses to business fraud. In terms of sheer output, legal scholars dominated this academic discourse. The nation's leading law reviews published a steady flow of articles that documented trends in anti-fraud policies, evaluated their impacts, and proposed new approaches. Many of the most probing analyses came from student editors, who produced comprehensive notes that detailed fraud law in action. This conversation within legal academia increased in frequency and intensity from the mid-1960s through the late 1970s. The most influential academic study, however, came from a sociologist, David Kaplowitz, whose research into consumer culture in disadvantaged New York City neighborhoods came out in 1963 under the title "The Poor Pay More: Consumer Practices of Low-Income Families." Kaplowitz showed the limited choices confronting these residents and the extent to which merchants and door-to-door salesmen took advantage of them through shady practices. His catalog of predatory retail tactics received extensive notice from national opinion makers. It also helped to shape the agenda of the Kerner Commission on the race riots of the 1960s, whose 1968 report stressed commercial misrepresentations and abuses as contributing to urban unrest. By the early 1970s, a host of newer consumer groups had joined the anti-fraud fray. In almost every state, activists founded councils that focused on consumer education and policy work. From 1968 onward, these state-level groups were linked through national umbrella organizations such as the National Consumer Law Center and the Consumer Federation of America. In this same period, numerous community-based organizations were founded in the nation's largest cities, usually possessing shoestring budgets and sometimes keeping their doors open for only a few years. These advocates were based in poor urban neighborhoods and manifested the creative activism that characterized the era's wider social movements. To the leaders of San Francisco's Consumer Action, Chicago's Community Thrift Club, or Philadelphia's Consumer Education and Protective Association, CEPA, governments needed to do far more to combat the cruelest scams, which targeted individuals with limited formal education and low incomes, often in inner-city African American and Latino communities. Nonprofit consumer groups, however, did not initially take the lead in translating popular anger into concrete proposals for new anti-fraud policies. Instead, elected officials staked out this ground, with a few state attorneys general playing prominent roles. These officials had the responsibility of enforcing criminal fraud laws and recognized the political payoffs that might accrue to consumer champions. One way to cultivate such a reputation was to create anti-fraud bureaucracies. The first effort along these lines was instigated by New York Attorney General Louis Lefkowitz, a lifelong Republican stalwart. Hailing from an immigrant neighborhood on Manhattan's Lower East Side, Lefkowitz found himself inundated by consumer complaints about shady businesses and outright frauds after gaining office in 1956. The next year, he established a Consumer Frauds and Protection Bureau, which he made an internal funding priority. This new office developed ambitious strategies of public outreach and increased its capacity to investigate complaints from disaffected New York consumers. It put out newsletters, pamphlets, and educational films, and issued a blizzard of press releases. Hardly a legislative session went by without Lefkowitz calling for the passage of some new law to deal with a dimension of consumer fraud that citizen complaints had brought to the attention of his staff attorneys. All of this activity received assiduous coverage from the state's news outlets and cemented the Attorney General's popularity with New York voters, who returned him to office by large margins for over 2 decades. Lefkowitz pressed other states to address consumer fraud issues, and his long tenure in office advertised the electoral advantages of doing so. Elected officials elsewhere took note, with scores of prominent political figures seeking to position themselves as intrepid foes of consumer and investor fraud. Governors from both parties, including Connecticut's Abraham Ribicoff, New York's Nelson Rockefeller, Maryland's Spiro Agnew, and Georgia's Jimmy Carter, constructed anti-business fraud agendas. Even Ronald Reagan set out several proposals to constrain consumer frauds while serving as California governor. Attorneys general proved even more eager to build reputations as vocal defenders of the put-upon consumer. Often viewing their positions as stepping stones to governorships or U.S. Senate seats, they grasped that aligning themselves with a burgeoning consumer movement represented excellent politics. These ambitious politicos ranged from liberal Democrats, such as Illinois' William Clark, to more conservative members of the party, such as North Carolina's Robert Morgan, and also included moderate Republicans such as Slade Gorton and Yvel Younger, from Washington and California respectively. Each spearheaded anti-fraud agendas, lobbied state legislatures for more vigorous consumer protections and greater funding for consumer fraud divisions, and chased after media coverage. National political leaders soon joined the competition to burnish credentials as consumer advocates. Of all the voices asking for sterner anti-fraud policies, none had a bigger megaphone than occupants of the Oval Office. President Eisenhower had used that megaphone briefly after the television quiz show scandals. Subsequent presidential administrations did so more frequently, identifying anti-fraud reforms as national priorities. Presidents Kennedy, Johnson, and Nixon each used their bully pulpit to amplify public awareness of consumerism as a policy framework and commercial deception as an issue demanding legislative and administrative responses. The Kennedy administration signaled its intentions in the fall of 1961, when Attorney General Robert F. Kennedy convened a national conference for law enforcement officials on antitrust issues, consumer protection, and investment fraud. The following year, his brother, President John F. Kennedy, articulated an expansive commitment to consumerism in a special address to Congress. Modern consumers, Kennedy argued, faced unprecedented informational challenges. Firms throughout the country had embraced the impersonal marketing techniques of mass advertising, a bewildering array of credit terms, and confusing non-standard packaging techniques. In addition, the president stressed, the voice of consumers was not always as loudly heard in Washington as the voices of smaller and better organized groups, such as manufacturers, retailers, and trade associations. As a result, the federal government needed to develop a more cohesive program of consumer protection, tackling consumer safety, the problem of concentrated economic power, and the most prevalent versions of commercial deception. Kennedy concluded by calling for a Consumer's Bill of Rights featuring the right to be informed, to be protected against fraudulent, deceitful, or grossly misleading information, advertising, and labeling. Lyndon Johnson reprised all of these themes 4 years later in his own presidential message to Congress. For Johnson, America faced new problems of prosperity brought on by new complexities and hazards associated with the march of technology and marketing practices that made consumer choices more difficult. While lauding corporate innovation and cautioning against excessive meddling in the free enterprise system, the Texan nonetheless demarcated an indispensable role for government in safeguarding the consumer against unsafe products, against misleading information, and against the deceitful practices of a few businessmen that can undermine confidence in the vast majority of diligent and reputable firms. In addition, he made federal action against business deceptions a central feature of his Great Society agenda, calling for legislation that would establish new legal remedies for misleading packaging, deceptive consumer lending terms, sharp and unscrupulous selling of interstate real estate, and conflicts of interest in the management of pension plans. Reversion of the White House to Republican control in 1969 did not prompt a wholesale rhetorical shift on these issues. Emulating his two predecessors, President Richard M. Nixon issued yet another special message to Congress, assuring the nation that consumerism is here to stay, and that federal government remained committed to a buyer's bill of rights that included the right to accurate information that enabled the consumer to make his free choice. Nixon advocated several legal reforms designed to strengthen protections against marketplace deceptions and dishonest competitors, including easing the rules for bringing federal consumer class action lawsuits, though also requiring that such suits could only proceed after successful criminal prosecution of a business by the Justice Department, expanding the FTC's authority to ask for injunctions against deceptive corporations, and improving disclosure of warranty terms for durable goods. Such presidential pronouncements were augmented by new consumer offices. In 1963, President Kennedy established a White House Council on Consumer Affairs. The following year, President Johnson appointed Esther Peterson, a longtime activist in the consumer and labor movements, as head of the new council and special assistant to the president on consumer affairs. Although possessing a modest budget and still having other responsibilities in the Labor Department, Peterson gave consumer advocates a point person within the White House and kept in close contact with federal agencies and elected officials who focused on consumer issues. She also traveled the country to give speeches to consumer groups and business organizations, wrote extensively on consumerism, and stood ready to testify before Congress. After Peterson resigned her position in 1967, Johnson replaced her with Betty Furness, a career actress with close ties to Democratic Party leaders, but far less experience involving consumer matters. Furness nonetheless developed a reputation as an effective opponent of the rackets that victimized the elderly, the uninformed, the sick, and the poor. President Nixon transformed the Advisory Council into an Office of Consumer Affairs within the White House, which he characterized as obliged to take a leading role in the crusade for economic justice. Nixon further asked Congress to create a Consumer Protection Division within the Department of Justice, which would have the authority to investigate consumer abuses, represent consumer interests before Congress and federal agencies, and coordinate enforcement efforts related to consumer protection statutes. He also urged every state that had not already done so to enact its own consumer protection law and establish a dedicated enforcement body. Nixon's appointee to head the White House office was Virginia Nauer, the former head of the Pennsylvania Bureau of Consumer Protection. Like Peterson and Furness, Nauer maintained a grueling travel and speaking schedule in order to keep consumer issues in national headlines. Through speeches and congressional testimony, Nauer depicted consumer fraud in even graver terms than had her predecessors, referring to it as an insidious economic cancer which eats at the vitals of our society. Deception by the white-collar fraud robber, she warned, threatened popular faith in the rule of law. It also withers our moral fiber, misdirects our economic resources, and saps the strength of our free enterprise system. By identifying consumer protection as a national priority and characterizing business fraud with such stark images, the Kennedy, Johnson, and Nixon White Houses greatly enhanced the place of consumer fraud on the nation's policy agenda. Their administrations took place toward the end of a period of growing presidential influence in which the challenges of depression, World War, and the struggle against communism had consolidated power in Washington, the executive branch, and the White House. It was also the golden age of broadcast television, which allowed the head of the executive branch unmediated access to the citizenry at large. In an era in which presidents often framed public debate, their imprimaturs mattered, even if specific legislative proposals did not always meet the approval of more militant consumer organizations. Presidential insistence about the salience of any specific issue deepened public awareness of it. Such presidential blessings also stimulated more news coverage and journalistic investigations, galvanized the academics, interest groups, politicians, and career bureaucrats who most cared about an issue, and encouraged new policy ideas and more intense coalition building. Within Congress, a cluster of long-serving members carved out complementary niches as champions of tougher consumer fraud policies. These public servants had imbibed the critique of unregulated capitalism and the positive view of governmental power ushered in by the New Deal. Democratic Senator Warren Magnuson of Washington, one of the most committed consumer advocates on Capitol Hill, encapsulated this perspective in The Dark Side of the Marketplace, a well-received 1968 book that assessed numerous threats to economic welfare, health, and safety. As Magnuson confidently remarked in the book's introduction, he was certain that we all share the common conviction that it is no longer a question of whether the consumer will be protected, but rather a question of how. Magnuson, along with hundreds of elected officials who shared that conviction, believed that the state could redress socioeconomic problems. These national politicians, like their counterparts on the state level, also calculated that seeking out concrete strategies for combating business fraud would cement their stature and popularity. Like Magnuson, most of these congressmen and senators were Democrats who hailed from more industrialized parts of the country, such as the Midwest, Northeast, or Pacific Coast. Among senators, they included Paul Hart of Michigan, who became a key advocate for fair packaging and labeling legislation, Paul Douglas of Illinois, the chief proponent of truth in lending reform, and Harrison Williams of New Jersey, who provided leadership on the issue of fraudulent interstate real estate developments. In the House, Democrats such as John Moss of California and Howard Rosenthal of New York City emerged as prominent sponsors of anti-fraud legislation. These elected officials convened the legislative hearings and sometimes asked for the agency studies that built an evidentiary case for reform. They oversaw the drafting process by staff and managed bills as they moved through committee, floor consideration, and final negotiations among congressional leaders and the White House. Despite the central role of elected officials in turning domestic policy agendas toward the problem of business fraud in the early 1960s and maintaining public focus thereafter, the strategic preferences of consumer activists increasingly shaped legislative and administrative action. Once the newer consumer organizations and lawyer activists had gained a footing in cities, state capitals, and Washington, D.C., they had perches from which to influence policy discussions. This growing clout manifested itself at every stage of the policymaking process, as illustrated by the hearings on consumer law held by a Senate subcommittee in 1969 and 1970. Convened to consider responses to legislative proposals that would strengthen the FTC's ability to fight consumer frauds, the subcommittee's witness list included trade association representatives and corporate CEOs. Unlike the discussions that produced fur and wool labeling legislation in the 1950s, however, Congress now invited consumer organizations to the policymaking table. Indeed, the hearings were set up by testimony from representatives of these groups: George Gordon, Jr. of the National Consumer Law Center, Walker Sandback, Executive Director of Consumers Union, and Edward Berlin, General Counsel of the Consumer Federation of America. As consumerism took hold in the United States, its leaders began to shape the legislative agendas and the formulation of specific policy proposals, and anti-fraud reforms took on a more populist hue. The individual who had perhaps the greatest role in setting the broader consumerist agenda Activist lawyer Ralph Nader did not take the lead in channeling calls for action against consumer fraud, though he did give the issue some attention. In 1969, Nader charged a group of law students to prepare a detailed study of the FTC itself, focusing on its regulation of deceptive marketing practices. The result was a critical report that helped to lay the intellectual foundation for later FTC reforms. He also drove the long-standing and eventually unsuccessful effort to create a national consumer protection agency, which would have had the power to investigate issues related to consumer fraud, monitor fraud-related enforcement efforts, and shape new regulatory initiatives. But Nader focused far more on other consumer issues such as product safety, environmental protection, the reinvigoration of antitrust enforcement, and the selective dismantling of industry-specific regulatory structures. As a result, the consumerist challenge to deceptive marketing had more of a pluralist flavor, with studies and proposals emanating from across the new organizations that emerged in the 1960s and 1970s. A wave of regulatory action. At all levels of government, elected, appointed, and career officials at once recognized and emboldened advocates of enhanced consumer protection measures. Public servants sometimes transformed the more diffuse popular sentiment for enhanced consumer protection into concrete reform proposals, and more frequently appropriated the ideas put forward by academic experts and consumer organizations. They built coalitions within legislatures and executive agencies for new anti-fraud policies and engineered compromises to overcome entrenched opponents of change. Argument by argument, hearing by hearing, and debate by debate, they deepened the legitimacy of using public power to beat back the unscrupulous bait-and-switch artist and peddler of misrepresented goods, services, and investments. The result was a groundswell of anti-fraud reforms adopted between the Kennedy and Ford administrations in Washington, state capitals, and cities alike. At both the national and state levels, regulators and legislators took aim at the decades-old problem of spurious cures and medical treatments. Officials at the Food and Drug Administration, FDA, spearheaded the most comprehensive initiatives, as when they convened 3 massive national congresses on medical quackery with the AMA in 1961, 1963, and 1966. These meetings of medical experts and policymakers highlighted the extent to which false medical messiahs still preyed on the sick and terminally ill, and helped to galvanize support for tightening up marketing regulations. The most important congressional response came in the 1962 amendments to the Food and Drug Act. This legislation shifted regulatory authority over the advertising of medical products and services from the Federal Trade Commission to the FDA, mandated scientific proof of medical efficacy before firms could market drugs or other treatments, and required meticulous attention to scientific studies in the making of any therapeutic claims. Within the states, more vigorous regulation of fraudulent health care providers occurred partly through occupational licensing boards. Several states also adopted pure drug statutes and regulatory oversight bodies patterned on national policy frameworks in the hopes of rooting out adulterated, misbranded, and sham medical products. Leaning on the Democratic congressional supermajorities of the mid-1960s, consumer advocates enacted a trio of anti-fraud measures: the 1966 Fair Packaging and Labeling Act, the 1967 Interstate Land Sales Full Disclosure Act, and the 1968 Truth in Lending Act. Each of these statutes again sought to redress imbalances in information by requiring businesses to furnish purchasers with truthful, standardized statements as to the quantity, quality, and cost of goods, assets, or credit. Each further authorized the FTC to enforce these disclosure obligations. State and local governments embraced a slew of additional anti-fraud proposals. One popular reform imposed mandatory cooling-off periods 2 or 3 days in which customers could cancel purchases or contracts in commercial sectors notorious for high-pressure tactics, such as home improvement repairs. Several jurisdictions also tightened the regulation of consumer credit arrangements. Within the realm of investor protection, more expansive governmental reforms occurred through legislation and administrative action, often driven by appointed officials and career civil servants at the SEC. The mid-1960s revamping of New Deal securities regulation, which was set up by the SEC's 19-month Special Study of Securities Markets, stands out for this type of policy entrepreneurship. Taking place at the start of the Kennedy administration, the special study was a response to a fraud scandal on the American Stock Exchange, Amex. In 1960, regulators and the press discovered that for nearly a decade, the R.E. brokerage firm, a leading voice in internal Amex governance, had engaged in marketing manipulations and insider trading. This incident might have generated a fairly narrow assessment of the shortcomings in Amex self-regulation. Instead, SEC Commissioners William Carey, Jack Winter, and Emanuel Cohen opted for a much broader inquiry. Recognizing that the financial markets had undergone profound transformation since the start of the New Deal, they convinced Congress to furnish $750,000 as a share of the economy, roughly equivalent to $22 million in 2016 dollars, for an examination of shifting investing practices and the evolution of regulatory institutions. The commissioners asked Milton Cohen, a leading securities lawyer with SEC experience, to oversee the investigation. Its charge was to examine regulatory relationships among investment banks, corporations, and brokerage firms, on the one hand, and stock exchanges, professional gatekeepers, the NASD, and the SEC on the other. Cohen agreed, but only after securing guarantees that the Commission would not be able to demand revisions of study findings. Through confidential questionnaires to brokerage firms and detailed interviews of regulators and individuals who worked within the financial markets, Cohen's team of 65 veteran staffers amassed a mountain of evidence. They traced the emergence and rapid growth of institutional investors, documented the regulatory challenges posed by a quadrupling in the frequency and value of securities transactions since the 1930s, and completed several case studies of malfeasance and conflicts of interest on the part of securities promoters and stock brokerages. The team of lawyers and analysts then crafted detailed recommendations for legislative reforms. Upon the completion of the special study, the SEC convened a liaison committee with finance leaders to draft formal legislative proposals. Although Congress did not accept every one of the special study's recommendations, its monumental final report established an evidentiary and conceptual basis for the next 15 years of national legislation regarding securities regulation. The chief anti-fraud measures of the 1964 amendments to the Securities Acts, including a significant expansion in the number of firms subject to disclosure rules and NASD membership, and imposition of tighter regulatory oversight of sales practices by brokerages, emerged from the special study. Richard Nixon's victory in 1968 did not temper the SEC's commitment to full disclosure and candor in the securities markets. Acting at the request of SEC staff attorneys who wished to expand the agency's enforcement tools, federal judges acceded to requests for disgorgement and restitution orders that furnished at least partial compensation to defrauded investors. The judiciary further accommodated the filing of private class action suits by lawyers representing large numbers of similarly situated disgruntled investors. During the 1960s and 1970s, the clear trend remained placing higher regulatory barriers in the way of promoters, stock dealers, or corporate officers who wished to pull fast ones on the investing public. Born out of profound economic crisis, the New Deal administrative structures that sought to constrain securities fraud became entrenched features of the financial marketplace. These frameworks came to enjoy bipartisan support among political elites, though Democratic administrations in the 1940s and 1960s proved more willing to extend anti-fraud rules than did the Eisenhower administration. Despite initial antagonism from some parts of the financial sector, the cratering of business during the 1930s led a generation of stockbrokers, investment bankers, accounting firms, and securities lawyers to accept both the new regime of information disclosure and the more extensive prohibitions against market manipulation and insider trading. As SEC career attorney David Silver later recalled, in the post-World War II decades, there were a lot of memories of the trials and tribulations of Wall Street, how the shenanigans of Wall Street really fit into the Great Depression. There was a general perception that the misbehavior of financial institutions had an awful lot to do with what happened in the country. This view was widely embraced within the halls of the SEC, whose staff shared a conviction that honest communication was not only crucial to the proper working of capital markets, but also for their broader democratic legitimacy. Deceptive claims in the booming domain of business franchising attracted similar regulatory attention. This mode of business organization had been a feature of the American economy since the mid-19th century, but it burst onto the suburban landscape after World War II, as franchisers offered American consumers reliability in goods and services, branded clothing, fast food, motels, while achieving the economies of scale that came with a national or regional footprint. Purveyors of retailing concepts liked franchising because it slashed the capital costs and risks associated with expansion while securing the entrepreneurial energies and sweat equity of franchisees. Franchise owners appreciated the business training that they received, the extensive advertising campaigns mounted by the home office, and buy-in requirements that were less than the capital needed to launch standalone small businesses. The meteoric growth of post-war franchising, however, elicited duplicitous sales practices. Plenty of advance fee scams tempted Americans to chase after the dream of proprietorship by throwing their savings at non-existent franchisers. Many prospectuses for legitimate franchising opportunities also downplayed the number of competing franchises in an area and the implications of ongoing financial obligations while exaggerating likely income streams. Beginning in the late 1960s, policymakers took regulatory aim at these problems. Once more, the dominant instinct was to protect would-be small business owners with strategies of information disclosure. Through an array of civil actions brought by aggrieved franchisees, state and federal judges signaled a willingness to treat franchise contracts as investments subject to the New Deal regime of securities regulation. State legislatures also enacted laws that compelled franchisors to furnish prospects with detailed, truthful information about their training programs, ongoing financial obligations, and calculation of franchisee earnings projections. Drawing on the provisions of these state statutes, the FTC followed suit with a franchise disclosure rule. This administrative action, which took a full 6 years to move through the rule-making process, imposed extensive informational obligations on franchisors operating in interstate commerce. The congressional pinnacle of 20th century efforts to curb deceptive retail marketing occurred in 1975, with the passage of the FTC Improvement Act. This legislation gave the FTC authority to combat commercial deceit through its own administrative rulemaking, which could create legally binding standards for industries or even the entire economy. It also augmented FTC enforcement powers. The Commission could now seek substantial fines from businesses that did not comply with cease and desist orders or that violated an FTC administrative rule, as well as financial restitution for consumers harmed by such actions. FTC officials soon flexed their new muscles, notifying scores of corporations about their potential liability for deception-related fines and considering several far-reaching substantive rules. The most consequential, adopted in 1976, did away with the holder in due course doctrine concerning debt collection. This legal standard, once exploited by 19th-century lightning rod salesmen and then a mainstay of urban retailers of durable goods, had long protected third-party holders of consumer debt, such as finance companies, from legal defenses that the underlying commercial transaction had resulted from fraud. Even before the passage of the 1975 legislation, FTC officials experimented with ways to exert more pressure on national advertisers, introducing a policy in 1971 that required corporations to substantiate the factual assertions in their ads and, in the case of a demonstrated lack of substantiation, to run corrective advertising that alerted consumers to prior questionable claims. In addition to targeting specific marketing deceptions or extending the enforcement powers of existing agencies, states and local governments established many new bureaucratic beachheads against consumer fraud. Some states followed the path blazed by Louis Lefkowitz in New York, carving out consumer protection offices within the Office of the Attorney General. Others created standalone consumer protection departments or agencies. By 1974, all but 6 states had also codified their legal regulation of consumer fraud through general consumer protection statutes, following one of 3 basic approaches. In 13 states, legislatures enacted little FTC acts that borrowed the broad statutory language that had created the federal agency's anti-deception jurisdiction. These states all gave some department investigative authority and bestowed enforcement powers such as cease and desist orders, injunctive remedies, and restitution mechanisms. A few went so far as to proscribe misleading claims. Other states embraced the basic framework of 2 model consumer protection laws developed in the 1960s by legal scholars, legal elites, and good governance bodies, such as the National Conference of Commissioners on Uniform State Laws. The first of these, the Uniform Deceptive Trade Practices Act, UDTPA, laid out several categories of prohibited marketing tactics, including misrepresentation of the geographic origin of goods, disparagement of goods, services, and businesses, bait advertising, and price misrepresentation. Rather than relying solely on criminal enforcement or administrative action by a state agency, the UDTPA created private actions that could be brought by affected consumers. The second effort, the Uniform Consumer Sales Practices Act, UCSPA, was the least common legislative template. It targeted an even wider set of commercial transactions, proscribing unconscionable as well as deceptive behavior by merchants. It further gave the state agency charged with overseeing consumer protection issues the power to bring class action civil suits on behalf of consumers. Amid the institutional ferment and confidence in robust government that characterized the late 1960s and early 1970s, urban officials joined the anti-consumer fraud bandwagon. Major cities such as Boston, New York, Jacksonville, Louisville, Chicago, and Seattle passed local ordinances that codified prohibitions against deceptive marketing and established their own offices of consumer affairs or consumer protection agencies. This flurry of institution building was matched by metropolitan county governments such as Long Island's Nassau County, Maryland's Montgomery County, and southern Florida's Dade County. The rise of consumerism also had far-reaching impacts on the realm of business self-regulation. BBB officials recognized that as unions created consumer offices to assist their members, as dozens of independent consumer groups emerged, and as more and more states and cities established consumer protection agencies, advertising and marketing self-regulation faced powerful new institutional competitors. These developments expanded both the number of voices seeking to shape anti-fraud policy and the potential venues for registering consumer complaints. BBB leaders such as Denver's W. Dan Bell pointed to the tide of consumer regulation as they sought to persuade local and national businesses to increase their financial support of advertising self-regulation. As early as 1961, Bell berated other BBB managers and his own membership about the grave dangers facing the Better Business Bureau movement. The AFL-CIO's consumer counseling program and the reemergence of professional consumer groups, the looming creation of a Colorado State Consumer Fraud Bureau or even a federal Department of the Consumer, the emergence of exposure books such as Vance Packard's The Wastemakers and Frank Gibney's The Operators, which stoked mounting expressions of suspicion and distrust from consumers about American business, all of these developments threaten to siphon away an inestimable amount of self-regulation and BBB strength. Unless the business community replaced its token financial backing and lip service with resources to sustain meaningful self-regulation, Bell and other BBB executives warned, there was reason to worry about the survival of the kind of economy under which America had grown to greatness, the free enterprise system. A consensus also emerged by the end of the 1960s that the BBBs required not only more funding, but also a fundamental reorganization. Centralization of authority and a new Council of Better Business Bureaus, the thinking went, would improve the consistency of operations and allow individual BBBs to receive some income from the national organization, lessening dependence on local businesses. This approach would also enable the BBB network to make substantial investments in information technology to improve management of the overwhelming bits of information that crowded into BBB offices. A 1969 management consulting study by Knight, Gladioh, and Smith called for all of these changes, ratifying proposals that had long circulated among the Bureau's leaders. The BBB network immediately set about implementing them, without significant objections. For the BBB old guard who worked either at the national level or in metropolitan areas that were part of the Northeast, the Midwest, or the West Coast, the Bureau network needed to accommodate a historical transformation that was too strong to simply oppose. These leaders, including Kenneth Barnard, Victor Nyborg, John O'Brien, who had a long career running BBBs in Akron and St. Louis, and Edward Gallagher, who had run the Boston Bureau for decades, had spent their working lives learning how to cooperate with the steadily expanding anti-fraud state. Their strategic sensibilities meshed with the moderate conservatism of an Eisenhower or Lefkowitz. They accepted the basic structure of the welfare state and more vigorous anti-fraud policing, but looked to soften public antagonism toward business. These figures had built close relationships with anti-fraud regulators from both parties, though they leaned toward Republican regulators such as Earl Kintner, who were strong supporters of business self-regulation. To veterans of truth in advertising campaigns, the social and political transformations that had put Kennedy and Johnson in the White House were irreversible. With consumer protection occupying a central position on the nation's policy agenda, they argued that the BBBs had to maintain a critical distance from business and deepen working relationships with consumer groups and governmental consumer protection agencies, so that its officials might continue their roles as regulatory brokers. Unless the organization adapted to consumerism, recognizing the permanence of this consumer voice movement and moving to join it in a more positive way, the BBBs ran the risk of becoming irrelevant. If the network did adapt, it could take advantage of its favorable reputation, indicated by both opinion polls and the frequency of public contacts with local BBBs, to shore up its position as a respected, independent guardian of commercial morality, an even-handed informal court of appeals for the customer. The goal, as one insurance executive with close ties to the BBB movement argued in the fall of 1971, was one of triangulation. Find the point in the center of, but equidistant from, business, the Federal Trade Commission, and Ralph Nader. In Chicago, longtime BBB head Kenneth Barnard followed this logic in responding to proposals for the creation of an Illinois Bureau of Consumer Fraud. Barnard supported the idea, though only if the new agency would concentrate on prosecuting the worst offenders, thereby increasing the leverage that BBB officials could exert on firms. For officials such as Victor Nyborg, this kind of political flexibility would not only make anti-fraud work more effective, but also inoculate bureaus against charges of always needing to be against everything. The BBB strategy of triangulation further extended procedural protections for businesses that ran afoul of its standards for truth in advertising. In 1971, the Advertising Federation of America, the American Association of Advertising Agencies, and the Association of National Advertisers agreed to the creation of a National Advertising Review Board, NARB, which would be run under the auspices of the newly formed Council of Better Business Bureaus, CBBB. Drawing on proposals that had circulated among BBB officials since 1960, as well as a British system of advertising self-regulation that had begun in 1962, the NARB comprised 5-person panels selected from 50 board members, 30 executives from national advertisers, 10 representatives of the advertising industry, and 10 independent experts on marketing who were to represent the public. It heard cases of alleged marketing deception whenever advertisers disputed the findings of the CBBB's newly formed National Advertising Division, NAD, which had the responsibility of monitoring television, radio, and national publications and assessing allegations of misrepresentation. The NARB could also take jurisdiction whenever a public complainant objected to an NAD ruling that an ad was not so deceptive as to merit action. The procedural mimicry of the administrative state by the BBBs did have limits. Local BBBs did not institute formal hearings in advance of decisions to issue a NIPI directive against an advertiser, nor ensure that the official who authorized the NIPI did so without any prior knowledge or involvement in the case. Most bureaus did not create review boards of any kind, and those that existed did not, like the NARB, create a public record of their proceedings and determinations. Indeed, when the Little Rock BBB's Advertising Review Board experimented in the mid-1960s with the creation of written rulings and a requirement that media outlets abide by NIPI declarations as a condition of BBB membership, the FTC ruled that such formal processes overstepped the bounds of legitimate self-regulation, shading over into the realm of illegal restraints on trade. In order to skirt similar legal concerns, the ad industry limited the NARB's sanctions to publicity and formal referral to the appropriate federal agency, usually the FTC. Still, the day-to-day regulatory efforts of BBBs testify to the salience of due process as a post-war institutional ideal. The anti-fraud institutions created during the late 1960s or 1970s relied heavily on young Turks fresh out of college or law school, sometimes with an internship or a year or two of work for community organizations under their belts. In the state and local consumer protection agencies, many leaders were true believers with experience in the consumer movement rather than politicos who spied a popular wave. Several of these appointees came from the growing ranks of activist lawyers. Philip Schrag, consumer advocate in the New York City Department of Consumer Affairs, DCA, had served as a community lawyer working for the National Association for the Advancement of Colored People, NAACP, Legal and Educational Defense Fund. Others hailed from the Journalists' Consumer Beat or came up the ranks of government agencies with consumer-related missions. In Minnesota, the head of the State Consumer Service during the early 1970s, Sherry Chenoweth, had covered consumer issues as a local television reporter. The inaugural head of the Los Angeles Consumer Affairs Bureau, Fern Jellison, had several decades of experience in the city office charged with regulating charities. In Chicago, Jane Byrne became the head of that city's Department of Consumer Sales, Weights and Measures after years of Democratic Party activism and positions in city anti-poverty programs. One of the most prominent local consumer agency leaders, New York City Commissioner of Consumer Affairs Bess Meyerson, turned to consumer protection from a career as a model and television actress that had been kick-started by her winning the Miss America pageant in 1945. Although Meyerson faced derision upon assuming office, she used her celebrity status to expand public awareness of consumer programs and build political support for them. Regardless of the career avenues that led to leadership in local consumer protection bureaucracies, these positions attracted energetic figures who embraced consumerism and policy experimentation. In numerous policy domains, the New Deal and Cold War eras generated state building predicated on linkages to a dense network of quasi-public and non-governmental institutions. The national defense establishment drew on the analysis furnished by social scientists based in universities, think tanks, and nonprofit organizations. The New Deal farm state incorporated not only new programs within the Federal Agriculture Department and companion state-level agencies, but also a complex set of organizations that spoke for farmers and farm workers, as well as elected committees of local farmers who had responsibilities for implementing federal agricultural programs. Regulatory governance over the content of American film, radio, and television relied on industry self-regulatory bodies. Post-World War II federal grant programs in healthcare and higher education depended on quasi-public mechanisms of accreditation. The laboratory of the American anti-fraud state mirrored these other complex regulatory ecologies. By the mid-1970s, the anti-fraud terrain encompassed not only a thicket of public laws and administrative rules adopted by every level of government, but also myriad public and quasi-public agencies, as well as a burgeoning army of private watchdogs and gatekeepers. Within all of these institutions, regulatory protagonists shared, for the most part, the premises that Warren Magnuson had articulated in his preface to The Dark Side of the Marketplace. Consumer and investor protection, including protection against mendacious businesses, was a fundamental element of government. American marketplaces should not operate according to the unforgiving logic of caveat emptor. As FDR had argued in his message to Congress on securities regulation, sellers had obligations to customers, competitors, and the wider society. They too needed to look sharp lest they run afoul of the many legal prohibitions against dishonest marketing and the mushrooming public and quasi-public institutions charged with enforcing them. Consumer activists such as Colston Warren, the Amherst economics professor and longtime president of Consumers Union, and business regulators, including Republicans such as Louis Lefkowitz and FTC Commissioner Paul Rand Dixon, pressed this argument repeatedly. They insisted that caveat emptor has now become outmoded and caveat venditor must be the foundation of the marketplace, that protection from some business frauds cannot be afforded except by government protection, that the obsolescent and socially destructive idea of caveat emptor should be appropriately buried as a relic of the days of simple markets and well-understood commodities. A diverse chorus of voices from the business community ratified this turn away from caveat emptor. As early as 1960, the Advertising Federation of America characterized the legal principle of caveat venditor as a fact that advertisers ignored at their peril. By the late 1960s and early 1970s, this premise suffused business discourse. A Rhode Island paint dealer who wished to boast of his quality products could title a newspaper advertisement Caveat Venditor, while a manufacturer of construction materials could trumpet in its 1972 annual report that it had long ago replaced caveat emptor with the principle, let the buyer have faith. Even the conservative United States Chamber of Commerce conceded that commercial fraud was everybody's problem, everybody's loss. The inclination to bow before the dictates of consumerism did not quash disagreements over the best means to hold mendacity in check, nor disputes over how tightly constraints on sellers should pinch. In his 1969 message on consumerism, for example, Richard Nixon drew distinctions between his views and those of many consumer activists and Democrats. His steadfast commitment to a buyer's bill of rights, Nixon explained, did not mean that caveat emptor had been replaced by an equally harsh caveat venditor, nor that government should guide or dominate individual purchasing decisions, a view that pleased the conservative Chicago Tribune. The Chamber of Commerce accepted that consumer fraud was a national problem, but still worried about excessively rigid and cumbersome anti-fraud legislation and preferred solutions that depended on mechanisms of business self-regulation. For all the efforts of BBB leaders to cast their organization as a militant instrument of impartial enforcement and a steward of the public trust, they embraced negative conceptions of economic liberty associated with American conservatism. The BBB's core mission was to safeguard the free enterprise system, whether from confidence-sapping swindlers and chiselers, heavy-handed government bureaucracies, or impatient and unfair consumers. The politicians and interest groups with such viewpoints did not shy away from voicing their concerns in debates over fraud policies. Because of their influence, even the most aggressive anti-fraud legislation emphasized regimes of information disclosure that would empower consumers and investors to make better choices. And in states controlled by Republicans or conservative Southern Democrats, consumer fraud measures stressed cooperation with the business establishment. Nonetheless, it is striking how often participants in the 1960s and 1970s debates over anti-fraud policies framed the formal shift away from caveat emptor in epical terms. In reviewing The Dark Side of the Marketplace, Morton Mintz, a Washington Post political reporter, commented that the older injunction that buyers beware should have died centuries ago and been buried alongside those primitive deities in whose names millions of goats, sheep, and virgins were sacrificed. Before a 1971 audience of business executives, Elizabeth Hanford, Nixon's deputy assistant for consumer affairs, remarked that the days of caveat emptor are past, and the days of caveat vendor are at hand. Even a professor of marketing at a Louisiana university, writing in 1974 for a publication read chiefly by sales managers, judged that the United States had entered a new and extended era in which the possibility of class action suits, coupled with the adequate enforcement of federal and state consumer legislation, means the seller also must beware. The day of caveat vendor is here. The exclamation point suggests the degree of confidence in the durability of this new regulatory world. We shall have occasion to revisit this confident prediction of a new age of legal antagonism to the business cheat in light of contrary developments over the subsequent 4 decades. For the moment, we should take note of its central assumptions about the educational force of new anti-fraud rules and the impact of fraud enforcement. New language in the statute books, the daily compilations of rules in the Federal Register, and the pronouncements of state and local consumer protection agencies did not necessarily transform legal and commercial culture. Policy innovations did not automatically remake norms nor elicit adequate enforcement in the 1970s any more than in the 1870s, 1920s, or 1950s. Retracing paths of education and enforcement. The early 20th century movement for truth in advertising had invested first and foremost in public outreach, on the theory that the best way to constrain fraud was to inoculate potential victims against the enticements of get-rich-quick promoters, slick salesmen, and deceptive ads. The BBBs had retained this focus after World War II. As consumerism gained momentum in the 1960s and early 1970s, every anti-fraud organization, whether established by statutory authority or private initiative, did likewise. Investments in public education were cheap and embraced by politicians across the political spectrum. Who could object to attempts to steel investors and consumers against the wiles of the shape-shifting sharper? The flurry of informational posters, booklets, and pamphlets emanating from anti-fraud organizations intensified after 1960. Public education efforts turned to short films such as The Fine Art of Fraud, a 20-minute overview of fraud techniques produced by the New York Attorney General's Office in 1966, radio and television spots, and consumer-related high school and college curricula. Whatever the medium of communication, the content mirrored the basic messages conveyed by anti-fraud journalism. Most materials explained prevalent swindles and recommended that investors or consumers rely on professional experts to guide their economic decision-making. In case these messages did not hold the rip-off artists at bay, public education campaigns implored victims not to suffer in silence, but rather to be public-spirited and make a big squawk. Like their counterparts earlier in the century, post-World War II anti-fraud organizations argued that, by making known your dissatisfaction, you may save others from being victimized. The consistent plea, like the messaging of the NACM during their progressive-era battles against credit fraud, was one of social obligation, to help protect others by making it more difficult for the disreputable retailer to do business. To facilitate such communitarian goals, anti-fraud communications, such as a 1966 poster from the New York State Attorney General's Office, made a point of explaining where consumers or investors could seek assistance from non-governmental consumer groups and state agencies. They also detailed how to put together an effective complaint. For all the heightened attention in the 1960s to commercial predation faced by the urban poor, the educational materials produced by the anti-fraud state targeted a middle-class audience. In beseeching readers to run investment ideas by a banker or financial advisor, the authors had professionals and small business more in mind than day laborers or the rural poor. The Fine Art of Fraud included dramatizations of bait-and-switch marketing by a travel agent hawking European vacations to a pair of white school teachers, as well as a high-pressure pitch for a referral selling scheme made by a cultured salesman to a prim white couple in their comfortable suburban home. These were not the scams operating in the Puerto Rican neighborhoods of the Bronx, on the south side of Chicago, across the Watts neighborhood of Los Angeles, or in the hollows of Appalachia. Graphics and consumer protection pamphlets reflected comparable expectations about readership. For the Washington Attorney General's Office, the image of the consumer who had to watch out for bait-and-switch advertising was a well-coiffed, middle-aged white woman. When Pennsylvania's Bureau of Consumer Protection, BCP, crafted a buyer's Bible, its choice of a prototypical purchaser was Conrad Consumer, an average family man depicted in cartoon form as a young middle-class white father in a cardigan sweater. In the wake of the 1960s summer riots that devastated poor neighborhoods in many large cities, the new consumer protection agencies and older self-regulatory agencies brought educational messages more directly to those inner-city communities. In addition to setting up branch offices, state and local anti-fraud organizations put out Spanish-language versions of publications, equipped mobile outreach buses that could bring pamphlets and seasoned anti-fraud professionals to city neighborhoods, and participated in local consumer fairs. New York City's BBB hired African-American consumer specialists to staff its new Harlem branch and commissioned the film Just Sign Here, which focused on frauds endemic to poorer communities rather than schemes that targeted those higher up the income ladder. At the national level, the FTC established a companion consumer protection office for the District of Columbia, held a series of hearings on inner-city consumer fraud, and prioritized the hiring of African Americans for the Consumer Protection Division. Community-based consumer and civil rights organizations, which possessed far more legitimacy within poor urban neighborhoods than most state or business-linked agencies, launched their own educational efforts. In Philadelphia, CEPA's monthly newspaper, Consumer Voice, mixed in-depth reporting on the marketing abuses afflicting poorer consumers with a hard-edged editorial posture. In San Francisco, the anti-poverty organization Bay Area Neighborhood Development, BAND, set up a network of offices to assist consumers. BAND produced booklets that warned low-income residents about all manner of consumer deceptions, imploring readers, "Fight back! Don't let the gyp artists get away with it!" Regardless of the social milieu generating the outpouring of anti-fraud instruction, one might be tempted to see it solely in terms of the unending struggle to wise up individuals, whatever their ethnicity, race, gender, or social class. But a key goal of outreach, in this period as much as the Progressive Era, was to buttress social norms against manipulative modes of selling. State and local anti-fraud agencies also followed their predecessors in building informational networks and clearinghouses. Attorneys general built mechanisms to collect timely intelligence on fraudulent business activity in their states and to share that intelligence with state agencies, local police departments, and prosecutors. Louis Lefkowitz's office again laid the foundation for such initiatives during the late 1950s and soon attracted imitators. In 1962, Maryland Attorney General Thomas Finnan asked the state police to establish a special six-man intelligence unit to aggregate information from local authorities about prevalent rackets and identify emerging statewide trends. By the mid-1960s, the Consumer Fraud Unit of the California Attorney General's Office had developed a far more ambitious framework, using reports that came in from local police and prosecutors as a basis for multi-county fraud investigations and statewide criminal crackdowns. Other states developed variations on this approach, including policy councils that brought local prosecutors together with state officials responsible for consumer fraud, and statewide computer databases on fraud investigations and prosecutions. These more sophisticated enforcement networks facilitated a growing number of city-specific and statewide prosecutorial sweeps, which targeted the chicanery that went on in many automobile dealerships, home improvement companies, television repair shops, and purveyors of miracle health cures. On occasion, local law enforcement moved in response to specific newspaper exposés and indignant editorial demands for action. With the rising tide of consumerism, more prosecutors saw great value in gaining notice as inveterate foes of rackets. Press releases, newsletters, and annual reports from these agencies trumpeted statistics and capsule summaries of successful enforcement actions, such as criminal convictions, fines, injunctions, consent decrees, and orders of business dissolutions. So, too, did a steady stream of articles on consumer fraud enforcement produced by attorneys general, heads of consumer protection offices, and district attorneys for law reviews. Sometimes, state-driven undertakings even zeroed in on larger business frauds with national reach. In the early 1970s, authorities in more than 30 states drew on their new anti-fraud powers to shut down Glenn Turner's pyramid sales schemes, which he had organized through the Coscott Interplanetary and Dare to Be Great corporations. Turner's business model involved selling cosmetics and then motivational books and tapes through multi-level distributorships, in which franchisees earned income through commissions earned by recruiting new franchisees. He pitched these distributorships through revivalist weekend-long meetings held in convention centers. From Oregon to Michigan to Mississippi to Maryland, state prosecutors brought dozens of successful injunctive proceedings and criminal cases against Turner Enterprises and mid-level franchisees. The Turner cases attest to the networks that state and local anti-fraud officials built to share policy ideas and enforcement techniques. Fraud fighters met at conferences convened by the National Association of Attorneys General, NAAG, and the Department of Justice. The NAAG published annual surveys of consumer fraud regulation, compiling statistics on consumer protection budgets and staffing and tracking legislative and administrative trends. Such efforts were accompanied by an uptick in academic scholarship on investor and consumer protection, as well as in news coverage. Ideas about how to combat business fraud circulated through all of these channels, encouraging national convergence of anti-fraud strategies. In part because of this deepening anti-fraud network, the champions of consumerism remained aware of the enduring obstacles that confronted criminal fraud prosecutions and administrative anti-deception proceedings. By the early 1970s, the legal system's soft treatment of fraudulent business owners and white-collar criminals more generally was considered commonplace by prosecutors and legal sociologists. Recognition of this pattern also seeped into popular sentiment, sometimes prompting indignant protest after guilty verdicts for prominent businessmen led only to trifling sentences. In 1975, after a prominent San Diego banker received a suspended 2-year sentence for a multi-million-dollar bank fraud, readers of the Los Angeles Times seethed in anger. To the 25 letter writers moved to comment about legal proceedings a 2-hour drive away, the case showed that America operates 2 systems of justice, one for the rich and powerful and another for the poor and powerless, that electric chairs ain't for millionaires, that you can't send Mr. San Diego to jail. The men and women charged with running consumer protection agencies knew all about cases such as Holland Furnace and were determined to avoid such outcomes by taking tougher stances toward deceptive sellers. They had fought hard to gain access to more potent enforcement tools, such as the power to ask for injunctions, dissolutions of incorporation, and mechanisms of compulsory restitution. In the most egregious cases, state and local consumer protection agencies deployed such authority to good effect, every year shutting down hundreds of abusive retailers and service providers. As with late 19th century postal officials and early 20th century regulators at the FTC, anti-fraud reformers of the late 1960s and early 1970s hoped to sidestep the inefficiencies of the criminal justice system through more nimble modes of regulatory governance. Had consumer protection champions possessed a deeper grasp of history, they might have tempered their expectations. Forceful anti-fraud tactics tended to generate complaints about autocratic governance that ran roughshod over individual rights and American values, which then prompted adoption of procedural protections, which in turn limited the effectiveness of administrative remedies. Post-World War II proceduralism deepened the democratic legitimacy of anti-fraud regulation, but at the cost of extending the rights of accused businesses, whether in criminal or administrative contexts. Such safeguards, in combination with judicial skepticism about business fraud cases, often stymied expeditious redress for consumers. Although New York City armed its DCA with the power to ask for injunctions against deceptive firms, the city's judiciary and the clerks on whom they relied for advice frowned on the rapid-fire action contemplated by Mayor John Lindsay's administration and its consumer protection officials. Even in cases with extensive documentation of predatory behavior by businesses, some members of the New York City bench harbored concerns about issuing injunctions, believing they should only be granted sparingly before a final court finding that firms had committed fraud. The resulting delays could sour victims on consumer protection agencies, convincing them that there was little justice to be found through recourse to the new champions of consumer rights. Once again, the effectiveness of anti-fraud agencies depended on the extent of funding. During the 1960s and 1970s, state legislatures in heavily industrialized states such as Illinois appropriated sums for consumer protection bureaus that allowed them to establish several satellite offices. In some of the largest cities, urban consumer protection bureaus had budgets and staffs of even greater size. A few suburban agencies, like the one in Long Island's Nassau County, received significant resources. By the early 1970s, it enjoyed a $376,000 budget, enabling it to employ a staff of almost 50. But American proceduralism often went hand in hand with budgetary stringency for regulatory agencies. Congress, state legislatures, and city councils proved far more willing to adopt new regulatory schemes that targeted hucksterism than to appropriate generous sums for implementation. Most public agencies charged with enforcing anti-deception law operated on a shoestring. Consumer protection divisions within the Attorney General's office or standalone consumer protection agencies usually had only a few staff members. Funding for city and county consumer bureaus proved even less munificent. The Los Angeles Bureau of Consumer Affairs launched in 1972 with only 21 salaried personnel to police marketing practices in a city of almost 3 million, only one fraud catcher for every 166,000 people. It enjoyed that many staff only because the city was able to obtain a federal grant to defray the costs. During the early 1970s, the entire city of Philadelphia relied on the efforts of a consumer affairs staff of just 3 people. When the Prince George's County, Maryland Consumer Protection Commission opened its doors in 1970, it had only a single commissioner and 2 assistants. Most consumer agencies, moreover, had a responsibility for a much wider set of consumer issues than just combating commercial duplicity. At the New York City DCA, a staff of 350, around 50 of whom worked for the Enforcement Division, still groaned under the weight of tens of thousands of annual consumer complaints. Matters worsened considerably in the mid-1970s when the city's fiscal woes led to budget reductions. Like public anti-fraud regulators, self-regulatory organizations confronted the problem of insufficient bureaucratic capacity. After years of rapid growth in the number of BBBs, member businesses, and collective financial resources, the 1960s brought relatively flat budgets, even as demands from consumers, businesses, and governmental agencies intensified. The BBB network expanded by an additional 22 locals between 1962 and 1972, but the total funds for operating budgets did not keep pace, approaching only $9 million in pledged memberships by 1972, just $2 million more than in 1962. Pinched budgets led to staffing shortfalls and associated declines in the quality of service. A 1971 report on the BBBs, undertaken by several law school students at the direction of New York Congressman Benjamin Rosenthal, chronicled the impacts on organizational performance. Pressed to respond to all the letters, phone calls, and consumer visits, many bureaus sharply curtailed their public hours. Even though this move rationed access and created consumer frustrations, the BBBs still battled to keep track of all the information that they received. As the reliability of their files diminished, many consumers who managed to get through to BBB employees received false impressions when they inquired about businesses. The Rosenthal report, modeled on the Nader-funded assessment of the FTC, further found that budgetary pressures had led most local bureaus to compromise some of their most basic moral commitments. Many had outsourced recruitment of new members to sales companies that engaged in high-pressure sales tactics and no longer screened new members to check on reputations, nor expelled members that repeatedly violated BBB standards. Most of these conclusions echoed the pronouncements of the confidential analysis of the bureaus conducted by the management consulting firm Knight, Gladue, and Smith in 1969. Together, punctilious proceduralism and tight budgets raised the likelihood that grievances about deceptive selling practices would take a long time to wind their way through the system, widening the practical openings for quick kills, or fall through bureaucratic cracks altogether. The publicity surrounding the inauguration of state-local consumer protection offices, in conjunction with a more general societal embrace of consumerism, only heightened such pressures. That publicity elicited a torrent of complaints, which immediately taxed investigative and adjudicative capacities. One common strategy was to turn to volunteers who could assist with monitoring and complaint-taking, much like the 19th century journal subscribers who answered the calls to become informal anti-fraud sentinels. Thus, in the late 1950s, New York Attorney General Louis Lefkowitz convened a statewide committee of 100 housewives to serve as unpaid adjuncts. These middle-class women likely had experience working with community organizations. Some may have participated in the citizen networks that monitored World War II consumer price regulations. Lefkowitz asked the volunteers to observe conditions which affect the purse strings, channel consumer complaints to his Consumer Protection Office, and serve as community spokespersons who would alert and educate the buying public in the techniques of slick salesmen. The Attorney General also drew on unpaid law student interns who processed less complex consumer complaints. Over the subsequent 2 decades, most state and local consumer agencies developed similar strategies. In some cases, as in the California Attorney General's office during the early 1970s, agencies recruited volunteers to serve as mystery shoppers who visited stores to assess the validity of advertisements and sales practices. Reliance on volunteers and interns extended regulatory footprints. The Office of Consumer Protection in New Jersey's Burlington County, created in 1969, had only 2 salaried staff members. But after the creation of a volunteer army of 50 persons in 1971, as well as a weekly local radio show that solicited complaints, it was able to handle a much larger caseload. Despite such measures, many of the new consumer protection agencies struggled to satisfy complainants in much the same fashion as local BBBs. All too often, consumers encountered recurrent busy signals, delays before investigators could look into their allegations, or referral runaround, as overwhelmed complaint takers directed them to other consumer protection bureaucracies. Confusion over which local, state, or federal agency to approach became commonplace. So did dissatisfaction with the pace of regulatory action. In many cases, formal proceedings within local or state consumer affairs offices bogged down in a procedural morass, leading angry citizens to throw up their hands in frustration after struggling through phone calls, letters, or visits to multiple agencies. The most jaded consumer protection officials tried to deflect unhappy consumers as much as solve their problems. The most well-intentioned often felt as if they were sitting at the bottom of the ocean bailing with a tin cup. In spite of intention and occasional practice, the anti-fraud monitors came to function as a mediation service. In 1962, the Illinois Attorney General had described the new Consumer Fraud Bureau, CFB, as dedicated to prosecuting merchants who habitually employ fraud. A decade later, the CFB instead proclaimed that it was the face-to-face legal representative of the citizen who feels that he has been duped or wronged in a consumer transaction, and that its chief goal was recovering the individual's money whenever possible. The strategic preferences of consumers and businesses encouraged this bureaucratic reorientation. Although some consumers took on the roles of communitarian guardians and asked for public-oriented remedies such as prosecution, most prioritized the righting of their own personal injustices. In one comprehensive study of an Illinois Consumer Protection Office, 7 in 8 complainants referenced only their desire to hold a business to what they perceived to be a contractual promise or to receive their money back. Thus, only 1 in 8 complainants voiced a desire for punishment or concern that a business not harm others. The most unscrupulous business cheats, like their counterparts in earlier periods, frequently took advantage of such inclinations to cool the mark out, in the language of the grafter, to pacify a mark after he has been fleeced, often by extending partial refunds to indignant customers. When the business managers of more reputable firms confronted allegations of deceptive behavior, they similarly looked to find some accommodation that would assuage consumer anger while minimizing financial repercussions. Limited institutional resources pressed consumer protection agencies in the same direction. Staff members at these agencies received an avalanche of complaints, most of which did not involve clear-cut evidence of misrepresentation or fraud. They had little option other than to focus on cases that seemed amenable to quick resolutions, that would offer complainants at least partial satisfaction, and that would allow businesses to sidestep admissions of bad faith. Many agencies reported that 9/10 of their staff time went into efforts to use dialogue to bring about reconciliation of the disadvantaged consumer and the businessman. In the rare cases where consumer protection agencies opted for sterner legal process, such as motions for an injunction or criminal prosecution, the most common outcome was still either some form of monetary settlement for complaining consumers or a promise of more complete contractual performance. This emphasis on retrospective compromises meant that every year tens of thousands of American consumers who asked for assistance from consumer protection bureaus received some form of redress. Over time, the data that accumulated from the stacks of individual grievance forms also allowed anti-fraud professionals to identify patterns of behavior by businesses that justified the expenditure of resources on sterner enforcement measures. Staff members at consumer protection bureaucracies toted up the resulting restitutions, and then pointed to those figures as concrete measures of their work on behalf of consumers. Every year during the mid-1970s, for example, Kansas consumers received several $100,000 in refunds as a result of interventions by the Attorney General's Consumer Protection Division, and had hundreds of contractual promises fulfilled. Such figures, however, represented only a small fraction of the most common estimates of annual losses imposed on the U.S. economy due to business fraud, which ran into the billions, though, as in the early 20th century, the people who offered such estimates never explained their method of calculation. The institutional preference for negotiated settlements further allowed a great many unscrupulous businesses to retain the long-standing strategy of the squawk fund. Rather than forsake misleading or even predatory styles of selling, they furnished refunds to insistent customers and paid the occasional fine, treating such payments as merely part of the cost of doing business. For the sternest advocates of consumerism, the dominance of mediation at consumer protection agencies elicited frustration and disillusionment. Philip Schrag set the tone for movement toward self-evaluation in his widely read 1972 memoir, Counsel for the Deceived: Case Studies in Consumer Fraud. Schrag might have subtitled the book The Education of an Activist Regulator. Drawing on his experience at the New York DCA, he chronicled just how hard it was to bring hucksters to heel, even with dedicated staff and the capacity to draw on significant investigative powers and coercive sanctions. Within just a few years after the launch of this expansive regulatory experiment, the initial heady expectations looked hopelessly naive. As Schrag framed his disappointment with his time at the DCA, "I had actually imagined that a good law, properly administered, could wipe out misleading sales practices altogether. Our experiences suggest that given our toleration of the way in which adversary and judicial systems now operate, the amount of resources constituting enough would be more than any government should devote to the problem." For this young attorney-turned-fraud enforcer, the enduring structures of legal decision-making profoundly compromised any reformist aspirations to use regulatory power to cast the worst dissemblers and cheats out of the temples of American consumer capitalism. This assessment, accepted across political divides, prompted a range of strategic replies by consumer activists. One response, forged on inner-city streets and borrowed from militant unions and the civil rights movement, harkened back to centuries-old strategies of legal self-help. Others, popular among intellectuals and policymakers, called for better arming consumers to look out for themselves, either before they entered into transactions or by seeking their own legal remedies if some business took advantage of them. Observers outside the ranks of the consumer movement, however, drew very different conclusions, pleading for renewed faith in the power of the market and at least a partial return to the legal premises that shaped Barnum's America. Before we take stock of Philip Schrag's pessimism about the 20th century anti-fraud state, these cross-currents deserve careful consideration. Chapter 11. The Promise and Limits of the Anti-Fraud State. Philip Schrag's account of battling consumer fraud was not all doom and gloom. The Department of Consumer Affairs achieved some early victories that he took care to document. Schrag was proudest of its takedown of vigilant protective systems, given the moniker Foolproof Protection Incorporated in Counsel for the Deceived. Created in 1968, this firm operated throughout New York City and its environs, selling residential burglar alarms to low-income African American and Puerto Rican families. Vigilant's African American sales force monitored police radio to learn about residential robberies. While the sense of personal violation was still fresh, they paid calls on victims. After commiserating about soaring crime rates, the salesman offered to install state-of-the-art alarm systems connected to the closest police precinct for a free 30-day trial. If customers chose to keep the alarm, they would pay a monthly leasing fee of $14, $20 if a fire alarm was included in the package, but would retain the right to cancel at will and could expect regular maintenance as necessary. Sales agents further promised that the company would never use court process to collect in the case of non-payment. Every one of these claims was false. The company installed low-grade alarms made of cheap components that rang only in the apartment and that burglars could easily disable. Contractual fine print, which many Spanish-speaking customers could not read, committed lessees to 3-year contracts with no right of cancellation, did not reference a trial period, and specified that lessees would owe legal fees if Vigilant had to go to court to compel payment. Vigilance lawyers always pursued court judgments in cases of non-payment, often on the basis of sewer service, not supplying legal notices to non-paying customers, but rather metaphorically chucking those notices into the sewer so that its debtors did not learn about hearings. The company soon became New York City's 5th most active plaintiff. Its salesmen also ignored a New York installment sale law that required distribution of a card that alerted customers, in both English and Spanish, of a 3-day cooling-off period for consumer contracts. Here was an updated version of the 19th-century lightning rod sales routine and the abusive tactics honed by Holland Furnace Company. Vigilance president, Sol Rosen, Sam Stone in Schrag's memoir, had extensive experience with this kind of marketing scheme. After spending a chunk of the 1950s selling deceptive food freezer plans, he started up a finance company that bought debt contracts from predatory urban merchants. Vigilant took his techniques of deception to a new level of sophistication. It was a subsidiary of a publicly traded holding company that skirted disclosure requirements in its financial reports. The holding company had managed to attract $1.5 million in working capital from 4 major New York banks, secured by its customer accounts, as well as an exclusive deal with a major department store to showcase its alarms. All of Rosen's ventures encountered pressure from anti-fraud regulators. In each case, Rosen adopted the common strategies of accommodation and retreat. He accepted a plea deal against the Freezer Plan Corporation that included dismissal of pending criminal charges and later allowed the finance company to go out of business. Within months of its launch, Vigilant faced an investigation by the New York Bureau of Consumer Fraud and Protection. That case ended with a consent decree in which Rosen pledged to discontinue objectionable marketing practices. He and his salesmen ignored its terms. Schrag and his colleagues succeeded in putting Vigilant out of business by 1971, but only by eschewing time-consuming enforcement tools, such as seeking an injunction against the company. There were several twists and turns in the story, including coordination of lease cancellations by almost 400 customers on the grounds that they had not received notice of their cooling-off rights, a threatened business license revocation, and complex negotiations that resulted in a very tough settlement agreement. The key point is that after the DCA received evidence of the firm's ongoing violations of the settlement, it threatened a parallel investigation of the department store that marketed Vigilant alarms and facilitated extensive press coverage about the case, which hurt the reputations of the department store and banks that kept Vigilant afloat. These tactics led to a bankruptcy filing in July 1971 and stimulated enough public uproar that the district attorney brought criminal charges against Sol Rosen. Success in this case depended on creative maneuvers akin to the policy innovations that anti-fraud activists and organizations had concocted since the mid-19th century, from the sandwich board warnings about Peter Funks in antebellum auction districts to postal fraud orders and sundry frauds and humbugs features in 19th century magazines, to the NACM's prosecution fund, to the SEC's stop orders, and the Better Business Bureau's NIPI declarations. As the implementation of consumer protection reforms in the 1960s and 1970s reinforced appreciation for the shortcomings of reliance on traditional legal mechanisms, opponents of business fraud continued to experiment with alternative enforcement strategies. The takedown of Vigilant Protective Systems incorporated several approaches that mirrored the long history of American anti-fraud efforts. One move was to rely on the disinfecting power of public exposure. A second was to find new ways to exert pressure on the business infrastructure that allowed deceptive firms to function, described by Philip Schrag as commercial synapses. These support service providers included advertising agencies, media outlets, law firms, banks, accounting firms, and insurance companies. Finally, anti-fraud bureaucracies looked for ways to reinforce the capacity of disgruntled consumers and investors to vindicate rights on their own, such as by informing Vigilant customers that they had a right to cancel their contracts and encouraging them to do so. These strategies all had limitations, but each, in at least some contexts, was a meaningful weapon against commercial deceit. Officials who turned to such tactics retained a conviction that the state had an obligation to protect investors and consumers from duplicitous marketing. Among American conservatives, there was a contrasting impulse to challenge anti-fraud measures as regulatory overreach, as just one more example of failed statism. This viewpoint found adherents within the realm of business self-regulation, and especially among a newly invigorated vanguard of conservative intellectuals. Elements of this perspective gained ground among some progressive policy elites as well, setting the stage for profound reconfigurations of anti-fraud policies in the final quarter of the 20th century. Exposing deceit in the Civil Rights Era. Philip Schrag used the term direct action to describe the creative maneuvers against Vigilant Protective Systems, evoking the civil rights demonstrations that had been roiling American society since the 1950s. This idiom surely came readily to mind because of Schrag's earlier experience as an NAACP attorney. Perhaps reflecting his socialization into the legal fraternity, the New York City consumer advocate did not think to reference an even more vigorous style of collective protest deployed to pressure notorious business cheats just 100 miles to the southwest. In Philadelphia, the Consumer Education Protective Association, CEPA, had refined the art of securing justice for consumers, including fraud victims, through an assertive style of community self-help informed by militant unionism. This cooperative organization was founded by Max Weiner, a former real estate broker and finance company manager who had seen the predatory side of urban marketing practices. In addition to provision of consumer education tailored for the inner city, the group urged low-income Philadelphians to inform its unpaid staff members about retailers who engaged in bait advertising, phony oral promises, abusive credit terms, and other prevalent consumer frauds. When staffers viewed complaints as meritorious, they advised the consumers in question about how to pursue informal redress. If satisfactory adjustments were not forthcoming, CEPA sent delegations of its members to accompany individual complainants in further efforts to seek accommodation. The next step involved picketing operations, which members committed to join as a condition of receiving assistance themselves. uncooperative business owners could look forward to the arrival of CEPA members equipped with placards, leaflets, and sometimes loudspeakers, who would march in front of the place of business, protesting the injustice and explaining it to passerby. From 1966 through the mid-1970s, CEPA coordinated scores of public protests against finance companies, car dealerships, furniture stores, and other retailers and service providers, both in Philadelphia and outlying communities. CEPA had the wherewithal to pursue targeted businesses for weeks and even months, garnering extensive media attention. The local African-American daily, the Philadelphia Tribune, furnished close coverage, and other local publications ran features on the cooperative and stories on specific boycotts, with state and national outlets also taking note. This publicity drove additional consumer complaints to CEPA. It also magnified the pressure that CEPA could bring to bear on local firms, which enabled it to negotiate hundreds of settlements a year and sometimes persuade the city district attorney to file criminal fraud charges. The amounts refunded through CEPA interventions rivaled those of the consumer protection agencies created by state and local governments. By the early 1970s, CEPA had set up branches in Des Moines, Cleveland, Baltimore, and Washington, D.C., with community activists in other cities explicitly patterning separate organizations on Max Weiner's template. Recognizing the antipathy of most business owners to unflattering publicity, some law enforcement personnel adopted analogous hard-edged tactics. The most flamboyant was Marvin Zindler, a deputy in the Harris County, Texas Sheriff's Office, tasked in 1971 with heading up a new consumer fraud division. Treating consumerism as up there with God, country, and motherhood, and having an uncanny flair for publicity, Zindler wielded his own sledgehammer at Houston businesses accused of deceptive practices. In cases of even small-scale misrepresentations, he coerced businesses into compromises by threatening publicized arrests. Former work as a newspaper photographer and public relations officer in the sheriff's office had given the nattily-attired deputy a wide network among local journalists, as well as insights about how to command public notice. The son of a wealthy Jewish retailer, Zindler had a chip on his shoulder as a result of perceived anti-Semitic slights, as well as an insatiable desire for public recognition. "I want the public to know I'm here to help them," he explained to one journalist, "and the crooks and cheats to know I'll get them." He made his threats realistic by initiating 1,300 criminal fraud cases in the first year of the Consumer Fraud Unit and informing television stations whenever he was on his way to make an arrest, so that the cameras could record it for the evening newscast. Even though Houston prosecutors viewed his cases as unwinnable, and local judges threw out most charges that went forward, fear of bad press led most businesses to agree to consumer settlements, which was always Zindler's goal. This approach attracted thousands of complaints and fawning profiles from local and national journalists. Business owners did not take kindly to such treatment, whether applied by community consumer groups or a maverick law enforcement official. San Francisco's consumer action faced a libel suit from one car dealer outraged by a demonstration. CEPA faced several lawsuits seeking to enjoin them from continuing their pickets. During one moment of widespread inner-city riots, it confronted a mayoral emergency proclamation banning public pickets of more than 12 persons. Marvin Zindler attracted deep enmity from the Houston business establishment. After a new Harris County sheriff took office in early 1973, business groups exerted their own pressure, successfully campaigning for Zindler's firing. American law and journalism nonetheless proved hospitable to this form of anti-fraud discipline. The courts tended to give direct action by consumer organizations a wide berth, so long as they framed their motives narrowly around the redress of specific, defensible consumer grievances. Judges accepted assertions of free speech rights by protesters of commercial injustice, in part because ordinary legal process did such a poor job of handling fraud allegations. And although Marvin Zindler lost his handcuffs and badge, within weeks of his dismissal he started a new career as a reporter for the local ABC television station. Using a consumer affairs segment to retain access to a complaint phone line, he continued to excoriate usurious merchants, unscrupulous auto mechanics, Flushing house siding salesmen, and other con artists, in the same florid style. During this era, media action lines proliferated at urban newspapers and broadcast stations because they tended to attract readers, listeners, and viewers. Numbering over 400 by the late 1970s, they were headed by a consumer affairs journalist, but relied on corps of college student volunteers and middle-class housewives. Although they handled citizen complaints of all kinds, a portion of their work involved allegations of false advertising or deceptive marketing. As with consumer protection agencies, these media departments focused on solving problems through mediation, though always with the threat of a negative newspaper column, radio spot, or television news segment hovering in the background. Very few American cities boasted a crusading figure such as Zindler, even if they possessed a media action line. Nor did every metropolitan area have a savvy neighborhood-based defender of consumer rights such as CEPA. Small towns and rural areas were even less likely to possess such guardians. Where they put down roots, however, they offered meaningful assistance to victims of consumer fraud and some measure of populist deterrence. Pinching off commercial and financial synapses. The idea of placing regulatory pressure on business counterparties of duplicitous firms hardly originated with the New York City DCA. One of the foundational premises of the Truth in Advertising movement had been to close off access of fraudulent advertisers to reputable publications. From the inception of the New Deal, federal securities regulation looked to law and accounting firms to police the truthfulness and completeness of registration statements and financial reports. In the wake of the quiz show scandals of the late 1950s, the FTC also brought some deceptive practices cases against advertising agencies as well as their clients. Before 1965, however, anti-fraud agencies rarely sought to target ancillary firms as a systematic strategy to constrain deceptive behavior by business principles. Thus, the SEC steered clear of efforts to pursue sanctions against the lawyers who furnished services to fraudulent stock promoters unless they helped to plan and execute scams. The FTC's experience in going after advertising agencies nonetheless hinted at how a tough-minded regulatory posture could percolate through corporate practice. At the Westinghouse Corporation, for instance, closer FTC scrutiny prompted new internal rules for the development of ad campaigns. All comparative performance claims would henceforth have to be certified by an accredited independent laboratory, and the firm's ad agency would have to keep affidavits of certification on file. A growing number of regulatory agencies soon embraced the tactic of attacking business fraud through the professional gatekeepers who either facilitated it or looked the other way. The SEC led the way in developing aggressive enforcement actions against fraud-abetting professionals, prompted by a series of cases in the 1960s that came to light as a result of corporate bankruptcies. The typical story involved corporate management who relied on legal opinions or auditor certifications to shield themselves from liability for violating securities laws, perhaps for misleading financial reports, or for delays in release of corrected financial data until after the closing of a corporate merger. Troubled by these instances in which gatekeepers skirted professional obligations, SEC lawyers explored ways to initiate charges against the lawyers and accountants who had blessed deceptive practices. The pivotal case that encapsulated this more aggressive enforcement posture was SEC v. National Student Marketing, brought in 1971. The SEC had already pursued criminal charges against two auditors some years earlier for their actions in the run-up to the bankruptcy of a franchise vending machine company. But only in national student marketing did SEC lawyers charge partners in a major law firm that had an international reputation, and only in this case did the SEC articulate an expansive interpretation of the legal obligations owed by attorneys and accountants when they learned of material misrepresentations by corporate clients. In 1967 and 1968, executives at the National Student Marketing Corporation approached several large-scale corporations about their business model, which was to use part-time college students to create buzz about consumer products on campuses. The company's management used oral agreements as the basis for booking revenues on their financial statements. When most of the oral agreements fell through, they did not disclose the news, but instead rushed to complete several corporate mergers, made possible by the company's inflated stock price. Executives carried out this deception over the objections of the corporation's accountants, but with the assistance of its attorneys. For SEC staff lawyers, this case suggested the importance of laying down two basic principles of professional responsibility. Attorneys and accountants had to correct financial estimates and projections as soon as they realized they were false or mistaken. They also had the obligation to bring such information to the attention of the authorities if their clients refused to act on their advice. The federal courts ruled for the SEC in national student marketing. With consumerism in the ascendancy, and with an embattled Nixon administration seeking to deflect political pressures by appointing anti-fraud hawks as SEC commissioners, staff lawyers felt that they could press forward with the opinion in this case as a guide. Their determination was only reinforced by several large-scale business failures in the early 1970s, including the Penn Central Railroad, equity funding, and Homestake Oil. These debacles all involved evidence of widespread securities fraud and each cost investors hundreds of millions of dollars. As a result, the SEC initiated a series of fraud and non-disclosure proceedings in the 1970s against leading New York law firms and the nation's most influential accounting companies. The avowed point of these proceedings was to buck up the legal and accounting professions, so that their members would be more stand-up-ish with their clients and say no when they needed to say no. Leading architects of enforcement at the SEC, such as Irving Pollock and Stanley Sporkin, took close note of the rapid growth in the securities markets during the 1960s and were horrified by the extent of professional abdication in some of the era's bigger business failures. These developments led them to conclude that the SEC would never have sufficient resources to monitor and police the markets on their own. The only sensible approach, as one longtime staff lawyer recalled the emerging bureaucratic consensus, was to create incentives for the people who are at the access points to the market, the brokers, dealers of the world, the investment bankers of the world, the lawyers and the accountants, and encourage them to police themselves. Accountants had to act in accordance with their duties to the investing public. Corporate lawyers had to remind themselves that their client was in fact the corporation, not senior executives, and that the SEC, with its small staff, limited resources, and onerous tasks, is peculiarly dependent on the probity and the diligence of the professionals who practice before it. Such diligence might cut off access to the financial services required for any large-scale investment deception. The rapid expansion of mutual funds and other institutional investors during the 1960s and early 1970s, moreover, meant that a greater proportion of disgruntled bond or shareholders had the resources to pursue legal avenues of redress. Plaintiffs' lawyers soon explored potential causes of action against defendants with sufficient assets to make civil lawsuits worth filing. After corporate bankruptcies, professional gatekeepers had the great advantage of still possessing assets that one might attack, as did creditors, investment banks, brokerage firms, and corporate directors in their personal capacity. These participants in the securities markets faced an increasing number of fraud-related civil suits, especially after the sharp stock market correction of the late 1960s. SEC regulators and plaintiffs' attorneys kept a close eye on test cases, piggybacking on each other's arguments and scrutinizing judicial opinions for indications of how to proceed with fraud allegations. In addition to pushing for expanded liability for legal counsel and accounting firms, the SEC's enforcement staff also concocted novel disciplinary mechanisms. One option was to suspend or bar individual lawyers or accountants from practicing before the Commission, which in most cases would preclude individuals from working on any securities-related filings. But the SEC tended to focus on remedies that would change how firms conducted core activities. Always conscious of tight budgets, SEC lawyers preferred negotiated consent decrees to litigated cases. During the late 1960s and early 1970s, the dramatic growth in demand for corporate auditing had fostered rapid consolidation in the accounting industry, which in turn generated, as the SEC's head accountant later described it, managerial and control problems of unprecedented magnitude. This diagnosis of auditing shortcomings shaped settlement priorities. SEC officials demanded that accounting firms commit to more searching internal supervision of auditing procedures, as well as regimes of continuing education and training for its accountants and peer review of its work by expert third parties. Such requirements obviated the common defense that in signing off on misleading financial statements, a firm's employees had acted on their own without the knowledge or consent of superiors. Regulators also sought to infuse organizational culture with a stronger commitment to professional obligations and legal compliance, to gatekeeping in the public interest. Within America's legal, accounting, and corporate establishments, the new enforcement landscape occasioned loud complaint, which paralleled earlier critiques of innovative anti-fraud techniques. Objections focused on the alacrity with which the SEC was willing to sully the reputations of leading figures of business, finance, accounting, and the bar, as well as the use of coercive negotiating tactics that compromised due process rights. Legal scholars, securities lawyers, and accounting specialists further raised the specter of unintended consequences. Attorneys might refuse to work for companies with financial difficulties, lest honest mistakes take on a different gloss if the businesses failed, or they might dissuade management from attempting novel, although perfectly proper transactions that could be the daring, imaginative business moves necessary to realize substantial profits. Executives would have to devote far more time to scrutiny of reporting statements, thereby diverting focus from managerial challenges. Fearful about the new limits to attorney-client confidentiality, they might also shy away from asking counsel about thorny disclosure questions, foreclosing the possibility that corporate lawyers would be able to head off proposed actions that might constitute illegal misrepresentation. Within the accounting world, some observers raised concerns that extension of liability to auditors would lead them to reject more challenging audit assignments, and that demands for more detailed reporting of complicated financial data might lead to disclosure pollution, the provision of so much information that investors would become lost in a sea of numbers and clarifying footnotes. Elite discontent prompted institutional pushback, which fed a more general anti-regulatory fervor in American politics. By the late 1970s, the federal courts began to restrict the SEC's most expansive efforts to saddle gatekeepers with liability for corporate misrepresentations. SEC commissioners appointed by Presidents Carter and Reagan, such as Harrison Williams and John Shadd, also toned down enforcement tactics and redirected priorities toward the investigation and prosecution of insider trading. In the short term, however, the campaign against professional facilitators of deception in the securities markets had significant institutional ramifications. Nudged by the Securities Law Division of the American Bar Association, ABA, and the Bar Association of New York City, law firms moved to tighten internal oversight of securities work. They adopted more cautious procedures for dealing with the complex issues that frequently arise under the federal securities laws, sought to inculcate a degree of independence in responding to client pressures, and required a review of legal opinions and registration statements by at least one additional partner. Stung by years of intense criticism, the accounting profession agreed in 1972 to the creation of a new Financial Accounting Standards Board, FASB. Unlike its predecessor, FASB would have full-time members and professional staff. Chastened later in the 1970s by yet more corporate reporting scandals and congressional inquiries that raised fears of direct federal control over accounting standards, the industry further strengthened mechanisms of self-regulation. In 1977, the American Institute of Certified Public Accountants made professional certification more stringent. It also imposed 3-year peer reviews of internal quality controls at member firms and compelled periodic rotation of the main partner in charge of a corporation's external auditing. Such internal governance mechanisms served as counterweights against insistent client requests that law and accounting firms approve misleading financial communications. The reach of the class action lawsuit. Several of the civil securities fraud cases brought against ancillary parties in the 1960s and early 1970s were class actions, in which lawyers filing the suits purported to act on behalf of all similarly situated investors. Those attorneys took advantage of a 1966 restatement of the rules of federal civil procedure, which made such cases much easier to pursue. Under the revised Rule 23, lawyers could bring a civil suit on behalf of multiple individuals so long as they had sufficiently comparable claims. Their allegations raised comparable issues of law, and a consolidated hearing would enhance judicial efficiency. The outcomes of post-1966 class actions pertained to all members of the relevant class, including parties not named in the suit, unless they asked to be excluded in a timely fashion. For consumer activists disappointed by the record of regulatory agencies, the class action beckoned as a way for consumers and investors to defend themselves. It seemed to offer a way around one of the biggest impediments to curbing many business frauds, the small losses typically inflicted on any individual victim, which often did not justify the expenditure of resources necessary to seek redress. Like the securities plaintiffs' bar, several public interest lawyers began experimenting with consumer fraud-related class actions in the 1960s, drawing on experiences with civil rights suits premised on the tactic. A 1964 case brought by a young Los Angeles attorney on behalf of the city's taxi riders suggested the potential for this form of collective lawsuit. The case involved rigged meters on the city's yellow cabs. In 1963, former maintenance employees alleged that for several years the company had deliberately set meters to run fast, resulting in systematic overcharges of between 3 and 5%. These charges were aired by a Miami cab company hoping to break into the Los Angeles market, which at that point remained a regulated monopoly. An eventual grand jury investigation cleared yellow cab owners of intentional deceit, as they had bought the company well after the meter rigging had occurred. But public testimony to the Los Angeles Board of Public Utilities created an extensive evidentiary trail about the episode. Able to draw on this record, the young lawyer, David Darr, filed a civil suit, taking advantage of a little-used provision for class actions that had been part of California civil procedure since the 1870s. Yellow Cab persuaded a state superior court judge to deny certification of the class on the grounds that cheated taxi riders had suffered varying losses and that there would be no way to identify wronged individuals or precise amounts lost, and so no way to apportion refunds. The state Supreme Court, however, reversed this ruling, accepting Darr's argument that the class action existed for such situations. that separate actions would be economically infeasible, and that the basic issues of law and fact were the same, even if the precise amounts at issue were not. Darr eventually wrung a negotiated settlement out of the company that incorporated innovative remedies. Because direct compensation to millions of people was impossible, Yellow Cab instead agreed to reduce its fares by a total of $1.2 million over the following 7.5 years, and to allow Darr to serve, along with the city's taxi regulator, as co-monitor of the company's compliance with the agreement. News of Darr's victory circulated among consumer groups, prompting keen interest in class action lawsuits as a means to furnish restitution to the victims of business fraud. The basic idea of enabling victims of relatively small-scale frauds to band together to pursue relief attracted support from both militant and more moderate consumer groups. If business firms can bilk in bulk, the New York City consumer activist Mark Green argued, then consumers should be able to sue them in bulk so that the penalty fits the offense. It quickly became clear, however, that consumer fraud class actions would confront high legal hurdles in most jurisdictions. Concerned about a deluge of lawsuits, the U.S. Supreme Court placed several barriers in the way of litigants trying to bring fraud-related class actions in the federal courts. For plaintiffs relying on interstate transactions to establish federal jurisdiction, each member of the class had to have a claim in excess of $10,000. The court also held in a 1974 case that plaintiffs' attorneys would have to exercise diligence in locating and notifying potential class members, which hiked pretrial costs. These rulings did not foreclose securities fraud class actions. The New Deal securities statutes established federal jurisdiction regardless of amounts at issue, and the Supreme Court eased the path for many suits in 1979, when it ruled that private litigants could rely on the factual determinations of SEC enforcement proceedings as bases for their own suits, which reduced discovery costs. The legal environment was sufficiently hospitable to securities class actions that law firms began to specialize in them, encouraging a steady increase in filings. By the late 1970s, initial filings and multi-million-dollar settlements in such cases had become commonplace. Attempts to bring consumer fraud class actions, however, ran into bigger legal obstacles. The $10,000 threshold for the establishment of federal jurisdiction created a key hurdle, for few individual claims reached this amount. Unlike California, most states did not possess ready mechanisms for class actions, and those that did often had cumbersome procedural rules that hindered would-be consumer fraud litigants. The judiciary in both federal and state courts also tended to be skeptical of claims that the victims of consumer frauds met the essential characteristics to justify class actions, that they had parallel legal complaints, that they constituted an ascertainable class who could learn about court proceedings, and that claims were specific enough that courts could oversee compensation. Aware of these issues, consumer advocates looked to statutory solutions, for which a bevy of legal scholars soon offered ideas. Beginning in the late 1960s, their proposals for consumer protection legislation included calls for Congress and state legislatures to relax the definitional standards for consumer fraud-related class action suits and to widen the range of remedies, including the fluid prospective restitution that California courts accepted in Darr v. Yellow Cab. Some federal consumer protection laws, such as the 1968 Truth in Lending Act and the 1975 Magnuson-Moss Warranty Act, widened the door for class actions. The Truth in Lending Act did not require a minimum amount at issue, and also called for a low standard of proof, just a showing that merchants had not provided mandated information to customers. Demonstration that merchants had misled customers or that purchase decisions had only occurred because of the lack of disclosure was not necessary. The burden on plaintiffs thus resembled the situation in many securities fraud cases. This statute also mandated minimum awards of $100 to winning plaintiffs and allowed for generous attorney fees. As a result, legal counsel for consumer debtors filed thousands of class action suits, many brought because they offered the best means of redressing the small-scale individual harms caused by deceptive marketing. Although some federal judges balked at certifying the largest proposed classes on the grounds that the resulting multi-million-dollar awards would impose too much harm on defendants, hundreds of suits were successful. According to many close observers of consumer issues, these cases helped to foster general compliance with the legislation by the late 1970s. The Magnuson-Moss Act established minimum standards for warranties of consumer products worth more than $10, including the use of clear language and a ban on deceptive disclaimers and exceptions. In order to limit pressure on the federal courts, the legislation encouraged corporations to create informal dispute resolution mechanisms to handle warranty-related complaints. But it also established an avenue for federal class action suits, so long as each individual claim exceeded $25, the class numbered 100 or more persons, and the amounts at issue totaled $50,000. Federal judges, however, ruled that Magnuson-Moss class actions had to name 100 specific plaintiffs and that plaintiffs had to pay for notice to the affected class. These impediments stymied all but a handful of warranty-related class action filings. Consumer groups and several members of Congress hoped to lower the jurisdictional hurdles to consumer fraud-related federal class actions, but proposals to create a more plaintiff-friendly federal mechanism never became law. During the early 1970s, the Nixon administration deflected political momentum by calling for a limited class action that would only become available once the FTC had declared a business practice to be deceptive. Later that decade, class action reform became bound up with the drive by Ralph Nader and a coalition of public interest organizations to create a Consumer Protection Agency, CPA, which would have had the authority to represent consumer interests before federal agencies. As Nader envisaged it, the CPA would counterbalance business interests in regulatory rulemaking and enforcement processes, prodding bureaucracies to act in the public interest. Both the proposed CPA and calls for streamlining federal consumer class action lawsuits became lightning rods for corporate executives, who mounted furious campaigns to thwart them. To opponents such as U.S. Chamber of Commerce President Richard Lesher, consumer class actions gave ambulance-chasing lawyers the capacity to shake down legitimate firms that might have done nothing but innocently violate some obscure government rule. Such arguments resonated with enough moderate Senate Democrats to keep the liberalization of class actions from becoming law. Supporters of consumer class actions fared better in the states, even though only a few created procedural mechanisms to facilitate these suits. California remained a leader in this regard. The state legislature revised its class action framework in 1970, allowing notification of class members by public advertisement. Shortly thereafter, the state Supreme Court reaffirmed its approbation of class actions in a case that involved 200 consumers who each alleged fraud by the same seller of freezer food schemes. Although the customers had purchased a variety of plans, the court certified the existence of a class because of a consistent pattern of falsehoods by company agents. Establishing commonality among plaintiffs was eased by the fact that company training included memorization of the required sales pitch. Several other states moved in California's direction, including Ohio, Illinois, and even New York, which before a legislative reform in 1980 had been unreceptive to consumer fraud class actions. Within these states, private class actions became a more viable means of redress. Regardless of how open a state's legal system was to consumer class actions, they proved less common than suits on behalf of investors. In part, this difference reflected a greater difficulty in identifying defendants with the capacity to make restitution. But it also resulted from evidentiary challenges. Plaintiffs' attorneys confronted the same problems in consumer fraud cases that so often bedeviled prosecutors. One could not always expect a would-be competitor to assist in bringing forward public testimony of a cab company's meter rigging, nor an offending company to have its sales staff repeat word for word the exact same lies to every customer. When large-scale consumer fraud class actions were successful, they often relied on the investigative capacities of the anti-fraud state, a pattern exemplified by the 1977 engine switching affair at General Motors. Beset by deteriorating labor relations and facing sharp competition from European and Japanese imports, General Motors also struggled with quality control during the mid-1970s. Nonetheless, it retained a dominant position in the U.S. market, which encouraged managerial complacency. In 1976, GM executives decided to equip 1977 Oldsmobiles with Chevrolet engines, without informing consumers that the higher-priced make had a lower-priced engine under the hood. Dealers received a cryptic notice of an engine change that did not announce the substitution of a Chevy powertrain. The company may have been responding to production problems caused by an underestimation of consumer demand for powerful engines, as it claimed, or it may have been seeking to cut costs. Either way, GM traded on customer expectations cultivated through a half-century's worth of product differentiation and brand management. For almost 30 years, Oldsmobile had advertised that its higher sticker price paid for a higher quality car, including the distinctive V8 Rocket powertrain. Oldsmobile headquarters even had a large sign on its roof proclaiming that the building was the home of the Rocket engine. Within months of GM's production shift, some owners learned of the switch, either because they were mechanics who fiddled with their new engines, or because they had to take in cars for needed repairs, only to discover that Oldsmobile dealerships lacked parts for Chevy engines. State and local consumer protection agencies soon received a thunder of protests, prompting widespread investigations. One of the first was undertaken by the Consumer Fraud Division of the Illinois Attorney General's Office, which soon ascertained the nationwide scope of the engine swaps. Recognizing the depth of anger among his constituents, Illinois Attorney General William Scott filed a $40 million class action suit in federal court on behalf of all affected American car owners. The value to individual consumers overcame the usual roadblocks to federal consumer class actions, and Scott could marshal the resources of his office to sustain evidence gathering and meet notice requirements. This move triggered 70 additional suits, including more than 20 filed by other consumer fraud agencies and a further 25 private class actions. 41 attorneys general also joined the Illinois filing. In response, GM lawyers insisted that its engine swap reflected a long-standing industry practice to exchange components as business conditions warranted. Confronted with withering publicity and formidable legal opposition, however, GM took steps in April 1977 to inform all of its customers about the engine switch, giving them the option of exchanging their Chevy mobiles for new cars, less 8 cents a mile for wear and tear. Then, in late 1977, the car manufacturer agreed to a further $40 million settlement with Attorney General Scott, lead negotiator for the public class actions. The corporation denied any culpability for deception, but committed to furnishing a $200 payment to all affected car owners, as well as a 3-year supplemental engine warranty. This settlement, however, represented just the end of the first phase of legal jockeying over the Chevy Mobile. Only half of eligible owners accepted the settlement, with some plaintiffs standing on the principle of the thing. As Joe Seeweck, the retired Chicago mechanic who first brought the issue to the attention of the Illinois Attorney General's office, put it, "People should be told what they are paying for. I bought something and I didn't get my money's worth." One private class action challenged the settlement, convincing an appeals court that the agreement did not gain the assent of all parties to the dispute. This ruling opened the way for a 1981 jury trial on the remaining class action, which culminated in a partial victory for the plaintiffs. Car owners who had purchased Chevy Mobiles before GM disclosed its engine switch would be entitled to $550 payments. After GM appealed this decision, it accepted a 1984 settlement that reduced its monetary obligations to $400 per holdout. Such victories led consumer activists and like-minded legal scholars to retain some faith in post-sale legal remedies as ways to discipline misleading or fraudulent selling. In the right circumstances, action by consumer protection agencies, criminal fraud prosecutions, civil suits, or some combination thereof furnished a measure of justice to victims of economic deceit and some degree of deterrence. But in the 15 years after Kennedy's message to Congress on consumer issues, there were enough cautionary tales to convince many leading scholars of consumerism that preventive strategies offered the best return on scarce anti-fraud resources. 2 large-scale studies commissioned by the Department of Justice's National Institute of Law Enforcement and Criminal Justice put the stamp of officialdom on this viewpoint. The first of these, a survey of consumer fraud law produced in 1978 by lawyers Jonathan Sheldon and George Zweibel, cataloged the shortcomings that had cramped retrospective fraud enforcement. Although the authors singled out class actions pressed by state attorneys general as one promising regulatory arena, they advocated greater focus on the requirement of effective pre-sale disclosures and the granting of more expansive cancellation rights. The second study, Consumer Fraud: An Empirical Perspective, written the following year by Jane Schubert and Robert Krug, analyzed a large sample of complaint files to government consumer protection agencies. Schubert and Krug assessed the nature of complaints, patterns of how they moved through bureaucracies, and their outcomes. Most transactions gone bad involved low stakes and required great effort to achieve any resolution. The social scientists thus recommended efforts to restructure the framework of consumer transactions. The goal, they argued, should be to empower consumers, whether through cooling-off periods, improved standards for warranties, or requirements of more effective information disclosure. Insofar as governments focused on post-sale mechanisms of redress, the most sensible option was to improve mediation services at consumer protection agencies. These studies signaled a tempering of aspirations for tackling consumer fraud, a judgment that only so much was possible in the context of American justice. They offered a coda to an era of regulatory governance born amid great anticipation and concluding with pleas for trimmed sails and curtailed aspirations. Reinvoking the regulatory filters of markets. For skeptics of concentrated state power, disenchantment with anti-fraud policies was to be expected. In some quarters, the expansion of the anti-fraud state during the New Deal and post-World War II decades had always occasioned suspicion or outright antagonism, as had expanded governmental authority over other economic realms. As the impacts of statutory reforms and enforcement campaigns accumulated, anti-fraud regulations attracted the critical attention of political scientists, legal scholars, and economists. The social science research was part of a more general inclination to appraise the shortcomings of modern regulatory governance, and shared a common intellectual touchstone: the implications of economic self-interest for political behavior. Many scholars who took a close look at the evolution of American regulatory institutions worried that regulated businesses invested far more effort in shaping policy than the rest of society. No other constituency cared more about regulatory outcomes, nor possessed comparable resources to shape the details of regulatory statutes and engage with administrative decision-making. The technocrats charged with carrying out regulatory missions also came in for close scrutiny because they had incentives to care more about building administrative empires or currying favor with regulated businesses than upholding broader interests. According to the academics who studied regulatory institutions, policymakers had to worry about the dual threats of regulatory capture from without and administrative inefficiency from within. This analytical indictment emerged from every direction of the American political compass. If there was one academic text that framed the trope of regulatory capture and set the parameters of specific agency studies, it was Marver Bernstein's 1955 monograph, Regulating Business by Independent Commission. A centrist and Princeton University political scientist, Bernstein stressed that even if powerful business interests were neither the architects of regulatory frameworks nor the puppet masters of regulatory officials, their structural advantages allowed them, over time, to bend regulatory decision-making to their liking. Drawing on extensive archival research for his 1963 monograph, The Triumph of Conservatism, radical historian Gabriel Kolko came to similar conclusions. Arguing that large corporations had dictated the progressive-era creation of national regulatory agencies, Kolko charted a line of interpretation adopted by activists Ralph Nader and Mark Green from the left, and economist George Stigler and legal thinker Richard Posner from the right. The range of perspectives that raised tough questions about the regulatory performance of federal agencies gave the resulting scholarship greater force than if censure had come from just one end of the political spectrum. The voluminous Cold War-era scholarship on American economic regulation primarily examined oversight of prices, rates, and entry in specific industries, including railroads, trucking, airlines, broadcast communications, and energy. There were, however, numerous investigations of deceptive practices regulation by academics and policy analysts within regulatory institutions. These studies put forward three overlapping critiques. The first raised questions about the benefits of anti-fraud policies. Several scholars argued that the impulse to strike at misrepresentation generated regulatory broadsides at trivial aspects of modern capitalism. Efforts by the FTC to define deceptive practices and then police those boundaries came in for the harshest scrutiny. The FTC prioritized such deceptions as inaccurate characterizations of synthetic fiber content in clothing, claims of sales discounts from misleading price anchors, and promotions that included free items. Between 1964 and 1968, more than half of FTC cease and desist cases addressed allegations of mischaracterized textile contents or misleading claims about a product's country of origin. But few FTC enforcement actions showed that a significant proportion of consumers were influenced by such claims or viewed themselves as harmed by them. By the mid-1960s, the lack of thoughtful priority setting had become a common concern among scholars who examined the FTC's anti-deception work. In 1969, both the Nader Report and the ABA committee that reviewed the FTC excoriated the Commission on this score. Several scholars raised questions about the supposedly beneficial impact that anti-fraud regulation had on commercial practices and consumer behavior. These academics took note of often toothless FTC cease and desist orders, pervasive difficulties in making criminal fraud cases stick, and overwhelmed consumer protection staffs. In addition, some studies found that the most basic tool of the anti-fraud state, improved disclosure to redress buyers' informational disadvantages, had grave limitations. Information provision about credit terms under the Truth in Lending Act serves as an important case in point. As state and federal officials implemented these requirements, a number of social scientists assessed business compliance and the impact of the new rules on consumer choice. Compliance improved over the course of the 1970s, partly because of low barriers to legal challenges by consumers if sellers had not supplied mandated disclosures. But mere disclosure often did not influence buying decisions. Many consumers found disclosed credit information to be confusing. Even clear understanding of credit terms did not matter much at the time of sale compared to availability of credit and perceived capacity to make payments. As one Los Angeles banker noted at the time of the Truth in Lending Act's passage, "What concerns most people is the amount they have to pay each month, regardless of the interest rate." Evaluation of information disclosure regimes in other consumer arenas raised similar cautions. In a host of contexts, social psychologists found that consumers paid minimal attention to disclosed information if they were unaccustomed to comparison shopping, or if disclosures used complex language, presented a mass of details, or did not have obvious relevance for a purchasing decision. If prospective buyers did comprehend the basic meaning of disclosures, their retention of that information proved ephemeral and rarely shaped purchasing selections. Studies by legal sociologists also suggested that disclosure did little to protect the urban poor from abuses, absent robust consumer markets that furnished meaningful competition. Skepticism about the value of mandatory disclosure regimes extended to analyses of investment markets, though here the most vociferous criticisms came from conservative scholars. The typical individual investor, critics aimed to show, lavished about as much attention on detailed historical accounting data as consumers paid to complicated disclosures of credit terms. Instead, investors relied on the advice of brokers and market letters, the opinions of friends, and recent price movements. During speculative booms like that of the late 1960s, investors paid scant attention to the prospectuses and registration statements of new firms. In periods of both boom and bust, the decision to re-elect corporate directors did not represent careful appraisal of performance or fidelity to corporate interests, but was rather a meaningless ritual in which the chief executive officer usually dominated the process, and apathetic investors ratified the CEO's hand-picked slate. As compared to individuals, institutional investors took far more note of mandated disclosures, but they preferred analysis of industry trends, macroeconomic forecasts, and overall market movements rather than detailed inquiry into the corporation's SEC filings. Investors in interstate real estate properties proved even less inclined to scrutinize information required by the 1968 Interstate Land Sales Full Disclosure Act, which often came in convoluted reports that confused many potential purchasers by their complexity. High-pressure sales tactics continued to generate ample demand for sham Sunbelt developments throughout the 1970s. The second major critique of anti-fraud regimes highlighted their substantial direct and indirect costs. The former were the easiest to see. Someone within corporate management and the staffs of smaller businesses had to gather the information required by consumer disclosure regulations and then prepare notices, forms, and reports. Employees had to receive training on the new regulatory environment and their responsibilities to give customers correct forms and appropriate information. In sales involving the extension of credit, mandatory disclosure meant additional time to complete transactions because loan officers or credit department employees had to sit down with customers and explain how rates are computed and how other provisions of the Truth in Lending regulation affect him. This sort of bureaucratic red tape increased overhead expenses, which translated into higher prices for goods and services. Compliance with the disclosure regime for public securities was far more costly, involving charges for external auditors, legal reviews, printing, and distribution of reports to far-flung investors. Once the SEC initiated fraud-related enforcement actions against independent auditors and law firms, moreover, liability insurance for these professionals became far more expensive, necessitating higher fees for corporate clients. The collateral consequences of consumer and investor protection efforts raised deeper reservations. Disclosure mandates erected barriers to entry for would-be newcomers. Constraints on marketing practices or capital-raising strategies curbed competition. This trade-off raised sharp dilemmas for a regulatory agency such as the FTC, which encompassed two missions in profound tension. It had the responsibility to uproot the deceptive practices that constituted unfair methods of competition, but it also had the obligation to promote robust competition, which generated cheaper prices for consumers. The SEC faced a similar conflict between combating misrepresentation and facilitating the transformation of savings into capital formation. State and local consumer protection agencies faced analogous quandaries. For detractors of anti-fraud regulation, Cold War-era regulatory agencies had sacrificed vigorous competition on the altar of sanctimonious policing of commercial candor. The legal scholars Gregory Alexander and Richard Posner developed this line of argument in separate indictments of the FTC. Writing in the mid-1960s, Alexander painstakingly documented the Commission's disproportionate antagonism to aggressive marketing by discounters. The firms that most eagerly embraced advertising hullabaloo hoped to drive price-conscious consumers through their doors. These same businesses were the ones that most frequently elided descriptions of a good's place of origin, or fought to gain the notice of consumers through offers of free gifts or bonuses, or described sales promotions in ways that exaggerated discounts. Alexander did not reject the value of FTC policing of retailing honesty, but he stressed that in hard cases, the FTC investigators and hearing examiners who handled deceptive practices cases too often ignored the impact of their actions on competitive conditions, thereby harming consumers in the very attempt to lend them a regulatory helping hand. Posner's analysis of the FTC, which he completed while a member of the ABA's 1969 Investigatory Committee, was even more scathing. Then a quickly rising star in the legal academy, Posner had spent several years as a staff attorney for FTC Commissioner Philip Ellman, who had developed his own critical appraisal of the agency. Like Alexander, Posner depicted most FTC cease and desist proceedings as nitpicking and characterized its fictitious pricing cases as harassing discounters. His greatest complaint, however, was the systematic burden that the FTC placed on young firms seeking to develop new products or services that would furnish cheaper substitutes for established offerings, often through importation, technological invention, or organizational innovation. Hundreds of post-war businesses had to cope with FTC investigations that scrutinized their advertising claims for novel wares, often at the behest of incumbent firms looking to beat back threats to their market share and profitability. These investigations, Posner maintained, cost upstarts millions in legal fees and had a chilling effect on competition. The financial economists and legal scholars who portrayed securities regulation as misguided and ineffective emphasized a different set of ancillary harms. To be sure, the expenses associated with public offerings could shut out some businesses from the public capital markets. By the 1960s, onerous disclosure requirements for bond issues had driven half of corporate debt placements off public exchanges. And the decision after the 1961 Special Study of Securities Markets to narrow registration and disclosure exemptions made it harder for some smaller companies to attract financing. But a bigger problem was the danger that formal disclosures might themselves become misleading. As of the early 1970s, filings to the SEC still had to eschew discussions of earnings projections and market forecasting, because these estimates represented opinions rather than historical measures of performance. But sophisticated investors demanded forward-looking assessments as a basis for decision-making, and SEC filings did not furnish that analysis. The third element in the intellectual challenge to anti-fraud regulation involved a reconsideration of the possibility of checking commercial and financial chicanery through the workings of markets. Did consumers and investors really need a paternalistic state that compelled information disclosure and disciplined wayward firms that strayed off the path of candor, especially through administrative sanctions such as cease and desist orders? Richard Posner, for one, had more confidence in the balancing pressures of competitive marketplaces. Consumers, he insisted, were not hapless dupes. They made reasonable assessments of economic options and relied, in a world of newfangled technologies and financial arrangements, on the advice of information brokers, who had expertise about specific products and services. If, on occasion, consumers did get taken in, they would learn from unhappy experiences. Sellers had plentiful reasons to worry about their reputations, which prevarication and imposture would soil. Even in impersonal markets, competitors could and would police one another, responding to false advertising with publicity campaigns to correct any misrepresentation and call out the miscreants. For the ever more complex world of securities, the economist George Benson and the securities law professor Homer Kripke placed their faith in the reputational considerations of intermediaries such as auditors, investment bankers, and financial analysts. Mindful of long-term interests, these experts would afford investors protection from fraudulent or misleading financial statements in the absence of government disclosure regulations. The critics of anti-fraud regulation recognize that the most vigilant marketplaces were still prone to misrepresentation and outright swindles. But the appropriate policy response for the dodgy seller who posed as a reputable dealer or the intermediary who traded on his reputation was criminal prosecution, not administrative rules and investigations. One sees in such arguments a return to the premises of 19th-century approaches to business fraud, reliance on the hardening impact of tough experience or the instructive guidance of Consumer Reports, rather than the Argus-eyed trade journal editor, meeting misleading claims with disparaging comparative advertising, rather than combating the product counterfeiter with advertising pleas to look for the genuine article's trademark, trusting to the good auspices of the financial analyst and auditor, rather than the august investment banker whose most important asset was his good name. Amid the heady days of consumerism, Elizabeth Hanford and many other political elites had proclaimed that in the United States, caveat emptor was dead. At essentially the very same moment, Richard Posner had offered as a full-throated rejoinder, "Long live caveat emptor." Posner capped off his 1969 flaying of the FTC by calling for its abolition, because the costs that it imposed exceeded whatever social benefits it conferred. He suggested that the loosening of common law evidentiary standards to establish liability for commercial deceit had been a fundamental policy error, as had the construction of administrative processes to police those more easily demonstrated violations of truthfulness. As a result, the best option was to uproot these costly mistakes. The most strident opponents of the American disclosure regime for securities regulation adopted a similar stance toward the SEC. This envisaged radical return to the legal premises that structured 19th-century American marketplaces never had much of a chance. No highly regarded politicians stepped forward with proposals to repeal the Federal Trade Commission Act, the New Deal securities statutes, or the state legislation and local ordinances that had dotted America's institutional landscape with consumer protection agencies. If prominent elected officials had made such overtures, consumer organizations and labor unions would have howled in opposition. Even so strident an advocate of unregulated competition as the economist Milton Friedman carved out exceptions for duplicity. There is one and only one social responsibility of business, Friedman argued in his best-selling 1962 book Capitalism and Freedom, to increase its profits so long as it stays within the rules of the game, which is to say, engages in open and free competition without deception or fraud. Nonetheless, many of the assumptions that undergirded conservative critiques of the anti-fraud state increasingly shaped policy-making within it. This shift reflected the waxing influence of economics within anti-fraud agencies and government more generally. Beginning in the early 1970s, American business elites pushed for greater reliance on economic analysis in regulatory decision-making. The Chamber of Commerce, Business Roundtable, and National Association of Manufacturers all viewed such analysis as a way to constrain intrusive and expensive rules on workplace and product safety, environmental impacts, and consumer protection. As the Nixon, Ford, and Carter administrations grappled with the inflationary forces set off by the Vietnam War and the 1973 oil crisis, they all asked for careful appraisals of the costs imposed by government regulations. At those agencies with anti-fraud missions, leaders were also confronted with the criticisms leveled by Posner, Kripke, and others. As a result of these pressures, regulatory officials moved to hire more economists, to direct resources toward offices responsible for economic research, and to consult with advisory committees that included academic economists. The experts empowered by these developments advocated strategic planning processes and the use of formal assessments of benefits and costs to structure priority setting. More rigorous engagement with economic analysis percolated up to the highest levels of anti-fraud agencies, especially at the national level. One can see this intellectual process at work at the FTC, where Robert Pitofsky spearheaded a reorientation of anti-deception strategy that reflected Posnerian empiricism and logic. Like so many other post-World War II anti-fraud regulators, Pitofsky was a lawyer. After serving as executive director of the 1969 ABA inquiry into the FTC, where he collaborated with Posner, he became director of the FTC's Consumer Protection Division in 1970, a position he held until 1974, when he accepted a law professorship at Georgetown University. In 1978, President Carter nominated him to serve as an FTC commissioner, with the expectation that he would bring a moderating influence to bear on consumer protection issues. Pitofsky had received a basic grounding in economics as a New York University undergraduate and undertook a self-taught crash course in more advanced principles when he started his legal career with a practice that defended corporate clients facing antitrust suits. At Georgetown, he delved into the economic dimensions of antitrust and trade regulation and helped to shape early research agendas within the law and economics movement, an emerging group of academics who wished to bring rigorous economic analysis into legal decision-making. This perspective suffused Pitofsky's approach to policing consumer fraud. The FTC, he argued, should remain committed to curbing marketing deceptions, but only those that harmed consumers, threatened trust in the marketplace, and generated misallocation of economic resources. There should be no more piddling cases prompted by puffery or promotional razzmatazz that allowed discounters to gain a foothold in concentrated retail markets, and perhaps no action against deceptive marketing for the lowest-priced goods. In such cases, the Commission should trust the disciplinary and educative functions of the market. Thus, Pitofsky advocated that the FTC partially return to the standard of caveat emptor, because consumers could spot the most obvious exaggerations and distortions. If false claims led to purchases of the cheapest goods, consumers would learn to avoid such impositions. The marketing of major corporations that reached national audiences deserved closer scrutiny. So too did advertising that targeted vulnerable populations, such as children and the elderly. This philosophy of more restrained and targeted anti-fraud regulation also shaped the federal government's responses to the demonstrated weaknesses in mandatory information disclosure. Drawing on findings from social psychology and economics, regulators and legislators sought to improve the design and implementation of disclosure standards. By the mid-1970s, social scientists, officials at anti-fraud agencies, and legislatures had all joined a debate about how to reduce excessive costs to businesses and better tailor the content and process of information provision so that it was more useful to relevant investors and consumers. A number of policy reforms ensued, including the SEC's Rule 175 on forward-looking statements, adopted in 1979. The SEC's development of a framework for integrated corporate disclosure, proposed in 1981, and the Truth in Lending Simplification and Reform Act, which passed Congress in 1980. Each of these reforms sought to ensure provision of relevant information and to moderate administrative burdens. The forward-looking statements rule facilitated corporate release of earnings projections by giving corporations that made good faith forecasts a legal safe harbor against fraud suits based on incorrect predictions. Based on a decade's worth of studies and hearings, integrated disclosure reduced information overload and cut compliance costs by eliminating duplicative filing requirements. The Truth in Lending reform lessened legal risks faced by creditors by limiting the reach of private class actions. But it also authorized the Federal Reserve to create standard forms in the hopes of improving the comprehensibility and salience of consumer credit disclosures. More self-conscious applications of cost-benefit screens did not foreclose extensions of regulatory authority. The FTC adopted its holder in due course rule in the mid-1970s and then placed a national spotlight on predatory marketing in the funeral business, leading to a funeral price disclosure rule that overcame ferocious industry opposition to curb the most abusive rip-offs. Greater respect for market dynamics, however, signaled an important turning point in the history of American fraud policing, part of a broader skepticism about regulatory authority that would drive several decades of deregulatory fervor. Better business bureaus and the fraying of self-regulation. Even before Ronald Reagan's electoral victory in 1980 solidified the influence of market-based predispositions in American government, the more populist dimensions of a conservative revolt against activist government had important implications for self-regulatory institutions. To appreciate this aspect of renewed American faith in unleashed capitalism, we need to return to the post-World War II endeavors of the better business bureaus. Those efforts always had significant limits. But insofar as the BBBs developed working partnerships with government anti-fraud agencies, they fostered smoldering resentments among their more conservative members that anticipated the wider revolt against regulation. Ongoing efforts by BBB leaders to cultivate a brokering role among government anti-fraud agencies, militant consumer groups, and business groups exposed an organizational fault line along geographic and generational divides. BBB officials from the South and Southwest, along with some newly appointed executives elsewhere who had corporate backgrounds, blanched at the strategy of accommodating consumerism. According to local BBB heads such as Dan Berry of Nashville, Richard McLean of Houston, Ralph Smathers of Miami, and Jim White of Phoenix, the organization's troubles resulted from not embracing the views of the business establishment and becoming too focused on racket busting. The Sunbelt faction, characterized by one of the older guard as the younger conservative chaps in our group, hoped to attract greater backing from business by offering full-throated critiques of both overreaching government and paternalistic consumer groups, and insisting that robust self-regulation was the only workable constraint on commercial speech. Influenced by the tide of Goldwaterism sweeping over the Sunbelt, these voices saw no reason to give any ground to consumerism. The conservatives called on the BBBs to restrict their assistance to government prosecutors. By building cozy relationships with public regulatory agencies, these leaders maintained, BBB officials had cultivated too much of a reputation as de facto policemen, compromising their relationships with the business community. James Stephens was insistent on this point. "We in Atlanta," Stephens confided to Dan Berry in a 1965 letter, "have long ago decided that our local problems can best be handled on a local basis and without the assistance of the FTC, SEC, Food and Drug Administration, or whatever. We do not receive one dime from the government and don't want any of their money. By the same token, we don't want any of their publicity. We are supposed to speak for business. Our conversations should be business conversations, and our files should be business files, and our information should be business information, and our reports should be business reports, and our standards should be business standards." If we are to play cops and robbers, then I think we should change the misnomer we call a slogan, private enterprise in the public's interest, to business-supported agencies for the purpose of squealing on business. For Stevens, the only appropriate stance for the bureaus was to remain business-sponsored and business-oriented. This perspective meant that BBBs needed to treat their files with greater respect for confidentiality and limit use of publicity as a sanction against firms, because exposés only heightened the pressure for more regulation. Wherever possible, Dan Berry implored, the bureaus had to solve our problems within the bureau family and not, in a mood of haste or despair, run to outside agencies. BBB leaders who adopted this approach committed themselves to lobbying against new consumer legislation and to recruiting businesses targeted by such initiatives. One policy arena that attracted their attention concerned proposals in many local jurisdictions to ban door-to-door selling. Several local BBBs opposed the bans, arguing that one should not cut off an arm to cure a boil, and that self-regulation of direct selling was a more appropriate means of addressing deception within the industry. After Kenneth Barnard's retirement in 1963, the Chicago BBB went so far as to inform businesses such as Encyclopedia Britannica and Avon of their efforts, and even to suggest that the National Association of Direct Sellers might assist in convincing its members to join BBBs in their marketing territories. Throughout the late 1960s and early 1970s, the Bureau's strategic response to consumerism vacillated. In 1970, Woodrow Wersig, who had been an editor at Printers, Inc. before taking the reins at the New York City BBB, publicly threw down the gauntlet to the consumer movement. Speaking at a national conference on consumer affairs, Wersig characterized activists in both government and nonprofit organizations as whipping up an atmosphere of hysteria and creating costly government bureaus on the basis of hunch and emotion. He further insisted, like Richard Posner, that consumers were not helpless, ignorant, constantly in need of protection. At the end of his remarks, over 100 executives in attendance gave him loud applause, signaling the approval of the corporate establishment. Wersig's speech, however, prompted a series of attacks by consumer groups and governmental officials on the BBB network. New York City's Commissioner of Consumer Affairs, Bess Meyerson, dismissed the local BBB as incapable of separating itself from the firms it was supposed to police, and as protecting a lot of bad guys. Ralph Nader offered an even bleaker assessment, maintaining that most local Better Business bureaus, our own in Washington included, have been miserable failures. The sparks between BBB leaders and consumer activists prompted several in-depth stories by journalists at national newspapers such as the New York Times, the Washington Post, and the Wall Street Journal, all of which raised serious questions about BBB performance, anticipating the various criticisms leveled in the Rosenthal report. The bureaus, which, since their inception, had enjoyed fawning press because of close cooperation with establishment media, had never before faced this kind of sustained scrutiny. Dissemination of the Rosenthal report only intensified negative press. The depth of public censure put many BBB officials on the defensive, as did the Nixon administration's moves to make the FTC a more effective regulator of deceptive practices and the burgeoning number of state and local consumer protection agencies. For a time, these trends strengthened the hand of more moderate BBB reformers. As a result, the reorganization of BBB structures, implemented in 1971 and 1972, was overseen by former St. Louis BBB manager John O'Brien and Elisha Gray, chairman of the Whirlpool Corporation, both of whom called for the organization to improve its role in consumer protection. O'Brien went so far as to bring in one of Nader's raiders, Dean Detterman, to assist in the organizational revamp. In some local BBBs, governance boards emulated this move, appointing new leadership directly out of the consumer movement. These actions would have been inconceivable as recently as the 1960s. Thus, the New York City BBB shifted its resources toward consumer outreach and instituted a much tougher screening process for potential business members, while becoming more willing to sanction wayward members through expulsion and even to publicize such internal policing. The conservative faction, however, continued to influence key policy decisions, reflecting the country's post-1968 political shift to the right and the growing assertiveness of corporate interests devoted to the tenets of market fundamentalism. In the late 1960s, for example, a 2-year nationwide BBB investigation documented a trend among Sears's appliance departments to adopt bait-and-switch methods. But an eventual national BBB bulletin on the inquiry, a communication produced for BBB insiders, ignored the question of whether incentive structures and sales training contributed to problematic marketing practices. Some years later, similar complaints about Sears culminated in an FTC investigation and 1976 consent decree. In the intervening years, the Chicago BBB soft-pedaled the situation with Sears whenever customers or other bureaus inquired about it, insisting that BBB policy precluded discussion of ongoing governmental investigations that had not reached a final determination. Conservatives also forced out John O'Brien within 2 years of his taking the helm of the new Council of BBBs, replacing him with a CBS television executive. Allied with the largest national advertisers, they won a key debate over the constitution of the National Advertising Review Board, which in the end included only 10 representatives of the public interest among its 50 members. Once the NARB had begun to function, they then relied on its operation to fend off calls for more stringent regulation of advertising by both the FTC and FCC, despite complaints by consumer activists about slow process, insufficient independence from corporate America, and a dearth of outreach to increase awareness and attract more consumer participation. Self-regulation of national advertising remained firmly in the hands of the business community. Conservatives also pushed through a national policy that allowed members to display BBB affiliation on store windows and in advertisements, and to create a series of formal arbitration programs. These changes facilitated business recruitment, but also threatened to exacerbate adverse selection problems, because firms that used aggressive marketing had reason to join a BBB in order to flash its seal of approval. The second initiative also furthered the goal of moving dispute resolution outside the state, extending the BBB's capacity to deflect consumer dissatisfaction. A 1973 marketing brochure that the Chicago BBB sent to prospective members made this point explicit, characterizing its consumer complaint mechanism as a safety valve and a shock absorber. As proposals for a federal consumer protection agency lost steam in the mid-1970s, advertising self-regulation settled back into a channel of business influence. The narrative of advertising self-regulation during the Cold War era reinforces the common pattern of interaction between regulatory pressures and the relative willingness of business elites to commit resources to non-governmental mechanisms of commercial standard setting and policing. The degree of support for the BBBs, financial and otherwise, tended to vary directly with the degree of threat that business leaders perceived from regulatory policy. In the face of the emerging consumer movement of the 1960s and early 1970s, and the associated rise of consumer protection measures by government, the business community made a concerted attempt to revamp the bureaus through reorganization, increased funding, and more aggressive provision of services to consumers. The intensifying legalism of BBB operations also underscores the susceptibility of self-regulatory mechanisms to procedural values. In the early 20th century, the first local groups of advertising professionals that formed to police marketing practices called themselves vigilance organizations. Deep into the 20th century, some insiders still referred to their work in terms of vigilante policing. But rights consciousness was not only the province of civil rights activists, women's rights advocates, or post-war consumers. Business managers demanded their right to be heard and, if necessary, appealed to a forum of their peers when BBBs questioned their business practices. As a result, the self-regulation of commercial speech lost some of its comparative advantage relative to the state in flexibility and institutional agility. The experience of the BBBs in the mid-20th century further suggests the possibilities of, and the barriers to, genuine bureaucratic autonomy within self-regulatory institutions. Bestowed by the Great Depression with a corps of dedicated professionals, the BBBs fashioned an uneven independence during the 1940s and 1950s, allowing them to become significant regulatory protagonists. Drawing on their expertise and taking advantage of constrained enforcement budgets at anti-fraud agencies, BBB officials claimed the status of quasi-lawmakers and quasi-regulatory police. If one imagines a dodgy retailer visiting a savvy lawyer in 1958 to ask about the law of commercial misrepresentation, the BBBs would likely have come up in the discussion of both relevant rules and enforcement probabilities. For a time in the early 1970s, it even looked as if BBB leaders might forge deep bonds and shared strategy with figures in the consumer movement. There was not so much conceptual ground between the mid-level BBB manager, who expressed contempt for merchants whose technique is to trade upon and exploit human ignorance and credulity, and who as an automobile medicine man pitches his snake oil by mass advertising to today's Mortimer Snurds, and the young devotees of Ralph Nader. The opportunity to build such linkages, however, ran afoul of two unfavorable contingencies. First, the BBB leaders most amenable to such partnerships were the ones who had seen what a collapse of public confidence looked like during the 1930s, who recognized that healthy markets and public trust depended on robust regulatory infrastructures, and who had learned to work with the modern regulatory state. But that group hit retirement age just as the dilemmas posed by consumerism demanded creative answers. Second, the newer generation of officials were shaped by the rejuvenated conservatism of the Sun Belt, which viewed markets as separate from and threatened by governmental regulation. Never a monolithic entity any more than other institutions of similar complexity, the BBB network of the 1970s had to navigate a profound political shift to the right. With that shift came renewed belief in free enterprise as a product of nature and an intensified impulse to deploy self-regulation as a shock absorber of consumer complaints and a safety valve against pressures for more stringent governmental action. In 1979, University of Wisconsin legal scholar Stuart Macaulay published a searching appraisal of the previous decade's formal expansion of legal protections for consumers. Macaulay wanted to assess how a major law had changed the nature of commercial transactions and the day-to-day practice of law. He initially chose the 1975 Magnuson-Moss Warranty Act and, with the help of a law student, conducted about 100 interviews with Wisconsin lawyers to inquire about its impact. After some preliminary discussions, Macaulay realized that he would have to widen his scope to include all consumer protection-related matters. So few lawyers had heard of the new statute that specific inquiries about it would yield little salient evidence. Indeed, most attorneys knew very little about any of the consumer protection laws and regulations that had tumbled out of Congress, state legislatures, and regulatory bodies in Washington, D.C. and Madison. The majority of interviewees did report some experience with consumer complaints. Those in larger firms had defended businesses facing investigations by consumer protection agencies. In all such controversies, the lawyers focused on securing settlements, seeking to resolve disputes in a way that would restore social relations without anyone losing dignity. Every so often, the formal shift toward caveat venditor intruded on interactions between a seller and an unhappy buyer or a state regulator, nudging negotiating leverage away from the seller. Business lawyers also did their best to help clients comply with the disclosure requirements that had multiplied since the 1960s. But throughout Wisconsin, legal and economic culture proved resistant to consumer protection reforms. These findings prompted Macaulay to wonder if one should view most of the individual rights created by consumer protection laws as primarily exercises in symbolism. Proponents of anti-fraud reforms, on this reading, gained the pretty words in the statute books and some indirect impact, but the practice of those to be regulated was affected only marginally. Given the practical constraints on the most ambitious legal articulations of caveat venditor, this way of framing the historical significance of mid-20th century American anti-fraud policies has obvious appeal. One must be leery, however, of equating consequences with aspirations. One must also consider the full mosaic of anti-fraud policies. For all of the anti-fraud states' limitations, the myriad educational efforts, wide-ranging extensions of legal obligations, sprouting of anti-fraud bureaucracies, deepening of regulatory networks and self-regulatory institutions, unprecedented attention to the frauds that victimized the poorest Americans, fashioning of novel enforcement tools, and periodic marshaling of targeted enforcement campaigns had a collective impact that exceeded the sum of the parts. That impact added up to fraud containment. From the first days of the New Deal through the oil shocks and stagflation of the 1970s, the American economy continued to furnish ample opportunities for commercial imposture and misdirection. But whenever the scale of deception and fraud raised major hackles, there was sufficient political will and regulatory capacity to clamp down on offenders. The worst securities fraud and most abusive business opportunity scams led to prosecutions and convictions, even if penalties sometimes struck observers as modest given the harms inflicted. By the 1970s, such enforcement actions included mechanisms for at least partial restitution to victims. Regulators eventually shut down the Holland Furnace Company, Vigilant Protective Systems, and a host of similarly abusive firms. Furthermore, the accumulated weight of anti-fraud efforts left a more diffuse imprint on social norms. All the declarations about the harms caused by business fraud deepened the discourse of consumer rights. Proliferating invocations of consumers as the bearers of rights that society was bound to respect encouraged the development of self-help strategies by CEPA and Consumer Action, as well as the crusading investigations of consumer reporters such as Marvin Zindler, and the willingness of trial lawyers to take a chance on fraud-related class actions. The broader climate of disapproval for commercial deceit also gave those more vigorous tactics legitimacy, increasing the pressure on the businesses that encountered leaflet-distributing pickets, embarrassing profiles on the 6 o'clock news, or fraud-related mass litigant civil suits. Still, there were ironies. To the extent that the mid-20th century anti-fraud state contained fraud in the short to medium term, it lessened longer-term commitment to regulatory efforts. As institutional frameworks built greater trust in economic communication, there was always the danger that investors and consumers would become less wary and that political elites would see less need for investments in fraud policing. And as policy elites emphasized from different points on the political spectrum, no regulations come without costs. The most stringent rules and toughest enforcement against marketplace deceptions curbed competition, in part by pinching back the limbs and muffling the voices of would-be entrepreneurs. That trade-off would strike the arbiters of U.S. regulatory policy as unacceptable in the closing decades of the 20th century, with profound implications for American thinking about the always vexing problem of business fraud. Part 5. The Market Strikes Back, 1970s to 2010s. Chapter 12: Neoliberalism and the Rediscovery of Business Fraud. Since the 1970s, the problem of business fraud has taken a firmer hold on the American imagination. According to Google Books, the frequency of the phrases corporate fraud and business fraud in published works has doubled every 10 years since 1975. Growth in the number of articles that use one of these phrases in The New York Times, Wall Street Journal, Washington Post, and Los Angeles Times reflects a similar exponential curve. Every year, American newspapers, magazines, and blogs produce thousands of pages about specific fraud scandals and broader patterns of intentional economic duplicity, continuing the 150-year tradition of the journalistic fraud beat. Public officials have taken heed as well, whether through periodic prosecutions under existing law, inquiries into the extent and causes of fraudulent behavior, or consideration of reform proposals. During the past 4 decades, dozens of congressional hearings have examined fraudulent behavior that has harmed investors, consumers, other businesses, or the wider economy. This ever more intense focus on American business fraud has been prompted by a string of major fraud scandals involving allegations of intentional deception by corporations, including many large firms, against their counterparties. Consider the following examples, all familiar to readers of either the old-fashioned financial pages or, for more recent events, economics blogs. Beginning in the mid-1970s, the United States encountered an epidemic of telemarketing fraud. The boiler room brigades extended their stock in trade beyond penny stocks into real estate investments, useless merchandise, unnecessary insurance, and advance fee scams involving sweepstakes and credit repair services. By 1994, one accounting organization estimated annual losses from telemarketing fraud at around $16 billion. A year later, the FBI pegged a sum more than twice as high. During the 1980s and 1990s, systematic strategies of overbilling generated billion-dollar contracting fraud scandals in defense procurement and the Medicare and Medicaid programs. From the earliest days of the Internet, latter-day Peter Funks have taken advantage of the explosive growth in online commerce, creating fake firms, rigging electronic auctions, selling counterfeit goods, and peddling web-based investment scams. The most far-reaching impositions occurred within the financial industry. During the late 1980s and early 1990s, financial improprieties at savings and loan associations led to dozens of failures. Although there were innumerable variations on the basic themes, most of these collapses followed the basic smash-bang script developed at 19th-century financial institutions, with a few updates to take advantage of public deposit insurance and associated regulatory oversight. Attract deposits through comparatively high interest rates. Funnel the funds into investment projects controlled by bank insiders or their cronies. If necessary, arrange for generous appraisals to satisfy regulatory requirements for underwriting. Wherever possible, extract commissions, fees, and high salaries. And then, when an economic downturn exposes the house of cards, leave shareholders and government deposit insurance programs holding the bag. The final tally of direct costs from this period's S&L scandals exceeded $150 billion in nominal dollars, with the most persuasive assessments attributing at least 1/5 and as much as 1/2 of this amount to systematic control frauds. In the late 1990s and early 2000s, American securities markets were beset by new twists on the old game of pump and dump. Several of the country's largest public corporations, including Cendant, WorldCom, Tyco, HealthSouth, and Enron, obscured unfavorable financial results through deceptive accounting. These firms treated loans as revenue, capitalized expenses, booked current profits on the basis of aggressive projections of future earnings, and manipulated stock prices through transactions with special-purpose entities controlled by company insiders. Their ability to hide financial problems was facilitated by professional gatekeepers. Investment bankers devised complex off-balance sheet financing vehicles that hid poor results. Accountants, in many cases the firm of Arthur Andersen, and lawyers blessed such sleights of hand as meeting disclosure obligations. Financial analysts, many with undisclosed conflicts of interest because of their firm's investment positions and role as underwriters, trumpeted buy recommendations predicated on the misleading financial reports. In the worst scandals, losses to investors topped $50 billion. During the early 2000s, two wonders of the financial world, Alan Stanford and Bernard Madoff, ensnared thousands of investors in massive Ponzi schemes that reached into the billions of dollars. Scores of promoters pulled off less grandiose pyramid scams, leading one regulator to describe an era of rampant Ponzimonium. The damage from fraud in the nation's housing markets achieved even more colossal dimensions, as intentional misrepresentations became business as usual within the chain of financing home mortgages. By 2006, every link in that chain, from home appraisals and mortgage brokerage to loan securitization and bond rating to the use of credit default swaps, was shot through with conflicts of interest, false claims about underlying assets and creditworthiness, and duplicitous marketing. At the end of the chain, investment banks and hedge funds engaged in complex manipulation of derivatives markets. Direct losses attributable to these misrepresentations and frauds ran into the hundreds of billions of dollars, implicating almost every large American bank and bringing down Lehman Brothers, Countrywide Financial, Washington Mutual, and a slew of other non-bank lenders. These failures placed severe stress on the banking system and triggered a global downturn that threw millions of people out of work and destroyed several $1 trillion of household wealth in the United States alone. Then, in the aftermath of the collapse, financial firms engaged in pervasive misrepresentations and outright lies about legal titles to properties in order to streamline foreclosures against non-paying debtors. The enormity of these post-1980 scandals casts a different light on the business frauds of the preceding half-century, as well as the regulatory efforts to constrain them. From the mid-1930s into the 1980s, the most bald-faced consumer cheats were undertaken by small players operating on the margins of the economy, while the most substantial stock and commodities frauds involved obscure penny stocks or marginal companies. The worst frauds during the Cold War era, such as the Holland Furnace Company marketing scams or the market manipulations on the American Stock Exchange by the R.E. stock brokerage firm, rarely inflicted losses reaching beyond the tens of millions in inflation-adjusted current dollars. The very worst of the fraudulent business failures of the early 1970s, such as equity funding, cost investors around $150 million, or roughly $1.5 billion in 2015 dollars, calculated as an equivalent share of the overall economy. Over the past 4 decades, the most consequential fraud episodes have attained a much grander scale and scope, imposing direct costs an order of magnitude greater than those of the mid-20th century, and far more frequently embroiling large-scale corporations, including the country's biggest financial institutions. With these business frauds being of such recent vintage, historians have yet to spill much ink about them. Within the historical guild, most scholars shy away from analysis of events until at least a generation or two has passed. As a result, few fine-grained historical case studies have appeared that would facilitate broader causal synthesis. But journalists, economic sociologists, political scientists, and legal scholars have been far less reticent, offering several assessments of more recent fraud episodes. Their accounts offer helpful building blocks for an overarching explanation of this dramatic inflection point, which must engage with how post-1975 deregulation widened the opportunities for large-scale business frauds. But any narrative must also take note of regulatory countercurrents, as the past 4 decades have also included significant anti-fraud initiatives, again both public and private. This chapter and book conclude with reflections on the contingent posture of post-2008 anti-fraud regulation and the implications of history for the elected officials, bureaucrats, and judges who confront the always complex problem of marketplace masquerades. The many faces of deregulation. The occurrence of gigantic American business frauds after 1975 depended in part on structural shifts in modern capitalism. Rapid growth in telemarketing fraud was made possible by technological breakthroughs that drove down the costs of mass marketing over the phone lines. Similarly, the emergence of the Internet as a platform for communication and commerce proved a godsend to con artists and scamsters. Anonymity within the online world complicated reputational checks. Its many routes for bypassing legal borders muddled jurisdictional authority. The most extensive investment frauds involved complicated financial instruments that came into existence only because dramatic advances in computing power facilitated the underlying mathematical modeling. Processes of globalization constituted still another structural precondition for the largest financial frauds. The geographic expansion of integrated financial markets allowed intermediaries to sell more easily across oceans, increasing the potential for asymmetries of information. Steady growth in economic inequality since the early 1970s was an additional contributing factor. Stagnating incomes led to soaring household debt among less well-off Americans, opening up paths for debt-related frauds. Demographic changes represent yet another explanatory variable. The rapid graying of America increased the size of a social group that has always served as a prime target for investment swindles and high-pressure selling. Con artists and fraudulent businesses sought out elderly Americans for the same reason that thieves seek out neighborhood financial institutions. The nest eggs of retired persons, like bank vaults, were where one could count on finding ready money, comprising roughly half of all U.S. financial assets in 2000. This segment of the population also had time to answer phone calls or knocks at their doors, and those who were lonely tended to give sales personnel ample opportunity to make a pitch. Cognitive deficits associated with aging only heightened the appeal of steering deceptive marketing in this direction. Even when elderly Americans turned out not to be easy marks, those who took the bait had strong reasons to refrain from later voicing complaints. Defrauded senior citizens often worried about how their children might react to the news, which raised the specter of lost independence through guardianship or nursing home placement. As a result, surveys found Americans over age 65 as much as 3 times as likely to be fraud victims as other adults, with vulnerability spiking further over age 75. The most common theme running through accounts of large-scale American business fraud since 1975, however, has been the corrosive impact of deregulation, often linked to the insistent lobbying of firms and industry groups who pleaded for regulatory relief during the 3 decades that stretched from Jimmy Carter's election into the George W. Bush administration. In popular discourse and political rhetoric, deregulation often refers to actions that curb governmental restraints on the maneuverability of firms. But the term requires careful parsing because policymakers can take many different steps that relax regulatory fetters. This attention to detail is especially important in explaining post-1975 American business fraud. Different aspects of the more general deregulatory impulse have mattered more in encouraging some types of systematic corporate deception than others. The most thoroughgoing form of deregulation uproots regulatory frameworks for specific industries, either by abolishing regulatory agencies or breaking down market partitions. This type of deregulatory policy, such as the repeal of the structures overseeing routes and rates for passenger airlines, railroads, and long-distance trucking that occurred during the Carter administration, played at least an indirect role in some fraud episodes. The removal of entry and pricing regulations over long-distance telephone rates and telephone equipment in the 1980s and 1990s, for example, facilitated the rapid expansion of firms such as WorldCom, whose aggressive pursuit of market share and short-term stock price appreciation led to deceptive accounting practices. Similarly, The replacement of rigid energy pricing regulation with futures trading platforms gave Enron an opening to engage in the rigging of California energy spot markets, the sort of market manipulation that New Deal financial regulation had outlawed for stock and bond markets. Reconfigurations of rules structuring markets also sometimes encourage fraud outbreaks, as with the savings and loan crisis of the 1980s and early 1990s, and the mortgage financing debacle of the mid-2000s. In the first of these episodes, persistent inflation during the 1970s weakened the financial position of S&Ls, which were locked in to long-term, low-rate mortgages. Congress responded in 1982 by easing previous limits on S&L's capacity to attract brokered deposits with aggressive interest rates, expanding their investment options to include commercial real estate and business loans, and removing the requirement that savings and loans have at least 400 shareholders. All of these changes contributed to the rapid expansion of speculative real estate developments and fraudulent financing schemes. The subprime mortgage fiasco had important roots in several deregulatory statutes and administrative reforms. The former included the 1995 Private Securities Litigation Reform Act, PSLRA, the Graham-Leach-Bliley Act of 1999, and the 2000 Commodity Futures Modernization Act, CFMA. The PSLRA raised procedural and evidentiary hurdles associated with private securities fraud lawsuits against third parties, such as accounting firms. Graham-Leach-Bliley repealed the New Deal prohibition on integrating the operations of commercial and investment banks. After 1999, the largest financial institutions could draw on commercial banking arms for capital, expanding their capacity to create and distribute mortgage-backed securities, as well as to finance non-bank lenders who supplied loans to securitize. This ready access to financing increased the supply of mortgage bonds and related derivatives, widening opportunities for deceptive practices in the debt markets. The CFMA exempted most over-the-counter derivatives from federal regulation, which left the sausage-making of securitization and credit default swaps in the shadows, and so enabled falsification and manipulation. A crucial deregulatory action that eased the path to liar's loans, mortgages predicated on false claims about borrower incomes, occurred in 1997, when the Office of Thrift Supervision replaced its underwriting standards for residential mortgages with unenforceable guidelines. More subtle dimensions of American deregulation also promoted the proliferation of late 20th century business fraud. The impulse to loosen regulatory burdens often operated not so much through wholesale reconstruction of regulatory rules and institutions, but rather budget cuts or unwillingness to increase agency resources in the face of expanding market activity. Appointment of officials committed to more cooperative relations with regulated businesses, and expanded delegation of fraud monitoring to private parties, including regulated entities themselves and third parties, such as ratings agencies. These adjustments had dramatic impacts on anti-fraud enforcement. Insufficient investment in policing played a central role in almost every major post-1975 fraud episode. The schemes undertaken by hundreds of S&L executives in the 1980s and early 1990s all depended on lax oversight by underfunded and overworked bank examiners. Contractors who defrauded federal defense procurement and health care programs calculated that auditing mechanisms would not be able to keep up with sophisticated strategies to maximize billing. At the SEC, budget cuts in the 1990s comprised its capacity to identify the accounting frauds that emerged amid the dot-com boom. During the George W. Bush administration, the FBI shifted scores of field investigators with a background in fraud cases to join the war on terror. Over those same years, Alan Greenspan's Federal Reserve declined to use its authority to crack down on deceptive tactics by mortgage brokers and lenders. The point here is not that every American anti-fraud professional looked the other way. Harry Markopoulos, a mid-level securities executive in Boston, amassed evidence that Bernard Madoff was running a sophisticated Ponzi scheme as early as 1999, sharing his findings on several occasions with SEC officials and the New York State Attorney General's office. At least 2 SEC staffers encouraged him to continue his research and statistical analysis. At Enron, internal auditor Sharon Watkins informed her superiors about indefensible inflation of earnings and obscuring of losses through the use of special-purpose entities and deceptive internal financial reports. Within the Federal Reserve, board member Edward Gramlich sounded alarms about lax oversight of the mortgage markets in 2000. His fears were echoed by a 2004 report by the FBI's Mortgage Fraud Unit, which detailed widespread misrepresentations and outright duplicity. And the head of the Commodity Futures Trading Commission, CFTC, Brooksley Born, recognized the dangers lurking in unregulated derivatives such as credit default swaps, and spearheaded an effort to regulate them in 2000. Such cautions, however, found unreceptive audiences among higher-level regulatory officials, prosecutors, and the most influential legislators. At large financial institutions, internal whistleblowers who raised concerns about mortgage fraud before 2008 were either stonewalled by management or fired. In some instances, such as the Madoff case, this official skepticism reflected disinclination to take action against a well-connected member of the financial elite. In addition, the shift toward deregulatory premises in American policymaking reduced the salience of investor and consumer protection as officials sought to balance conflicting policy goals, at least until the economic ramifications of a specific kind of fraud became too obvious to ignore. Thus, the CFTC's attempt to regulate credit default swaps generated a firestorm of opposition from the financial industry, the Federal Reserve, Treasury Secretary Robert Rubin, and powerful members of Congress from both parties. Attempts in 2000 and 2001 by Sheila Bair, then head of the Federal Deposit Insurance Corporation, FDIC, to create a voluntary set of mortgage underwriting standards were undermined by Federal Reserve officials. Legislative efforts in both Georgia and New Jersey to tighten the regulation of mortgage lending in the early 2000s prompted furious objections from Wall Street power brokers and Washington regulators. After these 2 states made the securitizers of mortgage loans liable for damages if the underlying debts resulted from fraudulent transactions, ratings agencies refused to assess securitizations that included loans from New Jersey or Georgia, leading legislators to repeal key elements of their reforms. Federal banking regulators also moved to exempt federally chartered financial institutions from state oversight of mortgage practices. At moments like these, the policy decisions that facilitated new avenues for fraud were refusals to impose new regulations, rather than repeal of long-existing rules or atrophy of hard-nosed enforcement. One needs to place the evolving priorities of so many anti-fraud officials in the context of resurgent American anti-statism. Throughout the 20th century, conservative political thinkers had never lost their skepticism of onerous regulation, even as the consolidation of New Deal institutions marginalized this viewpoint. Antagonism toward heavy-handed, intrusive economic regulation regained some credence from the academic critiques of the regulatory state put forward by Marver Bernstein, Gabriel Kolko, George Stigler, and Richard Posner, as well as scores of additional studies that built on their premises. By the time of the Carter administration, expectations that regulatory agencies would bog down in bureaucratic morass had seeped into conventional wisdom. Social scientists across the political spectrum tended to portray those agencies as favoring big business at the expense of smaller competitors and consumers, whether by design, through continuous lobbying by corporate interests, or because officials came to identify with the firms they regulated. Macroeconomic developments intensified with the appeal of these critiques, alongside companion proposals for formal deregulation. The persistent inflation caused by Vietnam War spending and Middle East oil shocks heightened concern about regulatory costs. With consumer prices rising 8% and then 15% a year in the 1970s, it became easier to argue that government officials could best look out for consumers by reducing regulatory burdens on corporations, because the latter responded to new rules by raising prices. Technological developments in some fields, such as telecommunications and banking, made existing regulatory frameworks seem like barriers to rapid adoption of efficiency-enhancing innovations in digital data services, cellular networks, financial data processing, and automatic teller machines. By the 1990s, the winds of globalization, fostered by global trading frameworks that reduced tariffs and non-tariff trade barriers, also appeared in arguments for loosening up regulatory constraints. Unless America removed regulatory fetters, the argument ran, U.S. firms would continue to lose out to less regulated competitors, whether in emerging markets or to long-standing rivals such as London's financial markets. Permeating these arguments was a deepening faith in the pervasiveness of economic rationality and the transformative power of markets. Building on the arguments of George Stigler and Richard Posner, critics of restrictive regulation beseeched policymakers to reconsider how individuals made economic decisions and how markets adapted to problems such as deception. Most economic actors could look out for their own long-range interests. Absent regulatory mandates, companies would still disclose relevant financial data to lower their capital costs. Corporate executives would safeguard their good names by insisting upon trustworthy internal accounting, just as retailers would stand by promises in order to cultivate goodwill. For similar reasons, auditors, underwriters, and legal counsel would take care to sustain their reputations. To the extent that fraudulent behavior intruded into marketplaces, critics of aggressive anti-fraud regulations adopted a Schumpeterian perspective, arguing that market discipline and entrepreneurial innovation offered the best means of addressing such problems. If firms misled investors or customers, any immediate gains would be counterbalanced by reputational consequences, especially in the case of settled businesses that had no intention of emulating the fly-by-night crowd. Over the long term, one could count on informational intermediaries to guide economic actors in assessing the trustworthiness of counterparties. This set of ideas, then, incorporated key dimensions of the earlier legal framework of caveat emptor. Adherents of this view also stressed the significance of long-term structural changes in American financial markets. By the 1980s, most purchasers of financial assets were not individuals, but rather mutual funds, pension funds, insurance companies, and hedge funds. Managers at these organizations presumably had the education, training, and moxie to look out for themselves as well as the interests of the investors, workers, and policyholders whose capital they controlled. Policy elites did not always broadcast these understandings, beliefs, and more inchoate attitudes about business fraud. Indeed, public rhetoric sometimes masked private belief, which seems to have been the case for Alan Greenspan, the powerful member and then chair of the Federal Reserve Board who served from 1987 to 2006. In his 2007 memoir, written as concerns about mortgage fraud were beginning to crest, Greenspan described the rooting out of fraud as an area in which more rather than less government involvement is needed. Deceit, he proclaimed, was the bane of the market system, a destroyer of the market process itself, because market participants need to rely on the veracity of other market participants. Accordingly, he advocated greatly stepping up enforcement of anti-fraud and anti-racketeering laws. In private, during the late 1990s and early 2000s, Greenspan seems to have sung a different tune. According to journalist Joe Nocera and former regulator Michael Greenberger, the Fed chair made clear in discussions about banking deregulation that he didn't believe that fraud was something that needed to be enforced or was something that regulators should worry about, because the market will figure it out and take care of the fraudsters. On occasion, decision-makers did bring such thinking more fully into view. Federal Circuit Court Judge Edith Jones demonstrated how these assumptions could shape judicial reasoning in a 1997 securities fraud class action involving alleged misrepresentations by a Texas used car lot chain that focused on high-risk customers. As a partial justification for the court's decision to throw out this suit, which investors had brought against the corporation and its auditors, Coopers & Lybrand, Judge Jones found that the plaintiffs had not demonstrated the accounting firm's motive for certifying the adequacy of financial reports that they allegedly knew to be misleading. Accounting firms, Jones conceded, like all rational economic actors, seek to maximize their profits. But because an accountant's greatest asset is its reputation for honesty, it was extremely unlikely that Coopers & Lybrand was willing to put its professional reputation on the line by conducting fraudulent auditing work. For Jones, the legal default was that powerful economic players would not risk reputational capital. Entrepreneurial innovation and business fraud in Greenspan's America. The tilting of regulatory discretion toward permissiveness after 1980, even in the face of credible evidence of far-reaching intentional deception, underscores the importance of more diffuse norms and cognitive defaults as shapers of business environments. At the height of America's recent age of deregulation, politicians and policymakers lionized risk-taking, innovation, short-term monetary incentives, and market discipline as the most desirable features of modern economic life. Such ideals, which also received a thorough airing in business schools and managerial discourse, seemed like a much-needed tonic for shaking off 1970s stagnation and meeting the stiff challenges of European and Japanese competition. Over the 1980s and 1990s, these shifts in public values encouraged aggressiveness among business executives. So did bold takeover campaigns by corporate raiders such as Michael Milken and Carl Icahn, who threatened sleepy corporations with leveraged buyouts. Investors channeled money and the business press directed plaudits toward brash, hard-headed managers. Both groups also advocated restructuring executive compensation to align the interests of managers with shareholders, whether through bonuses or stock options. Such compensation schemes spread rapidly in the 1990s, justified as ways to maximize shareholder value. Amid the resulting unforgiving, hyper-competitive environment, upper-level managers could more easily rationalize sharp business practices. Those executives confronted insistent expectations from institutional investors for short-term stock performance. Executives, in turn, pressured middle managers to achieve ever more ambitious quarterly production goals and sales quotas. As one business ethics consultant summarized the general orientation of corporate America in the early 1990s, "The message out there is, reaching objectives is what matters, and how you get there isn't that important." By the late 1990s, rank and yank became a standard technique of assessing managerial performance at both brash new corporations, such as Enron, and many companies with a much older pedigree, such as General Electric. Managers with the best rankings received promotions and enviable remuneration. Those in the middle received minimal raises and goads to improve. Those at the bottom found themselves looking for new jobs. This approach to managerial evaluation generated strong incentives to shade internal financial statements, with some confidential surveys indicating that as many as 1/3 of corporate managers had intentionally falsified reports. In many of the biggest instances of corporate accounting manipulations of the late 1990s and early 2000s, mid-level managers and internal accountants alleged far more coercive pressure to assist in systematic deception. At companies such as WorldCom, Enron, Sunbeam, and HealthSouth, chief executive officers, chief financial officers, and other high-level executives badgered subordinates to deliver reports that would meet market expectations. At HealthSouth, according to an eventual federal criminal complaint, CEO Richard Scrushy and CFO Michael Martin set targets for earnings per share and then instructed internal accountants to find a way to meet the numbers. The resulting conclaves, referred to as gatherings of the family, focused on how to fill the holes in the corporation's earnings with sufficient dirt, by which prosecutors alleged they meant modes of inflating revenues. An analogous mindset filtered into the organizational culture of private gatekeepers such as accounting firms, investment analysts, ratings agencies, and law firms. These providers of business services came to stress profitability themselves, which eroded dedication to professional responsibility. Resulting conflicts of interest undermined commitments to transparency and investor protection. The weakening of legal constraints and social norms against deceit unleashed a Gresham's dynamic in American financial markets, that is, duplicitous business practices drove out less ruthless approaches, in some contexts even fostering business cultures that normalized criminal behavior. The mantra of shareholder value, measured in terms of quarterly financial results, pushed the sensibilities of the used car lot into corporate boardrooms and cubicles, the offices of white-shoe law firms, and the workplaces of auditors. Throughout the early 21st century chain of American debt financing, sharp competition led thousands of businesses down this path. Real estate agents and appraisers, mortgage brokers, loan underwriters, and analysts at credit rating agencies all grasped that if they balked at the prevailing strategies for feeding the maw of debt securitizers, they risked lost business, disapproving peers, and angry bosses. Real estate agents and mortgage brokers who did not tout liar's loans and steer low-income Americans into abusive loan products gave juicy commissions away to their competitors. Appraisers who balked at signing off on inflated property value estimates could look forward to lonely afternoons in their offices. Undertrained and understaffed employees at third-party loan quality assessors learned how to say yes and say it quickly, or found themselves holding pink slips. Within investment banks that oversaw the sausage-making of securitized debt instruments and the ratings agencies that assessed their riskiness, decision-makers contended with similar pressures. Investors had come to expect investment returns that only high volume could provide, and high volume required minimal regard for candor about the underlying quality of debt. Ratings agencies complied with demands that they certify collateralized mortgage instruments as investment grade, even if they contained all manner of trash and garbage. They knew that refusals meant a loss of extremely profitable business. As the CEO of Citigroup, Charles Prince described the imperative of matching the business practices prevalent in the financial industry. As long as the music is playing, you have to get up and dance. The central rationale for deregulation was to spur technological, organizational, and financial entrepreneurship, to unleash the creative energies of individuals and firms. But the longer trajectory of U.S. business and legal history demonstrates enduring links between far-reaching commercial innovation, Joseph Schumpeter's process of creative destruction, and fraud. Fraudulent business practices and investment schemes have always clustered in sectors at the frontiers of economic change. This was so for Western real estate development, railroad building, and mail-order marketing in the 19th century, for early 20th century ventures in radio, aviation, and mutual stock funds, for mid-20th century home improvement companies and franchising schemes. Consumers and investors confront significant asymmetries of information on the entrepreneurial margin, while the latter often prove less skeptical about dubious representations, because new technologies, marketing approaches, and organizational strategies encourage visions of killer capital gains. The disorder unleashed by transformative innovations, economist Paul Krugman noted in reflecting on the implications of Enron's collapse, creates the kind of confusion in which scams flourish. How do you know whether a company has really found a highly profitable new economy niche or is just faking it? Whenever a cycle of creative destruction unleashes a speculative boom, the temptation to engage in profitable misrepresentation spreads, as does susceptibility to overconfident estimations of investment prospects by promoters and investors. When optimistic financial markets lead the public to believe in magic, Krugman observed, it's springtime for charlatans. Formal rules and informal norms, moreover, tend to be less clear in sectors undergoing entrepreneurial disruption, which makes it easier for economic actors to embrace strategies that strike counterparties and other observers as deceptive. Novel economic situations, such as 19th-century mail-order commerce, often lack established moral and legal anchors. Such circumstances amplify the incentives to take advantage of information asymmetries, while offering individuals ample ground to argue, to themselves and to others, that they did not transgress any established prohibitions. Indeed, research in cognitive psychology suggests that creative individuals, the sort likely to be at the forefront of entrepreneurial innovation, are more adept at rationalizing self-dealing and forms of commercial dishonesty, of coming up with good stories that help justify selfish interests, and developing original paths around rules, all the while allowing individuals to reinterpret information in a self-serving way. Insofar as innovation leads to newfangled financial instruments or unprecedented accounting questions, it also fosters ways to hide unanticipated problems behind a facade of hard-to-decipher accounting. Some of the larger fraud episodes in the late 20th and early 21st centuries fit this enduring historical pattern. The cluster of Medicare and Medicaid reimbursement scandals turned, in part, on the complex question of how to assign standardized payment codes to hospital treatments. On the margin, should back-office staff characterize services rendered to a patient with a bleeding ulcer as diagnostic-related group DRG 155 bleeding ulcer or DRG 154 bleeding ulcer with complications, the latter of which triggered higher payment from the government? During the 1990s, private hospital chains and many non-profit healthcare providers answered that question by training billing staffs in upcoding, the healthcare analog of upselling. Instead of jawboning customers into purchasing pricier models, the idea was to find justifications for moving medical treatments into more expensive accounting categories, as by making sure that ulcer patients received nutritional workups. At Enron, executives embraced the goal of transforming a one-time energy pipeline company into a financial services juggernaut, dedicated to the invention of new derivatives contracts, energy market platforms, and modes of organizing business units. Enron's leaders touted the advantages of pursuing large-scale projects and managing the resulting risks through complicated hedging strategies. This invocation of entrepreneurial risk-taking, in combination with rank-and-yank employee performance reviews, created strong incentives for misleading depictions of business results, as well as manipulation of the new energy markets. The labyrinthine nature of so many Enron activities and financial products facilitated these misrepresentations, as did the optimism fostered by internal breastbeating, years of outsized stock performance, and accolades from the business press. The biggest business frauds of the post-1980 period depended on the opacity that has so often accompanied the most abstruse financial innovations. Rottenness in the chain of debt securitization depended on the complexity of collateralized debt obligations and credit default swaps. In the early 2000s, financial engineers found even more intricate ways to construct securities out of other financial assets, extending the risk management principles of portfolio diversification. Investment bankers started with mortgage-backed securities, MBS, assets backed by scores of mortgages. From the 1960s through the 1980s, the MBS market was limited to securities marketed by the Federal National Mortgage Association, Fannie Mae, and the Federal Home Loan Mortgage Corporation, Freddie Mac, federal agencies that packaged loans meeting strict government underwriting standards. During the 1980s and 1990s, Wall Street bankers saw an opportunity to emulate this approach first with jumbo mortgages, whose higher loan amounts made them ineligible for bundling by Fannie Mae or Freddie Mac, and later with higher-risk subprime mortgages, as well as car loans, credit card balances, and commercial loans. Securitizers purchased pools of mortgages or other forms of debt and sliced them into different tranches, which possessed varying degrees of risk. The first tranche would receive the initial slice of payments from the overall pool, the last would receive the very last payments, and so had the highest risk. Once these debt-backed securities gained significant traction in the financial markets, some underwriters realized that they could extend this approach by creating a new type of security, called a collateralized debt obligation, CDO. This financial instrument would be made up of a given tranche from many different collateralized obligations of a given type of debt. Some financial alchemists went yet one step further, creating CDOs out of a pool of underlying CDOs. Others created credit default swaps, which gave CDO investors the opportunity to hedge their positions through premium payments linked to estimations of default risk, and speculators a means of shorting a given debt market. As soon as credit default swaps became commonplace, investment banks came up with synthetic CDOs built out of pools of credit default swaps. One insider described the process of assessing the quality of a plain vanilla CDO as akin to taking 10 different vegetables and pureeing them in a food processor until you have something close to soup. Ask someone to identify the ingredients, but don't let him taste it. Make him rely strictly on his sense of sight. Your concoction is sure to make him wonder what's inside. Each level of additional securitization further muddled the soup. Even sophisticated American investors had great difficulty in scrutinizing the resulting financial stews. As a result, they tended to rely on the judgments of ratings agencies, which investment banks paid to assess the risk associated with these complex financial instruments. Despite the rickety foundations of underlying mortgages, car loans, or other debts, Moody's, Standard & Poor's, and Fitch ratings all treated the upper tranches of synthetic CDOs as gilt-edged investments, reasoning that diversification and over-collateralization provided safety. They accordingly furnished them with AAA ratings, equivalent to the seals of approval given to the least risky corporations and sovereigns with unimpeachable credit. This rating made the complicated instruments eligible for the portfolios of insurance companies, pension funds, and other institutional investors that were prohibited from buying risky assets. Such analytical snake oil was facilitated by the novelty of collateralized debt and loan obligations, which posed new questions about how to assess their riskiness. Analysts at ratings agencies based their risk models on historical payment data that went back only to the late 1980s, when the market for them became sizable. That choice absolved them from reckoning with the possibility of a nationwide downturn in property values, something that had not occurred since the 1930s. Wall Street received a signal about the vulnerabilities of experienced corporate investors in evaluating complex structured debt vehicles during the early 1990s as a result of fraud allegations leveled against Bankers Trust by Gibson Greetings Incorporated and Procter & Gamble. Brokers at Bankers Trust convinced senior executives at both companies to enter into interest rate swaps that they did not understand, leading Bankers Trust employees to joke about how they were taking advantage of their counterparties. The far more convoluted structures of CDOs multiplied openings for sharp dealing, as demonstrated by the Abacus affair at Goldman Sachs. At the height of the real estate bubble in 2007, a Goldman Sachs client, the Paulson hedge fund, wanted to short the subprime market, a strategy that Goldman was also employing. Goldman traders obliged by allowing Paulson to select several mortgage-backed securities with weak assets as the basis for a specific synthetic CDO in a class of financial instruments that the investment bank had dubbed Abacus. Goldman then sold the financial instrument to 2 European banks without disclosing Paulson's participation in the selection process. It instead emphasized the role of a third party that specialized in this work and helped Paulson purchase credit default swaps against the new security. This arrangement cost the banks nearly $1 billion, with Paulson profiting by a similar amount. Such predatory conduct recalls the tactics of Gilded Age promoters of fake companies and blind stock pools, or 1960s inner-city retailers who sold shoddy merchandise on credit before transferring debts to Confederate finance companies. The fabulous bonuses available to wizards of the modern debt trading desks encouraged this sort of behavior. But it is hard to see how such practices could have become standard operating procedure within Wall Street's loftiest firms without a quarter-century's worth of public veneration for imaginative financial invention. If the inventors of CDOs and synthetic CDOs, the analysts who rated them as AAA, or the salesmen who peddled them harbored any doubts about the propriety of their daily work, they could console themselves with reflections on the capacity of financial innovation to tame risk and sustain America's competitive position in the global economy. Pockets of regulatory action. Through several channels, then, neoliberal preferences to constrain government regulation encouraged businesses, including prominent corporations, to take greater liberties with marketing practices and financial reporting. But in spite of the dominant tendency toward deregulation and faith in unrestrained innovation, the period after 1975 also included moments of heightened regulatory stringency. These episodes often followed close on the heels of fraud scandals that garnered the attention of journalists, consumer groups, business elites, and governmental officials. Amid the moves toward regulatory disengagement, there were sporadic efforts to pin back opportunities for overbilling, phony accounting, and other forms of commercial or financial deceit. One such regulatory counterstrike sought to root out government contracting fraud in defense procurement and health care reimbursement. Stung by revelations of massive overcharging by defense contractors and confronting $100 billion annual deficits resulting from Reagan administration tax cuts, Congress enacted the Federal False Claims Act in 1986. Much like the Civil War-era statute on which it was based, the False Claims Act provided a mechanism for whistleblowers to bring fraudulent billing to light through private lawsuits. Ongoing post-Reagan budget deficits also heightened congressional concern about waste, fraud, and abuse in federal spending, which prompted tighter regulatory oversight and expanded investigative and prosecutorial capacity in the Departments of Defense, Health and Human Services, and Justice. A parallel burst of anti-fraud regulation occurred in response to the S&L crisis. In this case, elected officials viewed tough regulatory action as vital because of potential costs to the United States Treasury resulting from public deposit insurance. In 1989, President George H.W. Bush signed the Financial Institutions Reform, Recovery, and Enforcement Act, FIRREA, into law. FIRREA created a new regulatory overseer of savings and loans, the Office of Thrift Supervision, gave that agency authority to remove S&L officers and directors for malfeasance, and established new sanctions for false financial reports. It also increased civil and criminal penalties for the insider looting that had driven so many thrifts into financial difficulties, created mechanisms for disgorgement of assets illegally obtained by bank executives, and tightened standards for loan-related appraisals of real estate. In addition, the S&L crisis was one rationale for the statutory establishment of a federal sentencing commission. Among other tasks, Congress charged the commission with devising formal sentencing parameters in cases involving white-collar crime, so that individuals and organizations convicted of fraud and other forms of financial malfeasance would not so readily avoid hefty fines and/or jail time. During the late 1980s and early 1990s, federal agencies coordinated thousands of S&L-related criminal investigations, which culminated in over 1,000 felony convictions. Mirroring the SEC's moves in the 1970s against gatekeepers who abetted financial frauds, the FDIC also went after prominent accounting and law firms that provided auditing and legal services to failed S&Ls, seeking monetary recompense for their breach of fiduciary duty and negligence. Settlements resulting from these cases reached as high as $400 million. The dot-com era's corruptions involving financial analysts and accounting frauds generated still another intense round of anti-fraud policymaking. One important locus of action occurred in New York State, where Attorney General Eliot Spitzer directed investigations into Wall Street conflicts of interest. The inquiry uncovered emails in which financial analysts described the high-flying Internet stocks that they publicly touted, and which brought their investment banks lucrative underwriting fees as crap and dogs. These revelations led to a global settlement with several large brokerages and investment banks, which compelled them to pay more than $1 billion in fines, change compensation practices, and disclose financial interests linked to recommended stocks. That same year, Congress passed the Sarbanes-Oxley Act, which tightened standards for corporate accounting, created a new oversight board for financial reporting, prohibited auditing firms from undertaking consulting work that created conflicts of interest, and mandated the medium-term rotation of external corporate auditors. In addition, the legislation delegated new regulatory responsibilities to corporate officials, requiring corporate attorneys to report instances of false accounts or other securities frauds, and mandating that corporate executives certify the truthfulness of financial reports. According to several leading scholars and economists, these new rules and monitoring structures improved the quality of internal and external auditing, as well as corporate financial reporting. Once large corporations implemented adjustments to internal audit systems, moreover, initial complaints about compliance costs dissipated. The most ambitious spurt of anti-fraud regulation occurred in the wake of the 2008 global financial crisis, centered on the Dodd-Frank Act of 2010. This mammoth statute sought to make the financial system more stable and reduce the risk of massive public bailouts for imperiled financial institutions. It also targeted the sort of deceptive marketing and fraudulent behavior that had helped to cause the 2008 crisis. Dodd-Frank authorized a well-funded, powerful new Consumer Financial Protection Bureau, CFPB, following the blueprint of then Harvard Law professor Elizabeth Warren, who first proposed such an agency in 2007. Located in the Federal Reserve, the CFPB had a single director rather than the more cumbersome arrangement of multiple commissioners, obtained funding from the Fed independent of annual congressional appropriations, and received a broad mandate to combat deceptive practices in consumer and residential lending. Dodd-Frank also established new disclosure standards for mortgage lending and loan securitization, tightened oversight of debt ratings agencies, and required that corporations adopt mechanisms to claw back incentive-based executive compensation based on false financial results. Two additional overlapping anti-fraud initiatives have occupied elected officials and national regulators in the late 20th and early 21st centuries, albeit with far less public fanfare. Congress, the FTC, state authorities, and consumer-oriented NGOs have waged intense campaigns against elder fraud, commercial or financial deceptions that target senior citizens, and Internet fraud. Since 1980, these campaigns have spawned more than 20 congressional hearings, recurrent legislation and administrative rulemaking, and large investments in public education. As a result of the Telemarketing and Consumer Fraud and Abuse Prevention Act of 1994 and subsequent FTC regulations, for example, telemarketers faced a much more restrictive legal environment. They were prohibited from using deceptive icebreakers to disguise the sales focus of calls, misrepresenting the cost, quantity, and other aspects of the offered goods or services, and offering recovery services that promise to aid aggrieved consumers in gaining refunds from previous scams. Businesses that ignored these rules were subject to injunctions, fines that could reach up to $11,000 per violation, and restitution orders. State attorneys general also received authority to bring enforcement cases in federal courts, which, as an observer of the industry noted, placed 51 new cops on the national telemarketing fraud beat. Even before the adoption of these regulations, the FBI, Justice Department, Postal Inspectorate, and state consumer protection agencies mounted major enforcement sweeps against fraudulent telemarketers, such as Operation Disconnect in 1993, Operation Sunstroke in 1994, and Operation Senior Sentinel in 1995. Adopting the same tactics as Anthony Comstock a century earlier, these campaigns used decoy customers and undercover employees to marshal evidence, and generated criminal prosecutions of hundreds of businesses and individuals. Once the FTC finalized its rules in 1995, it carried out further investigations in conjunction with state authorities through Project Jackpot, which led to dozens of enforcement lawsuits in 1996 alone. In the early 2000s, the FTC and SEC coordinated similar wide-ranging investigations of Internet fraud, such as Operation Top10.Cons in 2000, Operation Bidder Beware in 2003, and Operation Empty Promises in 2011. Reflecting the international character of e-commerce, these endeavors drew on the assistance of not only federal and state agencies, but also consumer protection officials from many other countries. Outside the realm of governmental policy, the continuing salience of business fraud prompted extensive media coverage. Consumer groups continued their missions of education and cooperation with law enforcement, but now deployed online information clearinghouses and complaint mechanisms. Thus, the National Consumer League established Fraud.org in 1996, while the American Association of Retired Persons, AARP, beefed up its online anti-fraud initiative in the late 1990s. Like earlier organizations focused on consumer and investor protection, these websites offered compendiums of specific scams and more general warning signs, as well as guidance about how to make effective complaints. From as early as 1996, specific complaints to Fraud.org fed a national fraud database used jointly by the FTC and the National Association of Attorneys General. AARP also replicated earlier communal tactics of reliance on dispersed volunteers, encouraging its members to become official fraud fighters who educated neighbors about prevalent rip-offs and served as community sentinels. A growing number of firms also sought profitable angles in the public demand for fraud protection. These third-party certifications would not only reassure consumers and businesses that online firms were real businesses, but also that they eschewed deceptive practices. Providers such as Square Trade offered the use of a digitally watermarked seal, which sellers could obtain on the basis of reference checks, evidence about customer service, and a pledge to use the website's dispute resolution mechanism. A competing approach focused on giving consumers an outlet to vent anger toward firms that they viewed as having ripped them off or treated them shabbily. At sites such as ripoffreport.com, scambook.com, my3cents.com, and pissedconsumer.com, disgruntled Americans could tell their side of individual transactions gone sour in their own unedited words. Their stories found audiences in the tens of thousands. Consumer sites less focused on fraud, such as Yelp and TripAdvisor, amplified the capacity of consumers to share marketplace experiences. Through all of these online communities, scathing reviews mirrored the 19th century signs that warned of Peter Funks, the cautions in early 20th century BBB newsletters, and leaflets distributed by CEPA members. They brought a communal hue and cry to bear on the online cheat. Whether through certifying trustworthiness or magnifying consumer gripes, these innovations aimed to prevent sharp dealing through timely provision of information about the behavior of businesses. Yet there were also profound limitations to these modes of informal regulation. So many entities offered trust marks that their value depreciated. Amid a scramble for market share, some certification schemes did minimal screening and so suffered from adverse selection, attracting businesses that needed a boost for compromised reputations. Sites with more stringent requirements often struggled to earn enough business to remain afloat. As soon as consumer complaint sites gained traction with web users, they drew criticism as constituting a new Wild West. Spokespersons for some businesses pointed out that without editorial or regulatory filters, the truthfulness of reports remained open to question. Complaint sites could become platforms for false allegations by disgruntled employees or rival companies. An emerging set of reputation management firms claimed that these websites engaged in a form of extortion, reminiscent of the appliance repair scams of the 1950s and 1960s. After posting devastating reviews, these critics alleged, the sites offered to scrub them for a fee or in exchange for advertising placements. In 2011, by contrast, ripoffreport.com discovered that its site had been hacked by a reputation management firm, which then removed negative commentary about its clients. After a comprehensive 2010 study, the Consumer Federation of America concluded that the great majority of complaints on the most reputable websites were genuine. But the report stressed a different shortcoming. Even when rants about abusive or fraudulent practices warned off future consumers, they did nothing to redress past injustices. The tellers of commercial tales of woe on pissedconsumer.com could not count on site visitors to join them as they visited a place of business to seek redress, nor to participate in actual pickets if it was not forthcoming. Still other organizations and businesses focused on the burgeoning problem of deceit inside large-scale corporations. Concern over the accounting dimensions of the S&L crisis prompted Joseph Wells, a Texas CPA who had spent part of his career with the FBI, to establish the National Association of Certified Fraud Examiners, NACFE, in 1988. Headquartered first in Dallas, ground zero of the S&L debacle, NACFE gained thousands of members who saw the opportunity to offer specialized services to companies. The organization offered professional development courses, credentialed accountants who passed a 2-day exam in forensic accounting, and kept its members abreast of financial innovations, ongoing fraud investigations, and shifts in regulatory policies. A few years after its launch, it dropped the word national to reflect its move onto the international stage and began to commission annual studies of fraud costs, pegging them at $400 billion a year in the United States for 1994, roughly 6% of overall economic activity. Although this organization focused on aspects of occupational fraud, such as embezzlement, it also paid attention to the issues posed by corporate deceptions that harmed suppliers, customers, and investors. During the 1990s, the proliferation of deceit within the corporate world led major accounting firms to hire scores of ACFE certified accountants. It also prompted the emergence of boutique firms specializing in forensic accounting, and convinced some providers of general investigative services to corporations, such as Kroll Associates, to invest in fraud-related consulting services. After 1975, self-regulatory organizations continued to dot the American anti-fraud landscape. The Better Business Bureau network sustained its national coverage, though it experienced a slight drop in the number of local chapters, settling around 115. At the behest of business leaders who felt under siege from class action lawsuits, local BBBs initiated formal dispute resolution programs in the late 1970s, and then encouraged members to handle unresolvable consumer complaints through BBB-trained arbitrators. The bureaus also offered this service to consumers whose complaints it viewed as legitimate, and which were not resolved through initial mediation. Arbitration rapidly became a central BBB endeavor, with as many as 1/3 of member businesses in some metropolitan areas pledging to abide by its outcomes. Several national corporations also turned to the program to handle disputes over warranties. As a result, BBBs recruited thousands of attorneys and other volunteers across the country to serve as arbitrators. BBBs were also early movers into cyberspace, connecting local bureaus to the Council of BBBs website, which offered scam alerts, a library of tips for avoiding rip-offs, searchable databases of business reviews, and the opportunity to file a complaint from one's keyboard. In the late 1990s, the organization created its own trust mark, an online BBB torch available only to member firms, ostensibly testifying to integrity and fair dealing. A decade later, it introduced a more elaborate system of accreditation for all enterprises. BBB staff members based their system of letter grades, A to F, on information provided by businesses, the BBB's own records of how they handled consumer complaints, and whether or not the firms were BBB members. These grades went into the BBB online database of business reviews. In 2014, the Council of Better Business Bureaus also launched Scam Tracker. Drawing on the crowdsourced input of consumers, this free interactive online tool gave consumers and law enforcement officials a heat map showing where scams are being reported. Nonetheless, the criticisms leveled at the BBBs at the height of the 1970s consumer movement did not fall away. From the 1980s onward, the BBB's own marketing practices attracted media scrutiny. Journalists found that some local BBBs had pursued aggressive strategies to boost dues-paying membership, raising questions about conflicts of interest and flirtations with deception. After the introduction of accreditation grades, more serious allegations surfaced that some BBBs would upgrade ratings if businesses agreed to become members. The sharpest allegations came from firms with poor BBB ratings, which portrayed the network as having become a private interest that pursued the sort of pay-for-play scheme that its leaders had long decried when practiced by others. After a 2010 expose on the ABC News program 2020, which documented the ease with which fictional businesses could achieve BBB ratings of A or A+, the BBB network pledged to revamp its accreditation process, removing any advantages associated with membership. Toward the end of the 20th century, new forms of anti-fraud business self-regulation emerged alongside the BBBs and the Securities and Commodities Exchanges, lodged inside America's largest corporations. Within sectors dependent on government contracting, such as defense and healthcare, corporate leaders once again turned to self-regulatory experiments as a means of deflecting pressures for more statist regulatory oversight. As the press and Congress bore down on defense suppliers in the 1980s and healthcare providers the following decade, each developed elaborate internal ethics and compliance departments charged with reforming billing practices. These new bureaucracies took on all of the classic regulatory functions. They generated mission statements and more detailed codes of conduct, as well as training modules for corporate staff. Contractors created ethics and compliance officers at subsidiaries and within divisions, and established anonymous phone hotlines to encourage flows of information about problematic behavior in the ranks. Just as stock exchanges used the latest computer software to identify trading patterns that suggested illegal manipulation, defense and healthcare firms developed computer algorithms that identified evidence of suspect coding or billing patterns. Hospital companies centralized coding and billing operations, while nudging far-flung medical facilities to forge cultures of regulatory compliance and voluntarily disclose problems affecting corporate contractual relationships with government. In both defense and healthcare, leading firms forged industry-wide organizations, the Defense Industry Initiative and the Healthcare Compliance Association, to share experiences and hone best practices. Some corporations vulnerable to fraud or dependent on consumer confidence took even more elaborate steps to combat deceitful behavior. Credit card companies confronted waves of fraudulent charges in the 1990s, both from unscrupulous businesses and as a result of stolen cards. To head off this threat, card issuers invested several $100 million in security features, as well as computer systems that would identify suspicious purchasing patterns. Once alerted, Company employees or automated calling systems contacted cardholders to verify that payments were legitimate. As web commerce took off, the prevalence of online auction fraud threatened public confidence in new platforms for commercial transactions. The popular auction and direct sales site eBay responded by building a robust internal fraud unit directed by a former prosecutor and by fashioning an elaborate governance structure for online sellers and buyers. These systems relied on satisfaction ratings from buyers and sellers and sophisticated computer programs to identify individuals who engaged in bid rigging, misrepresentation, or non-delivery of goods. Such measures improved eBay's ability to warn users about abusive sellers and shut down the worst offenders. When the company's CEO, Meg Whitman, became convinced that endemic deceit endangered profitability, she marshaled the financial resources and expertise to address the problem. As Whitman explained in a 1999 press release trumpeting new upgrades to the site's anti-fraud software, eBay has zero tolerance for fraud. Noting that fraud and other trust and safety issues are not new, she emphasized that eBay's solutions are. We will continue to commit resources to have the most comprehensive programs in order to keep eBay a safe harbor for online person-to-person trading. Ghosts of the regulatory past, present, and future. What to make of all this anti-fraud activity punctuating a neoliberal age? There are analytical dangers for historians who venture onto the terrain of the recent past. One reason so few have surveyed contemporary business culture, political economy, and regulatory institutions. Nonetheless, the longer arc of business fraud and anti-fraud regulation in the United States suggests some useful frames of reference. One important insight concerns an enduring feature in American political economy. Policymakers have never been comfortable with pure reliance on the checks and balances within markets to control duplicity. As the threat that business fraud poses to economic confidence becomes more obvious to journalists, academics, the business community, government officials, and the wider public, pressures for regulatory reform mount, and policy entrepreneurs come forward with specific plans of action. Prevailing ideas about the trustworthiness of government nonetheless have channeled regulatory responses. During the Progressive Era, the New Deal, and the 1960s and 1970s, supporters of tougher measures against fraud thought in terms of administrative bureaucracy. By contrast, late 20th century policymakers manifested abiding skepticism about this institutional orientation. The move against contracting fraud was spearheaded by Charles Grassley, a conservative Iowa senator. He structured the 1986 False Claims Act around private legal actions by whistleblowers, who would share handsomely in any monies that the government recouped as a result of their revelations. Federal policymakers also sought to delegate much of the responsibility for preventing fraudulent billing to contractors. The Reagan administration's Packard Commission, convened to devise ways to curb procurement fraud, prodded defense companies to embrace self-regulation. The movement to create ethics and compliance departments gained a further boost from the 1991 federal sentencing guidelines for criminal convictions, which promised easier treatment for corporations that could show good faith efforts to rein in wrongdoing by their employees. By the same token, private modes of regulation dominated responses to online business fraud, in part because government policymakers shied away from forceful actions during the web's formative years. As President Bill Clinton described this largely bipartisan consensus in a 1998 press briefing, "We will do nothing that undermines the capacity of emerging technologies to lift the lives of ordinary Americans." Experiences with American business fraud since the mid-1970s also replicated earlier patterns concerning the workings of self-regulatory organizations or self-regulatory mechanisms within corporations. When leaders of firms and industries saw that anti-fraud regulation mattered to policymakers, self-regulation could make a difference. So long as executives and trade association heads had to look over their shoulders at public regulators and prosecutors, they had strong reasons to make regulatory compliance a priority. This level of concern existed in the wake of defense and healthcare contracting scandals. The spotlight of congressional hearings and journalistic exposés, along with the pressure of whistleblower lawsuits and federal investigations, spurred meaningful commitments to clean up abuses. By contrast, reliance on self-regulation without a credible expectation of accountability furnished the thinnest of regulatory veneers, unless businesses deemed anti-fraud mechanisms as crucial to profitability. Defense contractors and eBay had reason to make self-regulation work. Third-party mortgage loan reviewers and credit ratings agencies did not. Another recurring pattern involves the willingness of policymakers who dislike state regulation and who extol individual responsibility to make exceptions for consumers and investors whom they see as especially susceptible to fraud. During the height of adherence to a philosophy of caveat emptor, 19th-century prosecutors, judges, and juries demonstrated sympathy for allegations of fraud from elderly women or recent immigrants. Similar judgments led late 20th-century conservatives such as Charles Grassley to support the deployment of public resources against elder fraud, along pragmatic electoral considerations given the high propensity of senior citizens to vote. As the economic, political, and intellectual fallout from the 2008 global financial crisis continues to unsettle the United States, the degree to which this episode represents a regulatory watershed remains an open question. The recent crisis most certainly shook confidence in the integrity of markets, among elites as well as the general public. Whether that jolt will prompt a fundamental reorientation of American regulatory policymaking away from the neoliberal premises of caveat emptor is less clear. The establishment of the Consumer Financial Protection Bureau points toward a reassertion of the state's responsibilities to sustain public confidence in markets and protect the interests of vulnerable economic actors. Despite vehement political opposition from Republicans in Congress, which included a year-long opposition to the appointment of former Ohio Attorney General Richard Cordray as its director, the CFPB has moved ahead on numerous regulatory fronts. Incorporating some former employees of the Office of Thrift Supervision, which Dodd-Frank eliminated, as well as a corps of experienced bank examiners, the Bureau also hired hundreds of highly educated, idealistic staff members, many with experience in the financial industry, who embraced its mission to bring consumer protection to credit markets. Over its first 5 years, it conducted detailed studies on financial literacy, arbitration, the student loan sector, and the impact of financial coaching, injected a new concern for consumer impacts in the regulatory monitoring of bank and non-bank lenders, and formulated several new regulatory rules. The most important of the latter clarified underwriting and disclosure standards for mortgages and several forms of consumer credit. The Bureau initiated scores of enforcement actions against lenders, loan originators, mortgage servicers, and collection agencies that engaged in abusive or deceptive behavior, resulting in restitution of $2.6 billion to millions of Americans through 2015, as well as more than $7 billion in additional relief to consumers. CFPB officials reached out to the segments of the credit markets that they regulated, soliciting feedback on every aspect of the Bureau's decision-making, and forged relationships with other federal agencies and state and local counterparts. The Bureau has also brought a new intellectual sophistication to consumer outreach, information disclosure, and enforcement strategy. The CFPB's policy innovations recall the flexibility and institutional creativity of many earlier anti-fraud institutions. The thorny nature of business fraud, the challenges associated with detection, the complexity of prosecutions, the protean character of scams and systemic misrepresentations, has often encouraged experimentation in regulatory design and strategy, driven by aspiring groups of experts and professionals. In the late 19th and early 20th centuries, the key protagonists were accountants, scientists, a segment of the advertising community who wished to improve its status, and lawyers who built up regulatory bureaucracies. At the CFPB, this role has been taken up by a cluster of behavioral economists, cognitive psychologists, sociologists, and statisticians working in conjunction with legal staff. These experts have focused on tailoring educational materials, online complaint databases, and lender disclosures to improve their salience for borrowers, as with a less complex standard mortgage disclosure form that facilitates comparison shopping. They have also integrated analysis of complaint patterns into monitoring and enforcement, calibrating the degree of scrutiny that a lender, mortgage broker, or debt collector receives in light of its complaint profile. At the same time, some CFPB staff members have expressed frustration with bureaucratic decision-making. The need to gain clearance from the chain of command to go forward with an enforcement action, such as multiple rounds of review for policy proposals, struck these young public servants as reflective of excessive timidity. Important productive initiatives, one former staff attorney recalled, could get delayed all too easily by someone, seemingly at any level, suggesting it might make sense to wait for a more certain environment. This comment evokes the now century-old trade-off between adopting the most effective means of curtailing commercial deception and retaining respect for fair regulatory process and the rule of law. So too do critics of Operation Choke Point, a joint effort begun by the Department of Justice and the Federal Deposit Insurance Corporation, FDIC, in 2013 to combat a host of fraudulent and other illegal or disreputable businesses by disrupting their ability to receive funds through online payment systems. Almost everything about this initiative harkens back to the Post Office's late 19th century regulation of mail-order commerce. The categories of targeted businesses include credit card schemes, credit repair services, debt consolidation scams, get-rich products, lifetime guarantees, lottery sales, online gambling, pharmaceutical sales, Ponzi schemes, pornography, pyramid-type sales, and telemarketing. A list that echoes eerily the types of firms that Anthony Comstock and other postal inspectors attacked from the 1870s through the turn of the 20th century. After identifying enterprises that fell into these categories, the officials responsible for Operation Choke Point pressured banks and third-party payment processors to stop online transfers of funds to them. As with the postal fraud order, the idea was to take away access to the basic infrastructure of commerce. Also like the postal fraud order in its first decades, this refusal of admission to economic life occurred without notice, hearings, or any other basic features of due process. Such actions could have devastating impacts on fraudulent businesses, but also on any other individuals or entities singled out as requiring regulatory discipline. They struck some observers, both conservative and liberal, as a turn to an electronic panopticon, a dystopian world of limitation, control, and surveillance that could ruin lawful as well as illicit firms, the next Richard Sears, as well as the latest Sarah Howe or Charles Ponzi. If the early record of the CFPB and the dynamics of Operation Choke Point suggest comparisons to the late 19th century Postal Inspector's Office, the New Deal SEC, or the most energetic state consumer protection agencies of the 1960s and 1970s, other aspects of anti-fraud regulation in the wake of the global financial crisis point in different directions. From late 2012 through 2014, the Justice Department negotiated a series of civil settlements with the largest financial institutions whose deceptive practices had helped to trigger the crisis. These settlements have clawed back tens of billions of dollars in fines, set aside billions more for restitution to still struggling mortgage holders, and included admissions of systematic non-disclosures and misrepresentations. But as yet, almost no one within the financial world has faced criminal prosecution, whether for extensive efforts to generate a steady stream of subprime mortgages dressed up with false loan application data and phony appraisals, the systemic misrepresentations of the resulting mortgage-backed securities, or the lies that greased foreclosures. From the mid-2000s into the first term of the Obama administration, federal investigations of mortgage frauds were hampered by insufficient manpower, the disinclination of some banking regulators to participate in criminal probes, and a skimpy conceptual definition of mortgage fraud that the FBI had agreed to as part of a partnership with the Mortgage Bankers of America. High-ranking members of the Obama administration, such as Treasury Secretary Tim Geithner, also worried about the impact that criminal prosecutions might have on systemic financial stability. For many critics, though, the lack of criminal prosecutions smacked of favoritism to the wealthy and powerful. When viewed against 2 centuries of American encounters with large-scale financial frauds, the Department of Justice's record-setting mortgage fraud-related settlements look a bit like payoffs from the squawk fund that companies facing fraud allegations have always been willing to make in order to quiet the angriest dupes. Even as the headline numbers for these settlements have inched closer to $100 billion, they still represent only a fraction of the profits earned from a system of deceptive practices in the 6 or 7 years before the financial crisis. These deals also remain framed around enterprise liability, doing little to touch the immense wealth accumulated by the bank executives as a result of their control over the firm during the time of wrongdoing. By foreclosing an airing of the evidence that underpins these complex cases, the settlements have also short-circuited public assessment of the problematic business practices and oversight failures that led to such pervasive and systemic frauds. The same Congress that passed Dodd-Frank, moreover, enacted the 2012 Jumpstart Our Business Startups Act, JOBS. This bipartisan legislation expanded the number of companies exempted from the more onerous reporting requirements of the Sarbanes-Oxley Act, while slashing disclosure requirements for new companies looking to raise up to $50 million in capital. Far from signaling a post-crisis intent to clamp down on dissembling promoters, the Jobs Act rather sought to address persistent economic slack by widening the scope to entice capital into new ventures. Consumer groups and voices for responsible investing have expressed worries about the law's potential exploitation by the less-than-honorable fringe. We can expect ongoing arguments about how to balance concerns about business fraud and facilitation of beneficial innovation. Some voices will point to the financial crisis's grave costs and demand smarter regulatory policies that improve the flow of usable information to consumers and investors, while prohibiting the worst deceptions. Where possible, those who see themselves as victims of deceit will seek redress from regulatory institutions. This has been the tack taken by thousands of former students who took out guaranteed federal loans to study at for-profit universities that made false claims about graduates' career paths. These individuals have pressed the Department of Education to void their debts, under a statutory provision that permits such action if former students show that schools lied in recruitment materials. Others will argue that even if business fraud has increased as a result of deregulatory policies, the socioeconomic benefits of less encumbered markets, greater maneuverability for entrepreneurs, and suitable wariness among investors and consumers outweigh any collateral increase in fraud. Where possible, those who rankle at overreaching regulatory institutions will do what they can to clip their wings. This perspective has underpinned the movement by major corporations to create contractual defaults that compel consumers to take any grievances to binding arbitration outside the ambit of the state. In a pivotal 2011 case, AT&T Mobility v. Concepcion, a sharply divided U.S. Supreme Court gave this corporate strategy a significant boost, ruling 5-4 that state legislatures lacked the authority to prohibit such clauses in consumer contracts. More recently, however, the CFPB has begun consideration of a new regulation that would ban compulsory arbitration as a feature of consumer financial products. In this and other policy debates about anti-fraud regulation, we can expect participants to engage in appeals to history. One struggles now to find anyone who would dispute the claim that during the past 30 years, the financial industry, along with the professional gatekeepers charged with keeping it honest, became far more hospitable to versions of Barnum-esque humbuggery and Peter Funkism. But how should we account for this dramatic reputational decline? One recent explanation places much of the blame on the regulatory shift that the New Deal ushered in toward the principle of caveat venditor, which on this view reduced the incentives for corporations to take the standing of counterparties into account, because regulators could be trusted to discipline wayward firms. By the same token, professional gatekeepers such as law firms, external auditors, and ratings agencies no longer needed to safeguard their own reputations because regulatory mandates compel corporate clients to retain their services. According to this interpretation, the way to restore reputational premiums would be to undertake more deregulation of the securities market and to direct the remaining regulatory energies toward structuring incentives that reward longer-term performance instead of short-term returns. This argument downplays the rise of limited liability partnerships within accounting, which removed the interests of accounting partners in monitoring activities elsewhere in the firm. It elides the semi-corporatization of law firms during the late 20th century, as well as the shift of some investment banks from partnerships to limited liability corporations, moves that also shortened managerial time horizons. More significantly, it skirts the profound impact that deregulatory fervor had on social norms within the business community, helping to drive the relentless focus on short-term financial results that contributed to the 2008 financial crisis, and regulatory agencies, recalibrating the mission, organizational culture, and employment filters at institutions such as the SEC. Most importantly, the presumption that a fuller deregulation would prompt a greater reliance on reputational checks ignores the lessons of the past 2 centuries of American encounters with business fraud. Such checks did not ward off rampant manipulations and deceptions in the New York City auction markets of the 1840s, on the San Francisco stock market of the 1870s, or on the Wall Street of the 1920s. In the mid-1950s, the economist John Kenneth Galbraith surveyed the origins of the 1929 stock market collapse in his now classic history, The Great Crash. Galbraith framed much of his analysis around capsule summaries of how American enterprise in the 20s had opened its hospitable arms to an exceptional number of promoters, grafters, swindlers, imposters, and frauds. This and the long history of such activities was a kind of flood tide of corporate larceny. Such endemic violations of trust, we should remember, occurred in an era without any regulatory SEC mandates to interfere with the imperatives of investments in reputational capital. Toward the end of the volume, Galbraith mused about the inevitable progression of generational amnesia about the Great Crash and the Great Depression that it triggered. In the midst of the 1930s, he noted, the clarion call was never again. But with the passage of the years, one could anticipate that perceptions of the need for regulatory constraints would fade, as American aspirations were drawn to some newly discovered virtuosity of the free enterprise system. Galbraith offers a formidable caution about reliance on historical memory as a guide to regulatory policy-making, and yet the complex narrative of American business fraud, filled with recurring motifs and tensions, but also profound evolutions in regulatory strategy, has much to offer the myriad regulatory protagonists who deal with the problem of economic deception on a regular basis. It has become a cast of thousands: the Deputy Attorney General in charge of consumer protection, SEC lawyer, and CFPB investigator, the BBB representative, AARP community volunteer, local consumer activist, and consumer affairs journalist, the certified public accountant, accredited forensic fraud specialist, and corporate general counsel, the trade association official for mortgage brokers, automobile dealers, and hundreds of additional sectors. The history of American business fraud offers such regulatory actors a rich set of analytical perspectives. These include an appreciation for enduring psychological vulnerabilities and evolving social norms, some sense of institutional possibilities and pitfalls, the importance of understanding prevailing regulatory ecologies before embarking on policy experiments or attempting to forge new policy coalitions, cognizance of the fine legal lines that distinguish swindling from mistaken enthusiasm, and the frequent role of social status in shaping prosecutorial outcomes, a grasp of the trade-offs between facilitating innovation and curbing deceit, mindfulness of the capacity of anti-fraud regulation to generate unforeseen consequences or become stuck in bureaucratic quagmires, as well as its potential to reshape conceptions of self-interest and restructure business routines in constructive directions. Awareness of how regulatory infrastructures can become outmoded or taken for granted in the face of socioeconomic, technological, and intellectual change, and always assistance in asking the most useful question or framing the most sensible menu of policy choices. One can also identify enduring features of effective anti-fraud regulation. As important as reputational dynamics can be in constraining deceit, they will not, by themselves, forestall the sort of systematic frauds that can undermine public confidence in economic institutions. The regulation of business fraud has to have some punitive bite, both to stifle the most unscrupulous firms and to convince all market participants that the state is serious about fighting economic deceit. But regulators should direct resources toward well-designed public education that minimizes informational imbalances, the design of transactional defaults that empower investors and consumers, and the cultivation of market norms that stigmatize those willing to trade on reputation in the face of competitive pressure, or to construct enterprises on platforms of misrepresentation or conflict of interest. As they craft such strategies, policymakers should build networks that cut across levels of government, and now international boundaries, and leverage the creativity, local knowledge, and legitimacy of non-governmental actors, including corporations, the press, professional gatekeepers, and private anti-fraud NGOs. No capitalist society will ever rid itself of clever, beguiling, charismatic flim-flammers, nor established firms that, in the face of new challenges, turn to deceptive marketing or dishonest accounting. But the history of American anti-fraud regulation shows that inventive governance can stay abreast of all the new twists on old games, shut down the worst frauds, fortify consumers and investors against imposition, and sustain at reasonable cost the social trust necessary for modern capitalism. This has been a Highbridge production, read by Tom Perkins. Copyright 2017 by Princeton University Press. Published by arrangement with Princeton University Press. Recording copyright 2017 by Highbridge, a division of Recorded Books.